Hey folks, happy Friday. Happy Friday to all of you. It is Friday, November 1st, 2024. It is the first day of November, which means we are entering the 11th month of the year that I still can't believe is, well, I still don't think it started yet. How you guys doing? Where are you tuning in from? What do you have in front of you? Drinking a beverage, having a cocktail, having a snack, eating Halloween candy that was either leftover, not given to trick-or-treaters, or maybe stolen from a child? I haven't stolen any Halloween candy yet. I haven't taken a stepdaddy tax. I probably will. I just haven't decided yet. So, how was everyone's Halloween? If you did celebrate, hopefully all is well. Oh, thanks, guys. Haircut. Yes, got a couple of them cut. I have the law firm's annual all hands meeting, which requires that well, actually, it's one of these really silly requirements. We have to take photos, like the whole headshot stuff. And I preferred not to look like I had a big mop on top of my head. I figured I might as well try and look somewhat decent. It's interesting. It's kind of like school day when like, they get photos taken at school. It's kind of odd. It's very uncomfortable. They have to tell you, it's not yet. It's on a Sunday. So 3 different outfits. I don't like this. I don't like this. You're gonna have to prod me with a few cocktails before you put me in front of a camera. I know that's weird, being as though I am talking to all of you right now in front of a live stream or on a live stream in front of a camera. It's just very different. I don't know why it's very different. No, there's no logic to it, but there's something very different between a photographer taking a photo of you and telling you, yeah, stand there, look something, and standing in front of a live stream or a camera where I'm talking to you guys now. So I'll get over it. It'll be fun. We'll figure it out. So, like I said, did you celebrate Halloween? What'd you guys do for Halloween? Just some fun. Bedford, Virginia, the Meg. Great to see you. Great to see all of you. Look at this. Hez celebrating 2 years as a member. Thank you. It's 2 whole years. Happy Friday. Oh, happy Friday indeed. JJ Wright, Mountain Dew with strawberry puree to settle in and grade. That sounds fun. Coke float. Apple cider. Parent tax candy in Florida. Solid move. Really appreciate it. Debbie's got a gin and diet tonic here in Florida. J. Michael RN coming in very, very generously with 50 gifted memberships. Thank you, J. Michael RN. Hopes everything's well with you. Halloween sangria for Melissa. Proof of life for Leo. The proof of life is the fact that he has caused so much chaos that he is in his crate right now. He's in his crate right now because there's Halloween candy that he can get into, and we got to make sure that he's not doing that. But he is, in fact, alive. I will find a photo of this dog to show you guys. Lots of leftover candy. Runkle stole a contest from a small, cute child. Yeah. We're about to. Bailey's and Coffee in Columbia, South Carolina. Sounds wonderful. Laura, we gave out candy for the first time since the pandemic. It was so much damn fun. Our neighborhood was scatterings of children everywhere, all of whom were in costumes. Mini Mischief 2 was dressed as Captain America. We saw probably 3 different Captain Americas. So that became a bit of a challenge when they're all running up to the same door and you see different Captain Americas. You're going, which one is mine? But it was a lot of fun. Tons and tons of candy. Christy Austin definitely sold some Halloween candy for my kids. But only the stuff they don't like, right? I have questions drinking half a glass of Malbec now that her annual guardianship is done. Phenomenal. Oh, this is cute. Jackie Durbin. It was my son's first Halloween, and he loved grabbing his own candy for her dada to enjoy later. See? That's wonderful. Mini Mischief 1 played loving escort to a very lovely, I believe, 2 or 3-year-old. That's one of the neighbors. And Dada, look at Kendi. She kept on saying. She held her own bucket. Dada, look at Kendi. It was really cute because she said, my dad is dressed up as yoga. instead of Yoda. So that was a cute moment. Kids are really adorable when they're dressing up for Halloween. It's a lot of fun. So that's what we did. Uh, Mischief Manager was one of the cool parents and purchased all full size candy bars, and they actually lasted the night. So I was pretty impressed with that. The only disappointing thing is that, of course, all the good candy bars are taken first. So the only thing we're left with is I don't remember where we're left with. Honey, what are we left with? Reese's peanut butter cups, which I objectively terrible candy. I cannot. Reese's peanut butter cups. For those of you who think that's your favorite candy, you're objectively wrong. It is not. They are not. They're not good. It is fake peanut butter. It tastes nothing like peanut butter. And yeah. Kayla, happy 40th birthday, aka level up tomorrow. So tomorrow you will be 40 years old. 40 is great. Don't be afraid of it. It's phenomenal. 40 is one of the best years so far that I can ever attest to. Cowpoke kid dressed up as Little Red Riding Hood. That's phenomenal. How you doing, Rob? Rob's doing great. Got some energy. We're gonna make it through this evening. We've got one topic to cover. So we're gonna try and keep this one not the latest evening in the world because we've got stuff to do tomorrow that's really important, including making an appearance with Ian at some point in the morning. So it's getting caught up. Coke Zero in Michigan. I'm never gonna get caught up. I'm so far behind. Drinking hot tea. Pepsi in Oklahoma. Oh, Christy, 10-hour healthcare shift. Ouch. Coffee for Celine, root beer in Georgia, water in Georgia. Did absolutely nothing for Halloween except for work and watch some Netflix. See, there's nothing wrong with that. I have no problem with that. That sounds like a phenomenal day because at the end of the evening, I am exhausted walking around a neighborhood at a very slow pace. It sounds ridiculous, but I don't know why that's more tiring than if I was actually doing more hard labor. So I'm not sure why, but it's exhausting. What's our goal tonight before Runkle takes over and does Extra Life? I have been wondering what we should do. Let's see where he is right now. Extra Life. Do y'all remember what his short link was? I don't. And of course, I texted him and asked him, do you have your short link ready yet? Of course, he doesn't respond when I need him to, because why would he? That makes total sense. Oh, look at that. Copy link. Let's see. What does this do? What does this do? What does this link do? It says link not found. Ah, there it is. Thank you, mods. Mods, as always, saving the day. So let's go ahead and put that in the chat and pin it. Chat's moving too fast to pin it. That's scary. We're going to have to do it again. There we go. And pin message. So let's see where he is. Ian Runkle, Runkle of the Bailey. Let's check out how you doing, bud. And what's up? We remember how to do this. Yes, we do. All right, so Ian has raised $7,525. $7,525. So, of course, I will be donating at least at some point throughout this stream to that cause. But I'm going to encourage all of you that are available and able to do so. Please do not spend money you do not have or cannot afford to spend. Please don't do that. But if you feel inclined to donate to this Extra Life charity, this is Ian's 5th year doing it. Last year, I believe he raised $115,000. 124. My memory's terrible right now. But so what shall we set as a goal for ourselves? What do we think? Shall we set a goal for the conclusion of FNF? I think the goal should be. We want to be aspirational here. See, some people were saying 15,000, 25,000. See, 25,000 might be that's a lot. That's a lot for people to donate. I think the goal, you know what? I don't mind setting a $15,000 goal. I don't mind. I think we might be able to do it. And heck, if we fall short of the goal, then you know what? We'll be ahead of that already. So what I'm going to do is see if I can't. Let's see. I'm wondering. If I'm going to do this. Mm-hmm. Bear with me, folks. I promise it's going to make sense. Okay. So here is what I'm doing. Oh my. I'm just getting news that there are 64 items to be auctioned off tomorrow or throughout the course of the evening. 64 items? Wow. 64 items? That is wild. That is absolutely bananas. Look at that. Numbers already going up. I'm just sitting here talking, the numbers going up. What I'm trying to do is I actually created a QR code, which will allow people to look at the screen, hold their phone up to the screen, and it will take you right to that link. Should I have done this before I started streaming? Absolutely should have done that. Absolutely 100% should have done it. I didn't. So instead, I'm improvising. We're going to say that I'm improvising because I should have done it. I didn't do it. Thought I had time, didn't have time. And I was already late enough as it was. So a little bit of grace, hopefully, will go a little bit towards getting this done. Well, that if I make it that size, it's going to block up everything. Here, you guys want to see what I'm doing? Let's do this. Here, see what I'm doing. So we're going to go here. We're going to make that. We're going to make it a little bit smaller. We're going to put it in the bottom right hand corner. Put it over here. And go back here. Write this tab instead. Because I don't want to see you guys where I'm saving this on my computer. Because, you know, got to maintain a little modicum of privacy here. And we're going to put it up so people can see. Oh, yeah, 7691 already. Runkle QR. Let's see, overlay, add overlay. Desktop, Runkle QR. Let's see. Will you work? Are you going to work? Aha. There we go. So let me know if that link works. Please let me know if that link works. But it should take you directly to where you can donate. So hopefully. So what I'm going to do to further the interest of this cause is disable super chats, where you guys, if you want to donate anything this evening, it has one avenue where you can donate. Just one avenue. So got to go into the channel. And go there. Turning them off. One. That's off. That's off. And that's off. So right now, super chats should be disabled. There were some that you guys snuck in beforehand, but super chats are disabled. The only way you can donate this evening to anything is by that QR code. That's it. That is the only methodology that we're going to use to do any contributions to FNF this evening. So that is where we are. It's all good. Are you donating pens? Let me see. Got my pen book. I don't know what's in the pen book right now. I suppose I have some in here I can part with. Not all my favorites, though. I mean, I don't really have a ton. I've got some. I don't know. I'll talk to Ian about it. See if because he has 64 items. He has 64 items. I have some pens that I could, but I don't want to overwhelm him. I know he's already overwhelmed. We'll just have to see. But again, I'm not going to put additional stress on him because he's streaming for 24 hours. Oh, people are saying put it on the other corner because it's covered. Oh, I get it. Oh my gosh. Yeah, for people on the TV. Hang on. We shall do that as well. Ian's 24-hour live stream. Ian's 24-hour live stream begins at 2 a.m. my time, midnight his time, which is why he's not here. Hopefully, he is sleeping. That is the hope that I have, that he is sleeping and not foolishly not sleeping. Because, it's hard to stay awake for 24 hours while live streaming. It's hard to live stream at all. It's hard to remember what you're doing. It's hard to remember to keep communicating because dead air is really pretty terrible. So sometimes you just got to communicate with yourself, especially when you're looking at the screen that doesn't have anything on it except for a QR code that you're moving around an empty screen while you're trying to generate another thing. So we're going to put it at the top right. Hopefully that doesn't block anything. Let's go ahead and download that. And we'll fix it because people on TVs, because I do know this, when you're on a TV, when you're watching YouTube on a TV and you're watching chat actually pops up on the right-hand side of the screen. So you can't see anything on the right-hand side if you're watching chat. Some people like watching chat. So we're going to fix that right now. We're going to hide one and show the other. Look at that QR code in the top left. Remembered how to do the stuff. Remembered how to do all the things. Okay. We will check back on this momentarily. See, I think 15,000 was a pretty good goal. I think we're going to surpass it because we'll check back on it momentarily. We'll check back on it throughout the evening and see how we're doing. Because like I said, we really only have we really only have one topic to cover this evening. Mikey B, I'm really confused about this. I'm so happy cloud chasers are over. I don't know what that is. I get confused by that. Have you got your workshop set up yet after your move? Workshop is partially assembled. It is in a remarkable state of disrepair, but it is in somewhat of a working order where I can actually do a little bit of work. Right now, it's just doing actual, absolute necessary work and trying to train children that it is no longer a garage. Like you cannot put your things in this space. It is not a garage that stores scooters, for example. It is a shop that stores tools. I am told I'm going to lose this battle. It does not mean that I'm not going to keep fighting this battle. I'm totally going to lose this battle, but we're going to keep fighting the good fight. The shop is going to be a dedicated shop. If I have to disconnect the garage door opener, I'll disconnect the garage door opener. If I have to install a new set of lock and key on the door accessing the garage, I will install a new set of, a new lock and key. If that lock happens to be a biometric lock that only opens with the scan of my thumbprint, I will install a biometric lock that only opens with the scan of my thumbprint. We will see how clever these children are. Are they going to be Mission Impossible, where they're walking around the house looking for my thumbprint to try and lift with a piece of tape and graphite and try to get into this shop so they can store their things? I don't know. So we're just going to have to, up. She's always watching. She's always watching. Why didn't you warn me, guys? Why didn't anyone tell me? Y'all could have warned me well in advance of me going down that rant. Speaking of rant, I do have a poll for all of you. Let's do this. We're gonna have it. We're gonna have a mature discussion, an adult discussion. The adult discussion for this evening, prior to getting into any of the material that we're going to discuss, which has one topic, and that's the Young Thug trial. The adult discussion and debate we're going to have is what is the appropriate temperature for the inside of a dwelling in which humans reside. And we're going to do a scale. So, what is the appropriate temperature for a household? The inside of a household. And I'm going to give you some options. And I have been told I might regret the outcome of this poll. I don't know. We're going to find out, though. We're going to give people an option. What is the ideal temperature inside a home? You know what? We're gonna we have to do conversion here because I know for all of my Canadian friends. So Fahrenheit to Celsius. Do I know the math on top of my head? Not a clue. Uh, $69 to $71. How many options can I do for these bowls? Only 4. Mm. I only have 4 options. This is going to be tough. We're going to make it work. See, the thing is, this is what pisses me off about Celsius. So there's a big difference between. Maybe I'll do this when I post the poll. Give me 1 second. This is going to bother me. I'm about to go on a rant about Celsius as a measurement scale because it doesn't make sense. It doesn't make sense. There's not enough variance. Because for example, 70 degrees is 21.1 degrees Celsius, right? But 71 degrees is 21.66. Now here's the thing. Tell me that there's not a difference between the feeling of 70 degrees and 71 degrees, because you're wrong if you say that there's not. There is definitely a difference in the feeling of 70 and 71 degrees. People don't talk about it that often, but it's a real thing. And why is it taking me so long to post this poll? Well, I'll tell you why. Because I'm doing math. Using Google to do it because I don't trust myself to do it myself. And it's giving me a spelling error on Celsius because I didn't capitalize the damn C. So we're just going to do it that way. That's what we're going to do. So the options you have are sub 68 degrees, 20 degrees Celsius, 68 degrees to 70 degrees, which is 20 to 21.1 degrees Celsius. You have the option of 71 to 74 degrees Fahrenheit, which is 21.67 degrees Celsius to 23.33 degrees Celsius. And you have the option of above 74 degrees. Now, let's see where y'all come down on the appropriate temperature for the inside of a dwelling. And I'll tell you, it is a constant argument. Constant. Oh no, Mikey, we're not bored. Sorry, we're not bored. This is just I do these polls every single live stream where we have an adult discussion about certain things that are occurring within the household usually, and it's usually to answer debate that Mischief Manager and I are having. And I think we're split about 50-50 on who's been right in the answers to some of these. For example, one of them was whether a flat sheet is appropriate or not. Flat sheet being the sheet between your fitted sheet and the comforter. But we have these debates, and in order to resolve the debate within the household, we put the matter to the chat. Does it resolve the debate? Nope, because she and I are both remarkably stubborn. So we just either agree with the chat or disagree with the chat emphatically. So we have spirited discussions is what we shall call them. So let's get through the lovely gifted memberships, and then we'll get into the subject matter this evening, which is again the Young Thug outcome for some of the defendants. There are still defendants that are still on trial. Canonically, thank you for gifting 20 memberships. Much appreciated. That's very kind of you, as always. Susan Crespi, thank you for gifting a membership. Very nice of you. Fiona W., thank you for gifting 10 memberships. Very kind of you. Koch, the Frankfurter, gifted 5 memberships. Very nice of you. Thank you very much. Baby Steps 22 gifted 5 memberships. Much appreciated. Lynn, hi, Rob. Just wondering if you got a package in the last week or so for Mini Mischiefs 1 and 2. I'll double check. I haven't been in the last week, so I will have to double check. But thank you for getting me to keep a lookout for that. Thank you. Much appreciated. Babs, Austin. Hey, Rob. Love being a part of this community. Well, we love having you here, Babs. It's a lot of fun. Twubble. I almost said Twubble. Thank you for gifting. Oh, thank you for the gifted memberships that you said to somebody else. So your membership chat is much appreciated. Sandy gifted 50 memberships. Thank you very much, Sandy. That's extremely kind of you. You don't have to do that. You're a mod. I don't know why you continue to do it, but you still do, and you're growing this community. Otterly Bell just got to bed, homesick with a fever and sore throat, so hope y'all have a better weekend. Otterly Bell, I'm very sorry that you're not feeling so well. Hopefully you recover quickly, and you're feeling right as rain come the beginning of the week. Emily Aaron's Team Reese's Peanut Butter Cups forever. Disappointed. I'm disappointed, Emily. Remarkably. But it's okay. Bookworm, are you following Rasheed Rice case hit and run in Texas? I'm not, but I can. You can take a look at it. Is it gone to trial yet? Is it still pre-trial phase? Let's see real quick. Rasheed Rice. What is it about? She rice. Lamborghini driven by Rasheed Rice before he was involved in a hit and run. Interesting. I haven't followed it, but I'll take a look at it, see if it's interesting or not. Adrian Angevine, thank you very much. I am awaiting my Panera broccoli cheddar soup while finishing domestic relations homework, a DV safety plan. How many hidden gem ideas I can include? Ooh. Those are so fact specific. Adrian, I don't know what you want me to do. Every one of those safety plans is remarkably fact specific to the actual incident that occurred and the two parties on the ground. Great ideas would be to take a look at the facts and really try to specifically tailor what you believe to be in the best interest of that family. What's going to protect the family? What can they engage in? Whether it's therapeutic approach, whether it's conditions that keep them apart from each other, whether it's other things, classes. I don't know. My best of luck to you. They're not fun to create. They're even harder to enforce. I mean, it's just not fun. Bez from Quebec, back after a month without stream. Missed you all. Glad to see you back, Bez. Much appreciated. Thank you for being here. Daffy, been away too long. Hello, Rob in the chat. Hello, Daffy. Nice to see you back. Yellow Pill NP. My door lock uses a fingerprint and or the code, number code. The thing is, well, I could do a number code. I just feel like there would be cheaters trying to find it. But I could also get one of the ones that shows me how many times a wrong code is input. See, and what time of day it's input. That'd be fun. B Hartling, you just have to build him a scooter shed. I know that's on a list of things to do. And sadly enough, it might actually be one of those situations where I am employing someone to build a scooter shed because there's this thing called time that I just don't have enough of at all. But I do need to get to that. Rosalie, like the haircut looks good. Thank you very much, Rosalie. That's very kind of you. I will say on the haircut front, it is getting remarkably, I don't know about stressful, but every time that you go, I mean, there's a little more salt in the hair than there is pepper, and it's starting to drive me nuts. I think every time I've gone to the barber this year, the hair gets lopped off and I see a whole lot more gray that I didn't see before. And there's some in the beard too now that's just permanently there. Is what it is. Makes me look mature even if I don't act that way. Mispronounced name, way colder than the pole. Sweaters are awesome. Yes. I love the mentality. Tisha Seeks Orange Courthouse. I stopped using a top sheet. It was life-changing. Don't encourage her, Tisha. Katrina Turner. I weigh less than 90 pounds, so my heat is set at 75. That's fair. I understand that. I get it. Gretchen Call, 100 grand candy bars are the best for bad jokes as well as good candy. Yep. For those of you wondering why it's good for bad jokes, because 100 grand was used in, what was it, Caddyshack, to replicate a piece of poop in a pool. So it has a certain shape to it. KL Burke, almost every country uses Celsius, but it doesn't give me the appropriate. I can't adjust my internal thermostat to a Celsius scale. I'm stubborn like that. Now, here's the thing, centimeters and millimeters, I can get there. No problem. I actually like the use of millimeters in measurement for woodworking purposes. The CNC and the 3D printer kind of required me to adjust my metric there. But Celsius, I don't know. Follow the logic. Here's the logic. I'm going to make the point. The logic is, if I'm using millimeters as a metric of measurement, right? It is such a smaller increment to measure than inches. I don't have to go into a division of a millimeter until, well, actually, we don't go to, it's either 0.1 millimeter or 0.2 millimeter. It's decimal. It's very, very simple. It's a lot easier than going, 10 and a half inches or 7.5 inches or, 15 and 3/4 or 15 and 3/8. It just makes sense because there's smaller increments to use as a base, right? Now flip that when you come to Fahrenheit versus Celsius. Celsius, I mean, your scale is, it's what, 0 to 100 generally, and that little comfortable temperature, the metric of Fahrenheit, you've got so many more digits in there, right? 68, 69, 70, 71, 72, 73, 74. If all I had was an option of setting my thermostat to like 21 degrees Celsius, but I wanted it to be just a little bit or a scotch cooler than that, can I do that? Can I set my thermostat to a decimal of a Celsius, like 21.5 degrees Celsius? I don't know. But if I walk outside and I can very easily say, you know what, it feels 72 outside. That just makes sense to me. I would just have to adjust my own brain. Fat Yoga, I'd love to hear you laugh. Thank you very much, Fat Yoga. I hate it, but I love that you love it. Conacy, cheer up. My dad went completely white in his late 20s, early 30s. You mean like Ian? Spent my childhood thinking people could be born with gray hair. Oh, yeah, like Ian. Ian's an elf. He's a gray haired elf. Yep. Sensationally social with Beth. Grew up with Arctic temperature. Has to be 68 to 69 all year. See, that's my cup of tea. It's right there. We can. All right, Darkosaur, you can't tell me you've never had a need. There's no way you've never had a need to go somewhere, but oh my gosh, that I read your chat and then I saw your avatar, which is awesome, but also scared the hell out of me at first. You can't tell me you've never had a need to go somewhere in between the 2 degrees. So, but I will say what's cool is when you're the handy person in the household and you get to set up all the devices, and one of the devices happens to be a thermostat that you have control over on your phone, you know, you can kind of set it the way you want it to be. So when it's a little too hot for your liking, you can just adjust it from your phone, and you're the one that set it up. So you have the password to it because, you control those things. It's one of the benefits of being handy. Oh yeah. All right. No, it said keep it at a range because again, we have to keep a compromise in the household. I'll tell you what the range is. No, I'll do that after you finish voting. For example, it got way too hot for my liking in here, and I'm sitting down in the basement. So if I'm sitting here feeling warm, I know it's freaking hot upstairs. Everyone's saying, I bet she also has the password. Yeah, it's called the actual thermostat that's above me that I can't physically control. But then there's us, having that little battle over what's faster, the Wi-Fi or the physical device. Anyway, okay, let's check back in on how we're doing. How did the poll disappear? The poll didn't disappear. Poll's still there. From what I can see, it's still there. 1,000 votes are in. Right now, that little comfort zone of 68 to 70 degrees seems to be taken away with the wind. So, poll is still there. Nanar, that's awesome. I have a different thermostat in every room. Yeah. This is a pretty solid idea, Laura. Present the weekly marital polls at the weekly marital polls at the wedding. It's pretty solid. That's a pretty solid one. To start pitting the results. Look at this, Professor Logic. Haven't seen you in a while, my friend. I have plenty of silver now. I'd rather have the silver and still have hair. Lucky in that respect. Again, truer words have never been stated. Very appropriate. I'm very fortunate to have the hair. I love the hair. It's awesome. So I'll take the salt. It shall be what it is. So let's check in on the status of the extra life. See how well we've been doing so far. $9,468. We started at $7,250. So we're doing well. We're doing really well. I think 15,000 is the appropriate goal. And for those of you who are just tuning in, we have turned off super chats for the evening. We are not doing any contribution to the channel. I didn't catch it in time, so there were some contributors. We read them out beforehand. But we are not doing anything to the channel tonight. We are 100% invested in the Stallard Children's Hospital and making sure that Ian's charity stream goes successfully. So you guys have already gone up $2,000. So you've been very, very generous already. I am being told there are 64 items up for auction. 64. So I have a lot to do tomorrow. I will be on stream for at least 2 hours. I don't know that that's going to be the auction time, but I know that Ian's been working very hard to get everything set up. So we shall see. I know there's a lot of really cool items though. Okay. So let's come back to the poll a little bit later and let's get into the first and only topic of the evening. In order to do that, we have to swoop. Because it's one topic, we're going to double swoop. Laura, I believe 10 a.m. to 12 p.m. tomorrow, my time, for a little D&D. I think that's what we're doing. I'll have to confirm with Ian. So what do we have today? Well, today we are playing a little bit of catch up. Not catch up like the condiment, catch up as in trying to get caught up on what transpired in the YSL trial. YSL trial is taking place in Fulton County, Georgia. YSL stands for Young Slime Life, which is a alleged gang in Georgia. At the head of said gang allegedly is Jeffrey Williams, Young Thug. So how did we get here? We got here because the prosecution has been jumping in misstep after misstep after misstep after miscalculation after misstep after. Have I stated too many missteps? I don't think so. Not based on where these prosecutors have gone. Not based on how horribly this trial has gone. So we have this trial is in day 154. And yes, you heard that right. Day 154. And I believe that count, I don't know if that count includes jury selection. So the trial was commenced by Fulton County DA, elected DA Fonnie Willis. I think there were 20 some odd defendants in the trial. Almost all of these defendants are incarcerated during the course of this trial. And all of them essentially just with their life in suspense while the trial is ongoing for this entire time. It's been a complete cluster. It's been horrible. And from what I have viewed, it's been just, this trial should not have taken anywhere near this long. Nowhere near this long. I cannot count the number of mistrials there have been because I don't know that that math is possible of mathing. It seems like there's been a mistrial every other day. Am I stalling because I'm logging in to find my materials? I am doing that. Absolutely. if you remember, we covered a while back, we covered Young Thug's lawyer Brian Steele being held in contempt by then presiding Judge Glanville. The basis for the contempt, he got very upset that there was an ex parte meeting that took place. Well, Judge Glanville got upset that Brian Steele found out about an ex parte meeting that Judge Glanville thought he shouldn't have known about. Everything about that transaction was wrong. Brian Steele set up and said, nope, I'm asking for a mistrial. This transpired outside of my knowledge. Glanville said, well, how did you know about this? And Brian Steele said, I'm not telling you. Glanville said, I'm going to hold you in contempt. And Brian Steele said, hold my beer. I don't think he actually said, hold my beer, but he might as well have. Because it was probably one of the most badass moves I've seen a trial attorney do ever. And in open court, Brian Steele took off his jacket, did the white shirt walk to the front, and before being escorted out by bailiffs, went to the podium, asked to put something on the record, still asking for, respectfully to put matters on the record, and put on the record that Glanville was denying his client the right to counsel, depriving him by putting him in contempt, holding him in contempt. Glanville completely caught off guard. Where was it? There we go. Glanville was completely caught off guard. The prosecutor realized the case is going to go sideways if they allowed him to remain, held it behind while the case was proceeding, because you can't have a trial keep going when you've got one of the attorneys for the defendant being held in contempt in the holding cell behind the court. So he said, you can serve your contempt on the weekends. And Brian Steele, as if he couldn't get more badass, said, well, I'd like to be housed with my client so that we can prep during the weekends. I mean, honestly, just about as cool as a human being can get from the lawyer standpoint. And in the course of that entire back and forth, Ashley Merchant comes downstairs. We learn that there's a defense attorney task force that is in place for just this particular occasion. That occasion being defense counsel being held in contempt and put in jail. Ashley Merchant begins to educate Judge Glanville on, what exactly he can do or cannot do in contempt proceedings, including whether he can or cannot preside over a contempt proceeding when it is in his immediate presence, and he's the one that saw it. I'll give you 3 guesses as to who was correct in that back and forth. I don't know that you need all 3, but we can actually do this as a little bit of catch up, because let's see. I'll tell you how that ended up going, because the Georgia Supreme Court actually came back with a ruling on whether Judge Glanville could or could not preside over the contempt proceeding. And I imagine Glanville was surprised. He shouldn't have been, but I imagine he was. Because somewhere, I don't understand half the decisions that man made. I really don't. I thought a lot of it was unfair. We read the transcripts to this ex parte proceeding, if you'll recall. And the transcript was full of so much wrong and so much horrible. I don't know if I can repeat it. Okay, well, that needs to be bigger. That also needs to be bigger. I mean, come on. So this was October 22nd, so about a week and a half ago. And this is out of the Supreme Court of Georgia. Steele versus the state. A trial court found attorney Brian Steele in contempt of court for refusing to tell the court how he learned about the court's ex parte hearing with a witness and prosecutors in a case in which Steele is representing one of the defendants. Steele appeals from that contempt order, arguing that the evidence did not support a contempt finding because he did not interfere with the court's administration of justice. His information was protected by attorney-client privilege, and due process required the judge to recuse from the contempt proceeding. Now, we're going to play a little game. I like this. This is a fun game. Let's play this game. We're going to highlight the three choices. Well, I mean, it's kind of, we're going to give, the game is kind of given away. So these are the things that he is arguing. The defense did not support, or he did not interfere. Wait, hang on. Undo. He did not interfere with the court's administration of justice. That is option one. Okay. There we go. Option one. Option two. His information was protected by attorney-client privilege. All right. That's option two. Option three. Due process required the judge to recuse himself from the contempt proceeding. I want you to categorize this option and think from the perspective of a court of appeals. Which one of these three is the easiest choice to choose? Which one requires the court to go into a thorough analysis that, might be a little bit more difficult for the court to reach a conclusion? Heck, they might have to put their foot in the ground. Is it A, he did not interfere with the court's administration of justice? Basically, on the merits, I didn't commit contempt. B, the information that he had was protected by attorney-client privilege. Or C, that due process required the judge to recuse himself from the contempt proceeding. Which one's the easy one? Which one's the hard one? And which one do you think that that the Court of Appeals wanted to hang their hat on? And when I say easy, I mean you're an appellate court. We've talked about this. Appellate courts love to take the easy way out. Do they really want to jump in and make the most complicated decision? Do they want to jump in and put their reputations on the line, for an appeal that goes all the way to the Supreme Court and gets shot back down? No, they don't want to do that. So if they can decide the case on a single issue that takes away two of the others, why would they ever make the hard decision? Even if it meant clarifying or actually vindicating conduct that occurred. Because I can tell you, if I analyze questions A and B, I would probably reach the decision, and some people would be very mad at me. I don't think any of you would be mad at me. I think some people would be. He didn't interfere with the administration of justice. I would say that's absolutely correct. He didn't. It was protected by privilege. I'd probably also agree with that. Due process required the judge to recuse from contempt proceeding. At the very least, I would do that. So what does the Court of Appeals do? What does the Supreme Court of Georgia do? Which one do they decide they're going to resolve that resolves the others? Because the court delayed punishment, the alleged disobedience was directed towards the court, and the court was involved in the controversy that formed the basis of contempt. Due process required the judge to recuse himself from the contempt proceeding. Ding, ding, ding. For those of you who had C, that is the correct answer. Why the Court of Appeals didn't want, or the Supreme Court didn't want to go into not interfering with the administration of justice or information protected by attorney-client privilege? Well, because that would put egg immediately and rightly on the face of Judge Glanville. Now, there's a little bit of egg on Judge Glanville's face, but not as much as there would have been if the Court of Appeals came outright, or the Supreme Court came outright and said, Steele was right. You were wrong. You shouldn't have done it. All the above. The record shows the following. Steele represents the defendant, Jeffrey Williams. We'll talk about him in a minute. In an ongoing criminal case. Not anymore, as the Jeffrey Williams, charging multiple defendants with, among other things, participation in criminal street gang and conspiracy to violate Georgia's RICO statute. In June 2024, Fulton County Superior Court Chief Judge Glanville was presiding over the trial. During the trial, Glanville found one of the state's witnesses in contempt for exercising his Fifth Amendment privilege against compelled self-incrimination, essentially refusing to testify, despite having been given immunity from the prosecution. Judge Glanville adjourned the trial on a Friday and stated he would resume the trial the following Monday and ask the witness, outside the jury's presence, whether the witness would testify. Interesting. That's a very interesting footnote. Although several defendants were charged with the murder, Williams was not. Okay. The following Monday morning, Glanville held an ex parte meeting with the witness's counsel, and state prosecutors and investigators to discuss whether the witness would testify for the state. The meeting, taken down by a court reporter and transcribed for the record. We're going to put a footnote on that because we don't know. There's been sworn testimony that the court reporter didn't take down everything. Took place in Judge Glanville's chambers and comprised most of the morning. the end of which the witness said he would testify. The witness gave limited testimony before lunch recess was taken. Following the recess, Steele informed Judge Glanville that Steele had learned about the ex parte meeting and moved for a mistrial. Glanville stated he was disturbed because this is ex parte and repeatedly asked Steele to reveal the source of his information, informing Steele that, quote, if you don't tell me how you got this information, then you and I are going to have some problems, end quote. Steele refused to reveal his source, and Glanville told Steele that it was, quote, disturbing that somehow you have surreptitiously gotten information in regard to the court's private ex parte conversation with a party, end quote. I might add, in Rob tone, an ex parte communication that should have never fucking taken place. A little early for profanity, but it's justified. Judge Glanville repeatedly told Steele that he was going to hold him in contempt if Steele did not tell him who disclosed the ex parte meeting. Steele claimed that the information was covered by attorney-client privilege, challenged by Glanville. Steele also said it was attorney work product. Judge Glanville then took a recess. Upon returning to the bench, Glanville told Steele that there was only one way he could have gotten the information, and it was not work product. Glanville asked Steele again to reveal the source, said he was going to hold Steele in contempt if he refused. Steele said he did not want to be held in contempt. Glanville responded, I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious. There are so many things wrong with that passage right there. So many things. Because notably absent from any of the discussion in the ex parte proceeding was anything that said this is under seal. This is not to be divulged. This is anything else. Nothing. None of the parties were enjoined from discussing the matter. Steele asserted that he could not comply with the court's order without violating Rule 1.6 of the Rules of Professional Conduct, which states that a lawyer shall maintain in confidence all information gained in the professional relationship with the client. See that part. Mr. Steele and I agree on what that part covers. Judge Glanville rejected the argument and said, I'm going to hold you in contempt, and you can think about it. Adding that at 5 o'clock today, we'll see where you stand on that point. Glanville told Steele that he was not asking for the sum and substance of what was said, only for how Steele learned about the meeting. Steele responded, I can't do that. Glanville then told Steele, I don't want to hold you in contempt, but this is that serious. You cannot eavesdrop and get information that was not meant for you to hear. Are y'all feeling really uncomfortable about that? This is a judge, ex parte. This is. Steele said he would do whatever you want me to do until 5 or thereafter, but maintained that the matter was serious enough to warrant a hearing and then moved for a mistrial. When Steele said he wanted to get the substance of the ex parte conversation first, Judge Glanville responded that Steele would be in custody until 5 because you need to tell me how you got the information. There was a brief back and forth about how Steele could possibly learn of the information, whether it was privileged, before Glanville said, I'm not going to have any further conversation with you about this. I want to know. The question still remains. I want to know how. Who gave you this information? Glanville then said he can go into custody at this point in time. Steele was not immediately taken into custody. He made additional arguments in support of a mistrial and repeated his argument that he should not have to disclose the source without breaching Rule 1.6. Glanville told Steele that he could not hide behind Rule 1.6. Wow, there you go. Supreme Court coming out and saying, Glanville, maybe you should have reconsidered this. Steele said he was not hiding behind anything and continued to ask why he was excluded from the ex parte hearing. Prosecutor then made several arguments as to why the ex parte meeting was not improper and why the information issue was not protected by Rule 1.6. Steele's co-counsel then addressed Judge Glanville, informing him that co-counsel was also in possession of the same information Steele received, and that the trial should not continue until the court resolved the ex parte issue. Steele's co-counsel renewed the motion for mistrial, which the other defendants joined. Glanville denied all those motions and said he was going to proceed with the trial. Steele's co-counsel said he would not participate in the trial without Steele and without the court addressing the ex parte issue. Judge Glanville quadrupled down. Sir, you all are getting yourselves cross purposes at this point in time. You made some things out of nothing. I think you are on a very precarious ground at this point in time. Well, Glanville's been standing on that for a while. Said he continued the trial and co-counsel would represent Williams. Co-counsel said that wanted to address the ex parte issue. And then this part. As he was being taken away, Steele asked to say one thing, clarifying that Glanville was denying Williams his right to counsel, and again moved for a mistrial. I just can't even imagine that this took place. I still can't. This was so stupid. Every part of it. That meeting should have never happened, ever. Judge Glanville informed Steele's attorney that he was about to enter an order of contempt, was offering Steele another chance to purge contempt, and that was the only thing I'm going to try and do at this point in time. Steele's counsel, Ashley Merchant, argued that due process required Glanville to refer the matter to another judge, and Steele was entitled to a hearing, and Glanville would be a witness at that hearing. Glanville rejected the argument, sentenced Steele to 20 days in jail and served on the weekends, and stated that Steele was not entitled to a supersedious bond. Well, turns out Glanville was wrong on several counts because he got the bond immediately. Written order reflected the sentence did not provide Steele with an opportunity to purge the contempt. The appeal ensued. Our precedent makes clear that individuals facing contempt are entitled to due process. Ooh, footnote. Anything good? Nope. Certiorari. Yeah, punishment. Okay. Distinction between civil and criminal. What process is due depends in part on whether the contumacious conduct occurred in the court's presence and whether a court announces punishment immediately. When the conduct occurs in the presence of the trial court has the power, when necessary, to maintain order in the courtroom, to declare the conduct to be contemptuous and announce a punishment summarily without further notice or hearing, so long as the contemptor has been given an opportunity to speak on his own behalf. Basically, judge witnesses you actually committing the contempt. Judge orders you to do something. You don't do it. Judge witnesses it, can punish you right there. These situations are usually limited to conduct which occurs in open court, because the open conduct in court threatens the court's immediate ability to conduct proceedings, such as when a witness refuses to testify or a party disrupts court. Pretty straightforward, right? Makes sense. We allow the summary proceedings, which I honestly think are a little bit overkill, but they're allowed because the trial court's substantial interest in rapidly coercing compliance and restoring order. You can't disrespect the court. Doing so actually, messes with the entire understanding of justice. So it can create a pretty big deal. The trial judge was required to recuse himself or hold separate hearings every time the proceeding was disrupted. Yeah, imagine that. Every time someone started yelling, if the judge was like, I got to recuse myself, we have to hear a separate matter, you can't, I can't hold you in contempt because you got to go to a different judge. Would never make sense. It's different when the conduct doesn't interfere with the proceedings and thus need not be punished immediately, such as, how did you learn about an ex parte proceeding or eavesdropping? Here, Glanville punished Steele summarily for his refusal in open court to comply with Judge Glanville's order. I don't think that was a rightful order, but as he held Steele in contempt, placed him in custody and had him removed from the courtroom. But that punishment is not the subject of this appeal. Steele was allowed to return, yada, yada. Was still in contempt, but he did not announce what specific punishment he would impose. Because the announcement of a specific punishment was delayed by the trial court, Steele was entitled to additional process. Basically, judge, if we're going to delay this, if you don't have to punish me immediately to maintain order in the courtroom, you actually have to give me some modicum of proper due process. In particular, he was entitled to have the matter heard by a different judge. Steele's repeated refusal to comply with Glanville's direct order was conduct directed towards the judge. Steele continued to challenge the propriety of the ex parte meeting, which alone should have required the freaking recusal, and asserted he could not legally comply with Glanville's order to disclose the source. The exchange between Steele and Glanville makes clear that Judge Glanville was involved in the controversy. No shit. For those reasons, a different judge should have presided over the contempt hearing, and a failure to do so requires reversal. So, Brian Steele wins. So he took a big win on this one. Glanville ultimately recused himself from the entire case and the entire case ends up being turned over to Judge Whitaker. And that is where we begin our story of how this case concluded for several of the defendants. Let's check in on the status of Ian's extra life stream and how we're doing. 9,855. For those of you tuning in just now, super chats, gifted memberships, all of the above are turned off just to try and further the interests of this Extra Life live stream charity, 24-hour charity for Ian Runkle, who begins his 24-hour live stream at 2 a.m. my time, 12 a.m. his time. So in just RCS Rose, Runkle is sleeping. As I'm explaining, because he begins his 24-hour live stream in, what's that math? It's 10 a.m. to 2 a.m. So 4 hours, 15 minutes. So hopefully he's getting himself some rest. Now this goal of 25,000, hopefully we knocked that one completely out of the park. Last year, I think we did far better than that. So, swoop to what transpired recently. And to do that, I have to show you guys. Let's see. Remember I said that this case brought about mistrial after mistrial after mistrial motion, just over and over and over and over again. Well, one such motion was brought on day 150 of the trial court proceedings, with a witness on the stand testifying to certain photographs that had been redacted because one of the defendants made an objection. One of the defendants properly objected that the photograph had beneath it a hashtag that said free Quay, which the implication behind the hashtag saying free Quay is that Quay requires freeing and is therefore incarcerated. When one of the charges that is being faced is possession of a firearm by a convicted felon, a jury discovering that he's been incarcerated might be prejudicial, which is why the motion was made and why the motion was granted by stipulation. So it's even worse. The prosecutor agreed that this would be redacted and it would not be recited in front of the jury. Despite the prosecutor's agreement, what do we think happened? And was it intentional or was it just stupid? Here.
I'm going to show you what's been marked as 37 and admitted, excuse me.
Oh, that was my mixtape name. That's why he put the hashtag. He was supporting my mixtape.
Your mixtape was No Slime Left Behind.
Yes.
What made you name your mixtape No Slime Left Behind?
Like the No Child Left Behind thing. There's in school.
Okay.
I just named it that. No Slime Left Behind.
And when you were talking about slime, who were you? Were you referencing anyone particular?
No, not nobody in particular.
Well, we're not doing this right now. Not tonight. Nope.
No, I just wanted to be different. I just named it that.
We're going to publish 37 NN.
Now, if we're looking at the photograph on the screen, y'all have, I assume some of you guys have used Instagram. You see that big old blank space right there? Life size blank. And then OTW blank. That is very clearly redacted, right? NSLB, no slime left behind. So the jury is now looking at a very redacted photograph.
Who is in 37 NN?
OG Boo. OG Boo.
And who is that?
Shannon.
All right. And can you read for the jury the caption?
Read his caption.
Yes.
Said ain't nothing more compatible than a trench. A carbon while in the trenches.
And then is there a hashtag?
Hashtag no slime left behind. Hashtag 2Bs. Life size.
Okay. And is there another hashtag?
Free Quay.
Well, there it is. Let's just go ahead and listen to the prosecutor swallowing their words, because
Life size.
Okay. And is there another hashtag?
Free Quay.
for those of you who didn't hear it, that's a big old whoop, whoop, whoop. Oh shit. Oh shit.
Is there another hashtag on the screen?
Oh no.
Your Honor,
It's in this paper
Your
right here.
Honor.
You got me reading.
Your Honor, I have to make a motion.
All right, I'm gonna excuse.
I wasn't looking at the screen. I was looking at this paper.
That's fine, don't worry about it. Can I ask you to step outside for just a minute?
Which makes it so much worse.
And jury.
All right, so everyone's rising, jury's out, witness is off the stand. That hair is a choice. How does one put a hat on top of it if you wanted to? Just hypothetically speaking. I mean, I'm impressed because that would take some
Ms. Josie,
time.
can you step outside for a minute for me, please? Thank you.
I've seen any number of hairstyles. That is wild. Here's one of the challenges with wearing a hairstyle like that. Better not ever get in trouble. Become very easily identifiable. All right, let's hear the motion.
Nichols, that while we were going to be,
Here we go.
Your Honor, we're making a motion for mistrial on behalf of Mr. Nichols. We're not going to be able to unring this bell. Your Honor, this is the exact same issue that while we were at the bench, I brought it up. It was Exhibit 37NN that the hashtag, there was a hashtag on that exhibit that said free Quay, which would definitely indicate to the jury that Quay, has spent time in jail or in prison. The state agreed. We stipulated that they would redact it. And then the state presented, I guess, to the witness the unredacted version, didn't prep him to not comment on it, and he did. And Your Honor, before we had the opportunity for you to preside over us, this happened already again. And before, and I made a motion for a mistrial. Now it's happened again. So now the jury has repeatedly heard about Mr. Nichols being in jail, being in prison, and you cannot unring that bell. We would ask for a mistrial.
Your Honor, Carter Matthews or Mr. Marquez, we join in that motion for mistrial. And what's important for this court to know is that 45 minutes ago, there had been a reference to a person being in jail. Now, this witness has identified Marquavius Huey and has also identified Marquavius Nichols. So all the state had to do was ask this honorable court for an opportunity to have this witness maybe step out of the courtroom and go over with that witness that, we don't need to say anything about someone in jail, what have you. That did not happen before he went on the stand, nor after that first slip up by this witness. There may have even been a document right there on the witness stand that should have been pulled from the state of Georgia from that witness stand so that this could have been avoided. So, Your Honor, we are joining in that motion as well.
Oh, hang on. It's all right. You just didn't know, but we'll let you.
Judge sees someone coming into the courtroom and is trying to make sure no one's there. All right. So let's just break this down a little bit. Why are they allowed to join in the motion? One, the rule that the court set forth in this case is that when one defendant files a motion, it's assumed that every single defendant is joining in that motion. So only one of the defendants needs to make the motion in order for every defendant to benefit off of it. However, because every defendant's rights are at stake, the defendants cannot they can join in, they can pile on, they can add additional argument if they think that, and I say additional, they don't get to repeat the argument, they can add additional argument if they think that it's important for their perspective or for their particular client. You have Marquavius Nichols and the other Marquavius Williams, so both of whom are identified as Quay. Whether it's this Quay that's being referred to in the hashtag or not, doesn't really matter. The implication is there. So what transpired? You had 45 minutes ago, you had a instruction given or the witness testifying to something they shouldn't have testified to, which is strike one for the prosecution. Prosecution has to prep their witnesses, and people are going to ask, well, what about prepping witnesses? You shouldn't have to prep them. Yes, you are the prosecutor. You cannot allow things, you cannot elicit testimony that is subject to a motion in limine or that cannot be heard by the jury. So you have to instruct your witnesses. It happens all the time. We've seen it happen with officers before. You have to instruct your witnesses that they are not allowed to go into a certain subject matter. I don't care if it's what the witness recalls. If a judge says you can't say this word, you have to find another word to say. So that didn't happen. So at that point in time, there was, again, a correction issued by the judge, and the state had an opportunity. They had a break. During that break, what someone from the state should have done is walked over to him and said, don't say that. You're not allowed to say that. Did they do that? No. Has this happened in the case before with other witnesses? Whole lot. So, as a practicing lawyer, in an abundance of caution, what would you do? Make sure that the materials that are in front of this particular witness has nothing on it that could draw that witness's attention to say the words that are the banned or bad words. Like a piece of paper that has the words they're not supposed to say in writing, right on it, in front of the witness testifying. So by agreement, they had redacted this particular exhibit, the exhibit itself. They had redacted it to remove the reference to this free Quay hashtag. Well, whether it was through incompetence or inadvertence or whatever you want to call it, they made the redaction of the digital file, but they still, and I want you to keep in mind that witness has the computer in front of him that displays what it is that's on the screen. So it's on the screen. It's there. Giving them the paper is redundant. But, you plan for the redundancies, right? So sure, they gave him the piece of paper. And while questioning this particular witness, maybe that prosecutor should have noticed he seems to be looking at the paper a lot. Maybe I should be more careful about the questions I'm asking because I don't think we got to that piece of paper. Or maybe I should draw his attention to the screen and say, Mr. Witness, if you wouldn't mind looking at the screen in front of you and not the paper, do me a favor, take that piece of paper and flip it upside down and just slide it to the side. We're just going to look at what's on the screen in front of you. Pretty simple question, right? Did that happen? No. So instead, what you had was the prosecutor directly asking, what is the next hashtag? Now, this is the other problem. You're in fucking danger territory. Because look at this. Where am I? Let's go back. Let's look at the exhibit. Look at the exhibit. The exhibit is And is this going to be the one that breaks the bank? No. No. But you ever hear about the straws on the camel's back? And all it takes is one, and it just happens to be that last one that breaks it.
Oh, no.
Your Honor.
It's in this.
Right there. So when you are a prosecutor and you're approaching danger territory, which is this previously redacted part of the page, you already know it's been previously redacted. So wouldn't you choose your questions a little carefully? For example, let's go here. What is the question that she asks?
And is there another hashtag?
Free Quay.
For example, is there another hashtag, one that appears after that? What is that? A alligator? It is such, or is a lizard, little lizard. It's a cute little lizard. You know, is there another hashtag after that appears this? Hell, you could probably get away with leading this witness because the judge has already made an instruction. It's already been redacted. No one's going to object to you leading the witness and say, doesn't this other hashtag say book and riches? OTW. Hey, no problem. There we go. We've bypassed the scary word. And then we don't have a motion for mistrial. And we're swimming. We're continuing to go. But no, we're just going to go ahead and just jump 2 feet ahead as if we don't give a shit, because consequences don't mean anything, right? It's not like you didn't previously stipulate to this and agree in your stipulation that, hey, the jury hearing this is of significance. So we're going to stipulate that this is not admissible. We're going to remove it from the exhibit and we're going to avoid the testimony. You have just acknowledged on the record that you think it's prejudicial. Is it a surprise to the jury that, you know, one of the Quays has been in jail? Probably not. They have seen these individuals every day for 150. And you can't tell me that they haven't reached a conclusion as to one or more of them as to their status of incarceration. It's not going to break the bank. But it's a big deal. And when this is one of several, what do? And that's what this entire trial has been. This entire trial has been a defense attorney's fucking nightmare. Because if you're a defense attorney, one, you have to be on guard for everything. Intentional shenanigans, mistaken shenanigans, witnesses that hate you, prosecutor that's out for you, other parties that are adverse to your interests. And now you feel like you've put one of these dragons to bed and you reach a conclusion that says it's not going to come out. And you're like, I should feel comfortable knowing that I have this resolution because we all acknowledge this isn't going to happen, right? Should feel that way. Not in this case. In this case, it has been painful to watch. Absolutely excruciating. I don't know how lawyers have watched every day of this trial. My hat goes off to them. I mean, but I don't know how you could do so and maintain a modicum of sanity. So let's see what it is the judge decides to do, or how we're going to try and unring this damn bell.
To know is that to Marquavius Huey. So the witness that would the front
Briefly add that it is painfully obvious that the state is not prepping their witnesses. You can tell by the way when the witness spoke the first time and he said, oops, am I not supposed to say that? Like, oh, I had no idea, which makes it obvious that the state had not spoke to him, had not prepped them. And this has happened repeatedly. It's happening over and over again, Your Honor, and we're just not going to be able to unring 100 bells.
And finally, Your Honor, Mr. Marquavius Huey, we all have, it's been established that that his nickname is Quay.
Okay, isn't there going to be, I mean, we talked today about, isn't there going to be a stipulation that references to Quay, at least at some points, are not either Mr. Nichols or Mr. Huey? I mean, we did.
Yes, Your Honor, and that's a few things. So one, Your Honor, it was not intentional because we clearly.
Okay, but it was sloppy because I presume he's reading from the document that you handed him instead of reading from the screen.
And we should have instructed him to read from the screen, but.
Or you
when-
should have presented him with a document that had that part redacted.
issue-
It's just sloppy.
The issue came while he was on the stand, Your Honor. So the issue did not come prior to. Ms. Westmoreland walked up to me while he was on the stand and said, I'm going to have an issue with that. Can you redact it? That is when the state became aware.
Then
Well-
it should have occurred to you, you know what? I'm handing him a hard copy of this document that is unredacted.
But
I mean,
not if there's multiple quays, Your Honor. If I don't know which quay that. they
hang
were-
on. Can we stop having people come in and out when I've asked the witness to step out and every time the door opens, they can hear what we're talking about? Please, just for a few seconds. I'm not asking anybody who's in here to leave. God have mercy, y'all. Huh?
The state is in charge of the witness and they supposed to be guided.
So incompetent is one way to put it. I mean, the judge makes the point. Just didn't it occur to you when you're handing this document to this witness, holy crap, hashtag still in the damn document. No, it didn't, because there's more than one quay. What? Just why? How? False. Not the case. Sorry, I've got another stream up.
Yeah, I mean, there seems to be.
And so that is the point in which we learned of it is we redacted it on here. Ms. Westmoreland brought it up here.
Yeah,
And when
and
I
you
came back-
didn't read it. I mean, so the
But I
jury
said-
didn't see it, but now the jury has heard it. I don't think it is really that, much of a crisis because there is going to be this stipulation that the, Quay is not always either of these defendants. So, nor is it obvious to everybody that free whomever is such a quote about who knows, everything these days. And so it doesn't necessarily indicate that whomever Quay spent time in jail or in custody or in prison or anything. I mean, they say it about, Hollywood stars who are in a breakup. I mean, it's not so obviously,
She's right. It's not the most obvious thing in the world. They know it. They're not stupid. They know that one of these is in jail.
Quay isn't either of these people. So let's just,
And
whether this was one of these people or I don't even know who it did refer to.
And we don't know because it's not his post. He was reading someone else's post. So it could be a multitude of
Okay.
quays.
You talked to his attorney
Yes.
earlier, right?
Yes.
And did you get any kind of an indication? I don't know if this
It
was
wasn't
one
an
of the
issue
things you
ear-
were gonna, but it's an issue now. And you said before lunch that you were gonna ask.
I can't get over how many times the prosecutors cut off the judge. That has been one thing about this trial that has just astounded me. Listen to you've heard how many times the prosecutors just talks right over top of the judge. My ass would be handed to me if I tried to pull that bullshit.
Mr. Rubin,
Yes, we did ask.
do you know at this point whether the
It's astounding and horrible. Prosecution's worse than horrible at this. And I don't know why I'm getting spinning wheel tonight. I had it fixed last week. Honey, turn off your Wi-Fi.
free Quay referenced, this wasn't even his post, was it?
All right, this is going to piss me off. This wasn't even his post. No, it wasn't. Blah, blah, blah. But the judge goes on basically says, I'm not.
A reference to, if you would prefer that.
I don't know what the poster is referencing. 'cause
I don't honestly really care what the poster was referencing. What I'm trying to do is fix your sloppiness so that everybody won't have wasted, 10, 12 months of their lives in this trial.
Yeah, we can.
In the world of you ever get trolled by your significant other so hard that you just stop and lose all thought process of what you were doing? Maybe you should turn off the Wi-Fi to the thermostat and your computer would go faster. Nice one, honey. So 66? Is that what we're setting it to? 66? Get your kicks on route 66. Don't threaten me with a good time. Okay, please don't fight. Okay. Hang on. Now the whole chat's involved. House routers overheating because the house too hot. Okay. All right. Hang on. Why a second? Despite the jokes.
So that everybody won't your sloppiness or that.
I don't know what the poster is referencing. 'cause
I don't honestly really care what the poster was referencing. What I'm trying to do is fix your sloppiness so that everybody won't have wasted, 10, 12 months of their lives in this trial.
Yeah, we can come up with
Okay, do it now.
And that's what I'm saying. The words that the judge wishes they would have back. I don't think she meant it this way. I really don't. I know people are saying that she did. I really don't. I think it is spoken in frustration of going, I know this thing is going to end in a damn mistrial. It's going to. One of these things is going to occur. And at some point, it's going to be that. You cannot unring a million bells. You can't. So a mistrial is going to get granted. I'm trying to prevent that from happening based on your stupidity, because I know as a judge that y'all are just going to come back and bring it again. It's going to be taxpayer money. It's going to be the defendant's time. It's going to be all this other stuff. But the judge shouldn't be saying anything that might imply that they would put their thumb on the scale, which is what this implication kind of gives. Trying to fix your sloppiness. That's not the judge's job. That is not. The judge is there to call balls and strikes. And if the prosecution can't throw a strike to save their life, then you got to walk the pitcher or batter. What am I saying? Walk the batter. And if the prosecutor continues to throw ball after ball after ball after ball, then you know what? We're going to have a really boring baseball game where it's like 15 walked runs. But it's not up to you to all of a sudden change the strike zone. If the prosecutor can't put one over the plate, you don't say, well, you've walked 15 runs in. You've already walked 15 runs in. So let's go ahead and do this. We're going to go ahead and bring out the kid toy strike zone. All you have to do is throw the ball in my general direction, and I'll call it a strike. I just thought in this case, prosecutor would probably do one of those first pitches that just goes just completely in the other dugout, just misses by a mile. And then the judge goes, let me correct this again. All you have to do is allow the ball to leave your hand, and I'll call that a strike. And the prosecutor goes, I can't let the ball leave my hand. I can't seem to throw the ball. Oh my God. But the judge is not there to change the rules of the game, which is how this starts to be perceived. So at the conclusion of this, Laura, what hand? This is a foot. What hand? This is a foot. Can I kick the ball to you, Judge? The judge like, sure, just kick the ball in my general direction. Different sport, but we're going to let it go. And the defense is sitting there, and they've got a guy in bat. I know culpristic. I get it. I understand. I'm saying is they're not supposed to. Umpires aren't supposed to do that either. The game is not supposed to. You're not supposed to alter the rules. And if I chose a bad hypothetical, then find a better one. There's all kinds of things you can find. It's just, it is horrible that you have this that has gone for 150 days and we're still getting all of this stuff fucked up. We can't figure it out at this point in time.
Y'all work on that. I'm going to take 5 minutes.
I think that would be, if I was presiding over this case, I think that would generally be my entire refrain. I'm going to take 5 minutes. I would probably be saying that every 5 minutes on the dot. Y'all figure this out. I'm going to take 5 minutes because I'm going to lose my fucking mind if you keep going. I would have a full wet bar in my chambers. There is no way. I don't know how a judge presides over this level of, can we just call it buffoonery? Incompetence? Whatever you want to call it. If you are a DA and you decide that you want to bring one of the largest RICO cases that Georgia's ever seen, and you want to take a bite at that apple, and you're like, I can do this. I can absolutely do this. Well, you better be fucking sure you can do it. Because if you're not, you end up with this drain on taxpayer resources. There is a judge, one out of how many judges in Fulton County, who has presided over this trial for 150 days. Here's Nicholas. I knew you'd be here, buddy. 150 days, 50 motions for mistrial, 320 sidebars, 36 jury instructions, 1 recused judge. Welcome to my life the past 1.5 years. Nicholas, better thee than me. Those are the stats, folks. 150 days, 50 motions for mistrial, 320 sidebars, 36 jury instructions, which means that something stupid was said that the jury had to be instructed or admonished or told they're not to interpret something or to interpret something 36 times. One recused judge. What a mess. So, what happened at the conclusion of that day, which was last week? At the conclusion of that day, there were whispers, that Fonnie Willis was meeting with the defense. And Fonnie Willis herself, being the elected DA, not these 3 that are there trying the case. Fonnie Willis was meeting with the defense attorneys and or their clients. Well, not their clients, but defense attorneys separately and in private to discuss the possibility of some plea deals. Why? Because Fonnie Willis is up for re-election. And her chief opponent in this re-election is saying they would dismiss this case on day 1. Do you know how big of an L that is? Where you're a DA and you have spent this much money, this many taxpayer dollars, this many resources, this many prosecutors, this many people, this many resources to bring a trial that is this messy, for the next DA, where the elected, the body politic comes in and they vote somebody else in office who dismisses all of the work that you have done since you were elected. They dismiss it on day one. And that was the campaign ad they ran on. So if they get elected, that's literally the people of Fulton County telling you that your entire effort in this regard was wasted. But that's what she was facing. So what did she decide that she needs to do? She needs to start making deals. Well, it's not easy because the defendants are all well, I mean, it's a little bit easy. The defendants are all sitting here going, they're going to get a mistrial at some point. Is going to get overturned on appeal at some juncture. But while this is all pending, each one of these defendants is in custody. Guys, Nick Starro has been covering this trial. Bless him. Since its inception, since it was brought. I don't know how, but he has. So he is, please go check out his channel. I think Nicholas Starro Trial Watch. Please go check out his channel if you want to see any of that. I know he had a big panel of several of the defense counsel from this trial. We're on that panel immediately prior to FNF, I think, this evening, including Thug Weinstein, who's been one of my favorite people to watch because he just explodes in rage. He had various other of the defense counsel on a live stream recapping a lot of these plea deals. So please go check out Nicholas. But Nicholas is saying rough calculation, $700,000 per month. That's the cost of trial. And people are asking, is that both sides or just the prosecution? A lot of these defendants have court-appointed counsel. Court-appointed counsel that's funded by the state. And they get paid measly amounts of money per hour and per case. And when they're in a case, they can't get let out of a case and because they accepted it. And this case has been all-consuming. There's been attorneys that have lost their entire law practice because of defending this case at those wages. It's all taxpayer money. So anyways, Fonnie Willis starts meeting with all of these different defendants and defense counsel, with the exception of one, Brian Steele, Jeffrey Williams' lead counsel, because Brian Steele will not speak with Adrian Love directly. Or I don't think he'll speak with any of the prosecution team directly. Oh, and Nicholas saying that's just the state's cost. That's batshit crazy. $750,000 been going for what, 15 months so far? So 750,000, 15, 16 months, 750. Let's call it 16 months. $12 million. What's the population of Fulton County, Georgia? Let's see what this is. What's the population of Fulton County, Georgia? Fulton County population. Population of Fulton County, Georgia is 1,084,512. So let's do a division. Divided by 1,084,512. That means that every single person, every individual in Fulton County, Georgia is out of pocket $11. Every single person in Fulton County has paid $11 towards this trial. If you're just doing divide by the numbers. And that's so far. And that's just the state side. So there's just over $1 million in Fulton County, and the trial has already run $12 million. What a waste of freaking resources. Do you know how much that could have funded in other prosecutions that would have been, going forward? You could probably, imagine how many judgeships you could have funded with that. Police, schools. Infrastructure, roads, all the above. Oh, I love pie. That's not $11 per month. That's from the case's inception. But when you think about 1 million residents of Fulton County, Georgia, and they've spent 12 million thus far. It's pretty wild. Meals in schools, buses. I mean, pick your poison. What could this have gone to other than this trial? And you know what's funny? This trial, if let's say that you brought the trial and there's some charges in here that are righteous, there are some people that are in this trial, some defendants that will go away to jail for a very long period of time. But why would you try it in this fashion? Create this shit show. So anyways, let's go ahead and swoop and talk about what happened more recently. Actually, let's see if there's any questions. Paladin Phil, elected versus appointed DAs, both options suck. Can. Rob, TP links, internet via electrical wiring. The route is right here. I think it's right there. It's honestly a Verizon problem. JPC 66 is perfect. I love it. Deanna Miller, Janowski, run AC at 75. It's cold when it's 90s in the Florida. Yeah, I remember that too. I went to law school in Florida. Ames, thanks for becoming a member. Much appreciated. Thanks for being here. Trish, this is probably right. Aren't people in Fulton County still waiting months just to be arraigned? I can't remember if it was Fulton County or somewhere else in Georgia. It might be the case. I don't know. I wouldn't be surprised. So back and forth transpires over plea deals, and this is Nicholas. This is where my head goes with this too. This is where my head goes. Remember the Johnny Depp trial when Judge Ascarati was on the bench in that trial for 6 weeks? 7 because you had the judicial conference. I will tell you that each one of my cases, when I bring the trial, my cases will generally, simple trials, single day, right? No problem. One day you get a resolution, done. So that's one judge, one court day, full matter taken off the court's docket. Some of my trials will be 2 days, 3 days, but the majority of trials take place in between anywhere from 1 to about 3 or 4 days, right? It's rare that you get a trial that's going to take a full 2 weeks. Heck, we just saw Sarah Boone's trial. That was two total weeks. 2 total weeks for the Sarah Boone trial. That was a complex murder trial where you had a defense that was going forward, right? So it is not normal that trials take more than 2 weeks of time. The Johnny Depp Amber Heard trial took a long time because there was a lot of witnesses, and honestly, it probably didn't need to take that long, but it did. So if one case can be resolved in a single day, let's say that on average, you can resolve, a single judge can resolve anywhere from, in circuit court, and that's not including motions. I mean, full trials, start to finish full trials. Say they get anywhere from 10 to 12 matters off their docket in a single week because they're working, they're doing motions practice, they're reviewing orders and signing them, they're hearing trials from start to finish. Heck, you probably bump that number to 20, 25. You take one judge out of commission and dedicate them exclusively to one trial for 150 court days. The damage you do to that court system is incalculable. Fulton County might as well, I mean, that should be a special docket initiative. I mean, a special initiative, ballot initiative, like bring on a new judge to preside over this, fund a new judge so we can have one judge presiding over this trial. 300 people in Fulton County have waited 180 days or more for their bond hearings. Yep. Resolved includes misdemeanors with guilty pleas. Oh my gosh. You cannot overstate how much of a dumpster fire this trial has been. Could have brought each of these charges separately, but they didn't because they needed the violation of RICO. I can't believe this. So let's do this. Let's give a little bit of sanity. I like the what do you think the goal was here? Realistically, what was the goal? They wanted the gang to stop. They wanted to stop to a lot of the gang violence, the gang behavior, the brandishing of firearms, all of the above. They wanted to stop to all of that behavior. So the inception of this one, the beginning of the trial, the beginning of the case probably had a noble cause. But they looped people into this that probably shouldn't have been looped into this. They cast a net so wide that it just caught so much. And the rule of unintended consequences, like just if they would have gone after each one of these individuals, it would have taken a lot of resources. But so much of this is I don't know. They had a lot of these cases locked up on individuals. I mean, you could have brought charges, got convictions on several individuals, but they wanted to get the gang activity down. And most notably, if I'm being honest and realistic, I think Fonnie Willis wanted to have that big old RICO conviction. Hubris, like you're the DA that brought the largest RICO case in Georgia state history, the largest RICO case in recent history that's not a federal RICO case, right? Feds do it all the time, but like you brought the RICO case that went down in history as being the largest in Georgia history, and you got all these convictions. You cleaned up the streets, and you cleaned the streets up of gangs. You're anti-gang. But she'll go down in history. I just don't think it's going to be. And you know what? This will go down in history as a large RICO cases in Fulton County and Georgia history. It will. But it's going to go down as the largest RICO case in Georgia history, not in a good way. I think the next time a judge sees a RICO case that's being brought, they're going to look at it with some serious scrutiny. And I think this has a very negative consequence in the next DA that looks at a case that could possibly be RICO is going to look at this particular case, the YSL trial, and say, do I really want to charge it this way? E-Class is just pouring depressing stats in the chat. Over 1,000 blank kits are still in the cooler because there's no money to get these tested. I'm not anti-prosecution. I'm not pro-defense. I'm not pro anything. I'll tell you what I am pro. I am very, very much pro not wasting resources and putting it towards cases that need to be just brought to conclusion. One way or the other. On a positive note, let's check in on Ian's status. So Ian is currently at $10,230. We have set a goal for chat this evening for 15,000. For those of you that are here, if you're able to, please do so. There's a QR code that's at the top of the screen. That QR code will take you directly to this website where you can donate to Ian Runkle's Extra Life Charity, which again is a 24-hour live stream that he will be beginning at 12 a.m. Eastern time, or no, sorry, 2 a.m. Eastern time, 12 a.m. Mountain time. And we are helping him get a jump start. So helping him raise money for the Stella Children's Hospital. Thus far, we have raised $10,230 towards his now goal of $25,000. My hope is to get his goal from $25,000 to $125,000. And he's got, where are we now? 28 hours to do it. So 28 hours. Anyways, so Fulton County DA realized writing's on the wall. Judge is going to grant a mistrial. The judge made clear that the mistrial would be without prejudice because it would be, which means the state would be able to bring the charge again. These defendants are all incarcerated pending trial, which means that if they're bringing the trial again, especially under this DA, they're in jail for how many more months and years while this is being resolved? Who knows? So the DA is doing some math. Defense counsel is doing some math. The DA starts meeting with people in secret. And lo and behold, start of this week, we start getting more whispers of possible deals being struck. Honestly, for every negative connotation you think of, for every negative connotation that we think of when it comes to deals and people admitting guilt, there is a whole lot of cost-benefit analysis that goes into it. These attorneys have been representing their defendants ably for 150 days of trial. So I have no problem with any of these individuals making the assessment that they don't want to wait indefinitely while their trial is being, kicked down the road. They would like to make the pain stop. So we're going to swoop back to the negative. And only slightly negative. So among the defendants to cut a deal was this lovely gentleman, which, yeah, is this Nichols? Let's listen. This is where defense counsel takes over. Prosecutor relays the conduct. They're recommending a certain sentence disposition, and the defense gets to make a statement. This defense attorney didn't hold back. I loved it. This is probably one of my favorite parts. Defense counsel did not hold back. Defense counsel did not hold back when given the opportunity to speak and address the court as to the prosecution's conduct leading to these charges, and thus far in this case.
With Mr. Stillwell at a Chick-fil-A gas station, Chick-fil-A restaurant.
Oh, come on.
There is a chase, I won't call it a high-speed chase, but there is a chase through the city of East Point, and eventually Mr. Nichols as well as Mr. Stillwell are both apprehended.
Going to 1 point. Let's go 1.5. It takes a little bit. Talks a little slow.
After arrest warrants were ultimately taken out for the murder.
Holy crap! Never mind. 1.25.
Given where we are in the case, Your Honor, we know that Mr. Nichols. We do not believe Mr. Nichols was in the vehicle in which the shooting occurred, but he was in this other vehicle. The state has made a decision to move forward with this recommendation for the RICO count, Your Honor, for count one.
Mr. Harvey, are y'all acknowledging a factual basis to the count one, the RICO count?
Okay, we are acknowledging a factual basis. There has already been evidence with regard to the July 3rd, 2017 drug event, the October 23rd, 2018 drug event. We categorically deny and contest any use of violence by Mr. Nichols. We don't agree to the underlying factual basis. We believe those two predicate acts that were committed by Mr. Nichols without any question are sufficient to meet the elements of the offense. The offense to which he's pleaded to, which is a RICO conspiracy. A RICO conspiracy requires proof that the defendant either conspire with another person to violate one of the substantive provisions of RICO, and that would be drug offenses, or personally endeavor, I believe that's what the language of the statute says, to violate one of the substantive provisions.
Well, that's what the language of the statute says, but
Yes.
he is indicted in this indictment with conspiring, not with endeavoring.
That's correct. So we're talking about a conspiracy. We acknowledge the two events that he participated in. We categorically deny any other allegations.
We preserve our appeal. We preserve our appeal. The statute itself. We preserve our appeal. We categorically deny. We are pleading to the indictment on count 1. We are saying fuck you to the state on every other count. Look at Adrian Love. This is my favorite part. By the way, is this guy related to Ian Runkle? It's phenomenal. I love him. I love him. So look at Adrian Love during this. I want you to start guessing what it is that she is thinking while he is talking, because her eyes are on one person. It is wild. Come
Other
on.
than those two events that are sufficient for a
Oh no, come on.
factual basis. We categorically deny that we participated in any way in the unfortunate death of Mr. Drinks. We categorically deny any other charges to which we are substantive charges to which we are not entering a plea, and that includes gang charges. This is a plea solely to a conspiracy to violate the RICO Act. So but yes, we acknowledge a factual basis to that extent, Your Honor.
Understood. All right, thank you.
Your Honor, I just have one additional thing to say.
Go ahead.
The factual basis regarding the nature of YSL is that the evidence has shown and will continue to show that Mr. Nichols conspired with others to participate in Young Slime Life through a pattern of racketeering activity, and multiple defendants and unindicted co-conspirators have committed overt acts to further this conspiracy, including drug sales, aggravated assault, and murder, also including social media posts asserting the violent nature of and asserted dominance of Young Slime Life, also known as YSL. And that concludes our factual.
And again, once again, we categorically deny those representations. And again, the only thing that is necessary to meet the factual evidence of a 16.
Oh, that is so boss. Oh, yeah, baby. Oh, that's so great. Oh, that makes me so happy. This is what we pled to. You can try to put on the record whatever the fuck you want. This is what we pled to. We deny all other allegations. You have to prove everything that you're saying right now. We stipulate that the factual basis exists for these charges and these charges alone. And this is what I'm telling you. My client my client denies everything else. And Love is sitting there looking at her deputy prosecutor and shitting a brick. And basically, if she could do that Darth Vader, like, I'm going to lift your ass up and like make you say something.
14.4c is proof that the defendant conspire with another person to violate one of the substantive provisions of RICO, and that is subsumed by the drug offenses that have already been proven in this case, and to which Mr. Nichols has previously pled.
All right, thank you. Understood.
And Your Honor, I approach with the waiver of rights for
Yes. All right. Mr. Harvey, have you reviewed with Mr. Nichols this plea of guilty and waiver of rights form, which the two of you have both signed?
I have, Judge, in
All
each
right.
individual provision in that plea colloquy has been acknowledged and gone over personally with Mr. Nichols.
All right. And Mr. Nichols, have you had sufficient time to consider this guilty plea that has been negotiated between the state and your attorneys and to discuss anything you wanted to about that with your attorneys?
Yes.
All right. And you understand, I hope, I'm going to ask you, that it is your decision ultimately, obviously with the advice of your attorneys, but it's ultimately up to you individually to decide whether you want to enter this guilty plea or not. Do you understand that?
Yes.
All right. And you do want to enter this guilty plea?
Yes.
All right. And Mr. Harvey, have you advised Mr. Nichols of the alternatives if he does not ultimately go through with his guilty plea and the potential benefits and drawbacks of all of the other options?
Yes,
All right.
very thoroughly, Judge.
All right. All right, Mr. Harvey, is there anything that the defense wants to add to the record?
Judge, other than the statement with regard to the underlying factual basis, I would point out for the court that when Mr. Nichols filled out his form, it says 29 plus. He is a birthday boy in a couple of days and he will be 30. And at 30 years of age, he has a wife. He has got a 13-year-old daughter. He's got a 10-year-old daughter and an 8-year-old son. His wife and sister, I believe, are here in the courtroom to support him. He, Mr. Nichols, was born and raised in Atlanta. And, you know, we're at this point, before I have even given my opening statement in this case.
Yes, sir.
I do want the court to know.
Oh, Harvey reserved? He reserved his opening? Interesting. So as defense counsel, you have the opportunity to give an opening statement immediately after the prosecution gives their opening statement. Generally speaking, most defense counsel do because you don't want to leave the jury hanging with the prosecution's words before they start hearing the evidence. But there are certain cases where defense counsel will withhold, or they will elect to defer their opening statement to the beginning of their case. And actually, come to think of it, in a RICO case like this, yeah, I could see that. So you wait for a couple of the other guys to give the defense counsel or to give the defense side. And at that point in time, the words that have gone by have kind of taken the prosecution's case in chief and taken their opening statement and minimized it. So you're not really facing the same risk. So by deferring after the prosecution rests, you get up and you get to give your opening statement for the first time. So the jury is sitting there having heard the end of the prosecution's case, scratching their head, and they get to hear you come in with a fresh recitation of what you're going to show as the defense. That's a nice move. Well played. Nice. Okay. I didn't know that.
That Mr. Nichols' mother died in prison. His father was shot by the Atlanta police when he was 4 years old. And he was raised by friends and family in the Atlanta area.
Hold up, Nicholas. That's the Harvey rule? All right. This dude's a boss. How did all of these defendants get these really fast trial attorneys? These guys are awesome. Thug Weinstein, Brian Steele, Mr. Harvey. So Mr. Harvey, apparently the rule I disclosed earlier about the ruling that was made in this case about one defendant has to make a motion and all of them have joined in the motion unless one of them opts out. That is called the Harvey rule. So if you're a badass enough that you get a rule named after you, sure. I love it. It's phenomenal.
Yeah. So he has come to this point in his life from a very humble beginning, and he has sought the support of friends in this courtroom and others in this courtroom. He is an intelligent young man who I believe has a future. Every day we do a word of the day. We put a new word into a sentence.
All right. This is making me really happy right now. I don't know if happy is the right word. Let me make a point before we get into this part. I said before, if you're a lawyer that doesn't get butterflies before you go to court, you're doing the wrong job. You've lost sight of what you got to do. If you're a lawyer that's not nervous as hell and wanting to vomit the day before a trial, you probably need to just reassess what you're doing. If you don't start to panic that you have the life of an individual or the most important things in their life at stake, that you're holding those things dear, you're doing the wrong job. So lawyers, when they're delivering closing statements, can become theatrical, but oftentimes that's just a whole lot of emotion they've been able to withhold breaking through in the end. I imagine, based on where Mr. Harvey is going here, that we're about to see a little bit of emotion. And the word of the day thing is pretty fucking cool. So it's a pretty cool thing. I like this idea, this word of the day. We do a word of the day. 150 days these guys have been in trial. All of these defendants could probably, if they applied themselves, take the bar with what they have seen from their attorneys and the judge. And that doesn't dismiss the bad shit they've done. The justice system is supposed to it's supposed to provide various different, it's supposed to serve various different causes, right? So punishment is supposed to serve various different rationale, different bases. One of them is punishment for behavior that has been done. And the punishment must meet the level of a grievance or of the offense itself, right? So that's one of the goals. The punishment has to be commensurate to the offense committed. The other one is rehabilitation. Whether in meeting this goal of punishment meets the offense, whether they can be rehabilitation, whether the person can be rehabilitated into a society where they can serve a positive good. And that comes to the measure of the person. And it's not the same across the board. And it's up to defense counsel to explain to the judge, to give the judge the facts. Can this person be rehabilitated? I don't know. Mr. Harvey believes so. Very much, apparently.
And I think this is in his best interest. I know that there is, and I know this plea is negotiated, but it's a long downside from 7 to 20. So the courts will have jurisdiction over him for a period of time. So I asked the court, given who this young man is, and given our categorical denial of some of the factual basis, to accept the plea and sentence Mr. Nichols accordingly.
Mr. Nichols, is there anything that you want to say?
No, ma'am.
All right. All right, I find there to be a factual basis for the guilty plea to the RICO count one of the indictment, that being a conspiracy to acquire control or interest in money and personal property through a pattern of racketeering activity. And that is the only count that guilty plea is being entered for. The remaining counts of this indictment as against Mr. Nichols are being null pros by the state as a part of this indictment. I find, having heard the evidence up
to the point of trial right now that there is evidence of at least one overt act in furtherance of the conspiracy. And that there is evidence that would fall within the required statute of limitations to establish this RICO conspiracy count. One of the things that we as judges are instructed by our Uniform Superior Court rules to do
She's got to make certain findings.
when we are considering whether to accept a guilty plea and whether to accept a negotiated sentence, and this is a negotiated sentence in this case, is to take into account whether giving leniency in sentencing is.
Pause. I brought this clip up, like, so we're watching Nichols because I want you to understand the difference in disposition. We're about to get to Jeffrey Williams, Young Thug, but I want you to understand, because the judge just laid out here, and this is the caveat. This is why I brought this clip up and why I want to play this. So there's a negotiated plea and there's a negotiated sentence, right? So the plea is, we have negotiated that we will plead to this and you will null, pros, or dismiss, or we're going to plead to these charges and you're going to agree to dismiss these other ones, right? And then there's a second phase of that negotiation, which is, okay, if we plead to this, what are you going to give us as far as your recommendation? And sometimes you're able to resolve that. Sometimes there's an impasse. Generally speaking, the rule of thumb is that you don't enter a negotiated plea unless you have a negotiated sentence. You start at the end. You start with the very end of it. You start with, what is my client going to do in jail, right? And then you work your way backwards. So if you start with, I want the disposition to be that my client is out of jail in 5 years, then you look at the actual charges and you reverse calculate. And what you do is you look at the charge and you say, okay, so if he pleads to this, then right there, we're within that parameter, the 5-year period. But let's say the prosecutor wants additional plea to something else, right? Something that would put him in a 10-year range. At that point in time, I'm saying, look, if you wanted to plead to that, you have to come down on your recommended sentence a lot. So he'll plead to that, but you have to come down to your sentence. So that's the horse trading that occurs when you're talking about that. In this case, with Mr. Nichols, it was a negotiated plea, which means they negotiated and pled to the charges. Now, what you heard from Mr. Harvey was Mr. Harvey pretty much acknowledged that as far as the violation of RICO, they would have had it with how broad that statute was. So I want you to think of who won this plea negotiation. Mr. Harvey basically said, all right, you prove RICO, but in a minute, I'm going to show you what the charges were and what the plea was for. And then you're going to tell me who you think won. Now, before I do that, I'm going to remind you there's a poll pending on what the adequate or appropriate temperature is for the inside of a dwelling. Please help to resolve the dispute between mischief manager and myself and vote accordingly, because there's a household dispute and I need to be on the right side of this one. Let's let Judge Whitaker continue, because I did want to pause there to kind of give an example of what it was that we were talking about. A negotiated plea and negotiated disposition.
It's going to aid in ensuring promptness and certainty, or at least more promptness and more certainty with regard to corrective measures, whether the defendant, and in this case, the defendant has acknowledged guilt and is accepting responsibility for his guilt of the RICO count, and whether accepting the plea will aid in avoiding further delays, not just with regard to this case, but with regard to the entirety of our.
This is why there's disagreement in my household right now. That right there. It is not fall weather outside. It was 83 degrees today. If it was lovely fall, cool, brisk weather, then maybe 72 would feel comfortable. It's not fall. Doesn't feel like it.
Our system here in Fulton County. And this plea does go towards doing all of those things. I am going to accept the plea as negotiated and sentence in accord with the negotiated recommendation. As I said before, find there to be a factual basis for count one of the plea. I find the plea to have been freely, knowingly, intelligently, and voluntarily entered into by Mr. Nichols with an understanding of the consequences of doing that. And the sentence on count one is the sentence that has been negotiated of 20 years to serve 7 with the balance of those years to be served on probation. And that, I don't know if there are any special conditions attached to this that y'all have talked about at all.
There are no negotiated special
Okay.
conditions in those, but there are none as far as I'm concerned.
All right. Okay. So with regard to the time that you are on probation, you need to stay out of all kinds of criminal trouble. Make this a birthday present to yourself and to your children and to your wife and family, that you will leave from here today and leave whatever you used to do behind you and take the next few years. You know, you're going to have some years that are still to be served on this. You'll have credit for the time you've already served, but you're still going to be facing some incarceration time. But after that, you are going to be out, and you, I believe Mr. Harvey is correct, can be a productive member of society. And this is an opportunity for you to do that and for you to put your past behind you, the bad parts of it, and continue and make your children proud of you and set a good example for them, an example that I guess unfortunately you were not lucky enough to have throughout the entirety of your childhood with your parents. I'm sorry about that, but you can be the kind of parent that you ought to be to your children. So I am going to impose that sentence, and I am going to wish you luck and good fortune as you go forth from here. So I think that unless there's anything else from either party, that will conclude these proceedings, and y'all can go ahead and take him into custody. Thank you.
Thank you, Judge.
All right. So one down. The judge is probably like one down, more to go, right? So let's look. And I asked you guys a question, like, what do you think? Was that fair? Or was that not fair? That's too small. Let me pull this up. Enhance. Okay. So Superior Court of Fulton County, Quay Nichols, negotiated agreement, negotiated plea. Charges. These were the charges he was facing. The charges included 1, RICO. 2, murder. 3, unlawful for a person to employ or associate with a criminal street gang. 4, unlawful to commit offense with intent to obtain in a gang or a membership or increased status in a gang. Possession of a firearm by convicted felon, previously convicted of felony involving or use of possession. Possession of firearm or knife during commission or attempt to commit certain felonies. Use of firearm or convicted felon during commission of a crime. So I think that all of these 49 through 65 of those indictment charges, all of those were by conspiracy implication. They would have had to prove conspiracy to do this, right? So they could have roped him in as a conspirator to these different acts. So he pled to the RICO, and the RICO, based on Mr. Harvey's representations, was based on the drug charges, which, if you think about the drug charges, was the basically distribution of certain drugs, like lots of them, from my understanding. So the disposition that gets negotiated is 20 years, but he's serving 7 and 13 years of probation. No special conditions. So he's been serving from March 17, 2022 to present. So he gets what, 2.5 years of time served? 2.5 years. So he has to do 4.5 left. It's a pretty good deal. So you tell me who you think won in that negotiation with these charges hanging over their head. Even if you think you're going to beat the charge through trial. Who won? Because I'm of the mind that Mr. Harvey won that negotiation. And that was Fonnie Willis needing to put a W on the board, even if that W was a complete bullshit W. Because that's what this is. That's a bullshit W for Fonnie Willis. That's nothing. There's no special conditions. There's no nothing. You just behave well, serve 4.5 more years, and you're out. And they had him on direct evidence of the drug charges. So, what do you think? Started a chat that was going by that makes it really funny. This was funny. Rosemary's Kitchen. This shift manager, I highly recommend distracting him with a lengthy and involved study of how the thermostat settings are affected by things like 1, outside humidity, temperature, and 2, position in the house. How dare you? Don't you distract me with things such as that. Things that you know that I will like dive down into and completely not ignore and probably find out every answer to. It's not fair. Chat is conspiring against me. I've lost the chat. Lost the chat. All right. So all of that was a preview. And I mean a preview because we had, I did not in my mind's eye think that Jeffrey Williams was going to plea. I did not think that Jeffrey Williams was going to accept a plea. I thought that Brian Steele and Fonnie Willis were and Adrian Love were so diametrically opposed that there would be no chance in hell that we would get an agreement. And I was partially right. I was partially right. It wasn't all the way right. I was partially right. Let's check in on Ian and his charity stream. It's not streamed yet, but so Ian is up to $10,529, $10,539. QR code above my head will take you directly to the website where you can donate. Ian is participating in Extra Life Charity. It's a live stream that he will be doing for 24 hours beginning 2 a.m. Eastern Standard Time at 12 a.m. midnight his time, which is Mountain Time. It will be going for 24 hours. He'll be live streaming, playing games. I will be back on tomorrow at some point in time playing Dungeons and Dragons, which is a lot of fun and enjoyable. Also be auctioning off several different items, 64, I am told. And I think I will probably spare a pen or two that I have made. What do I have to do? Oh, you know what? I have the pen. I have the brother to the pen that I made for Ian's for Christmas. Oh. I could do that. That's a good one. But I've got several that I can probably, I don't know, get rid of. I don't know if I can say get rid of them, but you see, big screen. That one. Those are the ones I've got that I've made. Some good, some not. And I mean good or not. They're all good. Some I'm less proud of, some I'm more proud of. These ones are fun. Nope, these ones. The little ones. They're right. So we'll auction off some items for the charity live stream, but we're trying to get him a head start before he begins his 24 hours. That's the plan. That's what we're going with. That's what we're sticking with. And now we get to the true purpose of what I want to cover this evening, which is Brian Steele and Jeffrey Williams and the plea arrangement. So without further ado, let's see what we got.
JEFFERY WILLIAMS.
Good afternoon, Mr. Williams.
Good afternoon.
Are you the same Jeffrey Williams indicted in case number? Your Honor,
Yes, ma'am.
actually, have we all signed the indictment, or are we going to do that afterwards? Because I don't have a copy of it.
I don't know the answer to that.
I don't believe that we
We have
have.
not signed the indictment.
Okay, probably be a good idea to do that.
That would-
Does anyone have a copy? Because you don't? Okay.
Where's the one we were using yesterday? We'll do that in just a minute. You can go ahead with the colloquy.
And Your Honor, we don't have the waiver form as well. I believe that the court had one.
That right here.
I've got blanks. Y'all filled one out, right?
We have.
Okay.
Thank you. Mr. Williams, are you the same Jeffrey Williams indicted in case number 22SC 183572?
Yes.
Okay. And are you also known as Young Thug?
Yes.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No.
Is there any medication that you normally take that you have not?
All right. I'm being told, one, that it's too cold in this house. Two, that given the number of items that are available for auction tomorrow and the fact that the pen has not been disclosed, that perhaps I should auction one of these pens off this evening. So, giving you a warning. I don't know how I'm going to do it though. Let me think about this for a minute. Oh, Kristen, you're killing me. I did 5 boxing mesh and pens. I can get to the lathe, but I don't know if I can do. I can't. One, I can't do it tonight. Two, it's not the easiest thing in the world to just get to the lathe. Oh, I can auction off everything in the book. There's some that I don't want to give away. Oh, it's like a pre-auction. The way that we did it before was we basically allowed for bidding to exist for a certain period of time, and I would close the bidding and would announce to close the bidding within the chat. And whoever was the winning bid would be announced as having the winning bid for the auction. And then what I would do is I would have the opportunity to check and verify the donation went through to Ian's Extra Life charity stream. So instead of money coming to me, it actually goes, I would check the donation on his charity stream because I can see who's donated. There's a list. So you have to show, what was it? See, there's a list of people who have recently donated. Well, there was. Where the hell is it? There it is. It shows who recently donated. But so, for example, holy crap, Dr. Z has been the top donor. He donated $500. And there's a bunch of other donations that I see to the incentive calendar 25 incentives. So there's incentives to donation that he's going to give away. And there's also different donations. But what we would do is we would kind of conduct a quiet auction where people would place bids on a pen for a period of time. And then we would close the auction, and then the high bidder would have to make their donation. And once their donation was reflected on the fundraiser website verifying that the donation was made, that person would win, and they would email me their address for where I could mail the pen. That's how we've done in the past. You guys let me know if you think that that's the way we want to do it. Kristen's bots, which are behind me, are also up for auction tomorrow. So I'll let you guys think about it for a bit while we play this. Oh, Ricky, you can open the bidding at 1 cent. You absolutely can. I would encourage you before you do, or before you, I don't know if the remark is a trolling remark or a joke remark or whatever. Encourage you to see how much the pens auctioned for last year. Timeout. I love this. What can a person that's rather broke do to support? Engaging in the chat, participating, communicating, helping build the community, talking with one another. Encourage your friends to watch the live stream. The more views it gets, the more people have eyes on it. I mean, all of the above. You've got tons of things that you can do to support this. Honestly, just participating in chat is a lot. 24 hours of live streaming is a long time. A whole long time for people to to be on a live stream engaging with an audience. It's very helpful to have someone to engage with. So if you're up and chatting and watching and supporting, that is a lot. It's a whole lot. And that's the part. Keep being awake. Yeah. Very much so. So let's continue. I'll let you guys keep chatting and I'll figure out how I want to do this, if I want to do this at all.
Not been given today.
No.
How old are you?
33.
And how far have you gone in school?
9.
Say that one more time.
9.
Okay. Are you able to read, write, and understand the English language?
Yes.
All right. Do you understand that you are charged with the following offenses? Conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, participation in criminal street gang activity, the leadership charge, participation in criminal street gang activity, violation of the Georgia Controlled Substances Act, 3 counts, possession of a firearm during the commission of a felony, and possession of a machine gun. Do you understand that?
Yes.
All right. And do you understand that you have the right to plead either guilty or not guilty to these charges, and that if you plead not guilty or remain silent, you will continue to receive a jury trial?
Yes.
All right. And have you received this waiver of rights form that I hold in my hand from your attorney and reviewed it with your attorney?
Yes.
All right. And is this your signature on the bottom of this form?
Yes.
Have you had enough time to speak with your attorneys, Mr. Steele and Mr. Adams, about all of the facts and circumstances known to you regarding the charges in indictment 22 SC 183572, including any potential defenses?
Yes.
Do you need additional time to discuss this case with your attorneys?
No.
Are you satisfied with their services?
Yes.
Mr. Steele and Mr. Adams, do you, on behalf of Mr. Williams, waive a formal reading of this indictment?
Yes, Your Honor. We do.
And do you, Mr. Williams, waive any and all defects in this?
Sorry, that's funny. That's really funny. So you know who's reading? You know who's reading right now? Adrian Love. We're going to rewind. Listen to how Brian Steele responds. Adrian Love is reading.
This indictment. Additional time to discuss this case with your attorneys?
No.
Are you satisfied with their services?
Yes.
Mr. Steele and Mr. Adams, do you, on behalf of Mr. Williams, waive a formal reading of this indictment?
Yes, Your Honor. We do.
I love this man. This objectively, just fucking love it. Fucking love it. She addresses him directly, Mr. Steele. Oh, the shade. The shade. It wasn't just yes. It was yes, Your Honor, making it very, very clear. I'm not answering you, lady. Not answering you. Fuck off. Oh my God. All right. We're not going to go through the whole reading. I want to get to the recommendation. Let me go to like 1.5 for the, we'll go to 2x for the rest of the reading of this, and then we'll go to the recommendation by the state, because she throws, this was a negotiated plea, but not a negotiated sentence, which is, holy shit, this is risky. You are negotiating and accepting a guilty plea on certain charges, but you're not anywhere close on what you believe the appropriate disposition is going to be. Oh, and Donna J, I'll explain. Brian Steele has previously said that he will not speak to Ms. Love. He does not trust her. He does not like her. He does not care for her. He has no respect for her. So he will not speak with her or to her. Therefore, in court, when Ms. Love is the one that's reading the acknowledgments, which is standard practice in Fulton County, apparently, is a plea open? No, but this is the thing. The state has to accept the plea open. It wasn't plea open. There was a plea to specific charges. Where was it? Where's Thug's dispo? Oh, because there's some NOLO. There was NOLO that he pled to. You know what? I'm going to put my foot in my mouth. I'm going to wait for a minute. Non-negotiated. He pled open. Shit. Wow. The whole plea was open fucking plea? That's just make the insanity stop. Wow. Hang on. What is an open plea? Open plea, pleading open, means that you are pleading the charges. You are saying, I either plead no contest or guilty to all the charges brought. Therefore, I accept whatever punishment the judge will impose. Let's proceed to argument on the punishment. It literally just, it is rolling the dice and saying, Judge, you have heard enough of this case. You have heard enough evidence in this case to know what a fair disposition is. Now, I know some of what the proposed recommendation was going to be. Is this just one big more fuck you by Brian Steele and Young Thug? All right. So he pleads open.
And do you, Mr. Williams, waive any and all defects in this indictment, including any with respect to your name?
Yes.
Have you been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorneys know of any outstanding warrants related to these charges?
Anyway.
Outstanding warrants related to any of the charges in the indictment?
No,
No.
I don't believe so either, Your Honor.
Okay. And I'm unaware of any as well, Your Honor.
I am as well.
Thank you. Have your attorneys advised you of the minimum and maximum sentence for each of the crimes that you are charged with?
Yes.
And each of the charges that you are pleading guilty to?
Yes.
All right. Your Honor, with respect to the charges that Mr. Williams faces, count 1 carries a minimum charge of 5 years and a maximum charge of 20 years in prison, or up to a $25,000 fine, or both.
Isn't it a $15,000 fine? Because wasn't it the version of the statute in effect at the time, or was that the same for RICO? Was RICO 25?
Yes, RICO was
Okay.
25.
All right, thank you.
You're welcome. Count 56 carries a minimum sentence of 5 years in prison, a maximum of 20 years in prison, consecutive to any other sentence, with a fine of $10,000 to $15,000 or both.
Okay.
Count 57 carries a minimum sentence of 5 years in prison and a maximum sentence of 20 years in prison. Count 58 carries a minimum sentence of 1 and a maximum sentence of 10 years in prison. Count 59 carries a sentence range of 5 to 30 years in prison. Count 60 carries a sentence.
Hang on, slow down just a second. All right, and that's for the amount of that drug that was found on 59, 5 to 30?
That's as a result of the charge itself, I believe, with intent to distribute.
I think that 59, Your Honor, is simple possession.
Already back and forth, baby. Oh, I love this. This is gonna be great, isn't it? I'm gonna love this.
Of cocaine. I have to look at the indictment to
I
be
think
sure.
that's 60.
Okay.
Let me look.
Okay.
Hang on. 59 is codeine and
Yes.
60 is cocaine.
Yes.
So,
Your Honor, it is with the intent to distribute. So my reading of the statute is that it carries the range of 5 to 30.
okay.
And Your Honor, also, as I have the indictment in my hand,
All right, Adrian Love, I need you to not do this to me. Not right now. If you wouldn't mind. Oh my.
it carries the range of 5 to 30.
Okay.
And Your Honor, also, as I have the indictment in my hand for Ms. Rosser, may I pass it to counsel for Mr. Williams?
Yes.
Thank you. Your Honor, with the court's permission, I'll permit time
Go
for
ahead.
them to. Okay. Count 60 carries a range of 1 to 5 years in prison. Count 61 carries a mandatory 5 years consecutive to the underlying felony. Count 62 carries a sentence of 10 years consecutive for a total maximum exposure of 120 years in prison. Were you aware of that, Mr. Williams?
Yes.
Do you understand that neither the court nor the district attorney's office has anything to do with parole or the Department of Corrections or the Board of Pardons and Paroles, and that if you are sentenced to confinement in the Georgia Department of Corrections, no one can guarantee parole?
You can say yes.
Well,
Yes, you can say that.
Oh, yes,
Guarantee
ma'am.
parole.
Your Honor, may I allow Mr. Williams time to finish signing the indictment?
Okay.
Your Honor, with permission, may I approach with a member of Mr. Williams' team?
You may.
Oh no, Brian Steele has to go up.
The blind plea. Mr. Williams, do you understand that this is a non-negotiated plea of guilty, and that since your guilty plea is a blind plea or a non-negotiated plea, the state is making a recommendation of sentencing to the court, notwithstanding the fact that this is a blind plea? You understand that, Mr. Williams? Okay. And Mr. Williams, were you aware of the state's previous offer that was turned down prior to your making this non-negotiated plea?
Yes.
All right. And Your Honor, at this time, the state is making a recommendation of 45 years with 25 to serve in custody, followed by 20 on probation, subject to the special requirements of 1615-4, the gang statute.
All right. And do you want to break down for me what your recommended sentence
Hold the fuck up. Hang on.
on each?
State's previous offer that was turned down prior to your making this non-negotiated plea.
Yes.
All right. And Your Honor, at this time, the state is making a recommendation of 45 years with 25 to serve in custody, followed by 20 on probation, subject to the special requirements of 1615-4, the gang statute.
All right. And do
45 years, 25 to serve, 20 probation, and then no contact with any prior or anyone affiliated with gangs. Wow. Shit.
Do you want to break down for me what your recommended sentence on each count is?
Yes, Your Honor. The state is recommending on count 1, 5 years to serve. Count 56, 20 years to serve consecutively to count 1. Count 57, 5 years of probation to serve consecutively to count 56. Count 58, 10 years of probation to serve concurrently with count 57. Count 59, 5 years of probation to serve concurrently with count 57 and 58. Count 60, 5 years of probation concurrent with count 57, 58, and 59. Count 61, 5 years of probation consecutive to count 57. And count 62, 10 years of probation consecutive to count 61.
All right, thank you.
Mr. Williams, did you discuss the state's previous offer with your attorneys?
Yes.
Okay.
All right, and so we're all clear that we're talking about the same thing. Can you put what the state's previous offer was on the record for me, please?
I can, Your Honor.
Thank you.
The state's previous offer was a total of 43 years with 20 years, 5 years to serve on count 56, commuted to time served, followed by 15 years on probation. On count 58, the sentence was 10 years to serve in the Georgia Department of Corrections, consecutive to count 56. Count 59 was 3 years to serve in the Georgia Department of Corrections, consecutive to counts 56 and 58. Count 60 was 5 years to serve in the Georgia Department of Corrections, consecutive to counts 56, 58, and 59. Count 61 was 5 years to serve in the Georgia Department of Corrections, consecutive to counts 56, 58, 59, and 60.
Was that the entirety of what the sentence was?
No, Your Honor.
I mean, I know
still
there were
reading.
special conditions, so y'all were
There
going
are-
null cross,
We-
what,
ye-
1
yes.
and 62?
Yes, as part
Okay.
of the recommended sentence, in exchange for
Listening.
the defendant agreeing to the special conditions that we asked the court to impose, the state was willing to null pros count 1, count 57, and count 62.
Okay, and then all of that consecutive to the probation, that was going to be what we call backloaded, and what were y'all proposing with regard to that, since it was
The
going to
total-
follow the probated sentence?
The total sentence was 43 years to serve, with the first 5 years in prison commuted to time served, followed by 15 years on probation, followed by 23 years in prison, which would have been served in confinement, except that if defendant had complied with the special conditions of probation imposed as part of this sentence, the backloaded portion of defendant's sentence would have been commuted. However, should defendant had violated any special condition of probation within the first 15 years of his sentence, his probated sentence would have immediately been revoked, and he would have been required to serve the entire remainder of his sentence confined to the Georgia Department of Corrections.
All right, so as long as he had successfully completed his 15 years of probation, the 23 years that was going to follow it was going to be commuted to time served, as long as his probation was successul. Is that right?
Yes, Your Honor,
Okay.
and the special, would the court like for us to?
No, I was really more interested in the length of sentence and what y'all had. I mean, I know you didn't reach agreement, but y'all, that's what the last offer had been, with, of course, a bunch of special conditions, which I guess is where the hang-up was. I don't know.
Right, defendant did not want to agree to the
Okay.
special conditions.
All right.
So Steele had them so bent over the barrel that they were going to let him walk and impose special conditions. One of those special conditions I recall was that he not affiliate with anyone who has any prior affiliation with gangs, which would have been his manager who manages his music. That's how he makes music. That's how he makes money. Okay. I think that was the hang up on the special conditions, but oh, and one of his brothers? Oh shit. So you can't talk to family. Can't talk to your manager. So you can't do shit. So how's he going to make money? How's he going to do anything? How is he going to become a positive member to society? If that's a condition. That was what y'all were hung up on? The state? His fucking brother and his manager? Was he agreeing to everybody else?
Is that basically your understanding too?
Yes, Your Honor. It would have been, yes, Your Honor. Mr. Williams would have been released today for 15 years on probation. If he successfully completes that probation, then he would not have to go to custody. If he did not, he'd face probation revocation as well as 23 years, as a court said, backloaded.
Backloaded. So basically just it, like if he doesn't successfully complete. This is going to piss me off, isn't it?
In the Georgia prison system, but we could not come to terms on all the conditions that the district attorney was insisting.
Okay. All right. Thank you. Go ahead, Ms. Love.
Okay. And Mr. Williams, were you aware of that previous offer as well as all of the requirements that that offer would have entailed?
Yes.
Okay. And had you had enough time to discuss that particular offer with your attorneys?
Yes.
All right.
The previous?
The previous offer. Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge in this indictment? Do you understand that, Mr. Williams?
Yes.
Do you understand that if you enter into a non-negotiated plea, you do not have a right to withdraw your plea once the sentence has been announced?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
I'm not on probation.
Okay, so you're not on
If you were on probation, but if you're not, then it doesn't matter.
Okay. Do you understand that if you are placed on probation of any kind by this court, you cannot violate any criminal laws of any governmental unit or any special conditions of probations without being subject to revocation for the balance of the sentence the court imposes?
All right, this is going to take forever. Let me get to Williams.
Plea and require either a guilty plea or a not guilty plea as to these.
Oh, this is a no-low argument. Hang on.
The right to subpoena witnesses and compel the.
You may.
Your Honor, on count 1, which is the racketeering conspiracy count, Mr. Williams is tendering a plea under nolo contendere. As to count 56, which is participation in criminal street gang activity as being illegal.
Wait, the state contests the nolo? On what grounds? On what grounds does the state have to contest the nolo plea? Now I'm real freaking curious.
Or a supervisor or organizer. Mr. Williams is also tendering a plea to this honorable court. Under nolo contendere, the balance of the counts, so he is tendering a guilty plea.
Your Honor,
Yes, ma'am.
would the court like to hear from the state or not?
About the NOLO issues?
Yes.
Sure.
Your Honor, the state asked that the court not accept a nolo plea and require either a guilty plea or a not guilty plea as to these charges.
All right. I'm going to permit a NOLO plea as to counts 1 and 56.
Nolo means nolo contendere. It means that I do not contend that the state has facts sufficient to plead or to prove the guilt. So nolo means essentially I stipulate that there are facts sufficient to adjudicate my guilt under this sentence. I am not contending or opposing the allegations in the indictment. Now, what does that do? It doesn't mean that I openly acknowledge guilt, that I openly acknowledge I did these things. I just acknowledge that you can prove that I did this thing, maybe. I don't think the state has the state doesn't have the, like, that was really dismissive too. Yeah. R. Bauer. Thank you with the intelligence. Sorry, it's late for me. Pleading guilty to the conspiracy charge, given the role that he had. He was alleged to be one of 2 leaders of this gang, if he had pled guilty and said that I was the co-conspirator, I was the individual who did all of these things, his plea of guilty was an acknowledgement that he orchestrated and directed all of these other individuals to do the things that the facts play out that they did. Wow. And that's the thing. Like, that's my question. What was Adrienne Love's grounds for not wanting to accept the NOLO? She didn't have a legal basis. She just said, I just don't want to. I just want to do this.
Anything to get you to enter plea because you are in fact.
Mr. Williams is tendering a plea under nolo contendere as to count 56, which is participation in a criminal street gang activity as being a leader or supervisor or organizer. Mr. Williams is also tendering a plea to this honorable court under nolo contendere. The balance of the count, so he is tendering a guilty plea.
Your Honor,
Yes, ma'am.
would the court like to hear from the state or not?
About the NOLO issues?
Yes.
Sure.
Your Honor, the state asked that the court not accept a nolo plea and require either a guilty plea or a not guilty plea as to these charges.
All right. I'm going to permit a NOLO plea as to count.
Everyone's saying to listen to Steele. Steele hasn't talked yet. Steele has not talked yet. The state is tendering. Steele is still yet to go.
It's 1 in 56.
All right. Mr. Williams, as to count 57, participation in criminal street gang activity, how do you plead?
I plead guilty.
As to count 58, violation of the Georgia Controlled Substances Act, how do you?
Here's Steele chime in. You're okay to say guilty now. I said my part. You can say guilty now.
Plead.
Guilty.
As to count 59, violation of the Georgia Controlled Substances Act, how do you plead?
Guilty.
As to count 60, violation of the Georgia Controlled Substances Act, how do you plead?
Guilty.
As to count 61, possession of a firearm during the commission of a felony, how do you plead?
Guilty.
And as to count 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, how do you plead?
Nolo.
As to count 56, participation in criminal street gang activity under the leadership charge, how do you plead?
Nolo.
I think you didn't ask about count 62.
As to count, thank you, Your Honor. As to count 62, possession of a machine gun, how do you plead?
Guilty.
Are you pleading guilty to the offenses you have indicated because you are in fact guilty of these charges?
Yes.
All right. Are your guilty pleas and your NOLO pleas freely
and
voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years?
4 years. Statute of limitations to raise that issue. Yes.
Today's date for a felony charge, and 12 months from today's date, you don't have a misdemeanor charge. But to file a habeas corpus petition challenging the voluntariness and constitutionality of this guilty plea.
Yes.
Your Honor, also, do you?
You have 30 days from today to file a direct appeal from this guilty plea and until the end of this term of court to file a motion seeking to withdraw the guilty plea, which does not mean it would be granted, but that's the time period. Okay.
What's a direct appeal?
Well, you can talk to your attorneys more about it, but it would be up to one of the, like the Court of Appeals, I think is where this one would go. Those are just the time periods.
And Your Honor, the state, in addition to the sentence we are asking that the court to impose,
Okay.
we would also be asking the court to require or to forfeit, have defendant forfeit all the property that has been seized and that is currently being held. That was.
You don't get to do that. That's a civil forfeiture action. You don't get to do that here. Stop trying to dunk. Now I get why Steele's pissed. Now I get why he's mad. Always trying to dunk on this fucking thing. This is ridiculous.
Found or recovered or taken from his home after it was searched on May 9th.
Do you have any kind of list of what that property is? I mean, I'm not familiar with what was seized.
And Your Honor, we're not
do.
agreeing.
Oh, I mean, I assume y'all aren't agreeing to anything.
We're not
You
agreeing
would
to that.
present it as a negotiated plea.
We're not, but we do have a list of the
All right.
property
Do you have
items.
it available right now?
No, you don't get to do that. Not right now. Not that's a separate action. All right, hang on. Someone's asked me to explain. So y'all have heard me talk about this in connection with the Sam Bankman-Fried case, right? So the adjudication of guilt is one thing, but oftentimes is a separate count. It is always a separate count. Is a civil forfeiture action or an action that's a forfeiture of essentially the property. All the property that is the call it this way, the fruit of the poisonous tree, the gains that you derived from the carrying on of this criminal enterprise, the money, the assets, the house, all the above. They want to seize that and they want to basically procure that and bring that into their fold. And what's really weird about that is they don't pay that out as restitution. It's just the state seizing it because you're done fucked up. So restitution cases are some of the most, I mean, the laws on the books with restitution are pretty fucking strict. Like they can, or not restitution, forfeiture. They can basically seize all of it, anything, all of it. Yes, yep. They are allowed to legally steal it. They really are. They're allowed to legally take all the shit. But it's a separate action. It has nothing to do with this because, as I discussed previously, in the federal cases, you will always see in the federal indictments that we've read, right? We've always read it, right? Federal indictments, you read down through, and at the bottom, there's always this forfeiture clause, this forfeiture request within the indictment. Noticeably absent from what I'm looking at as far as the plea arrangement or the plea here is a plea to forfeiture. There's no count in here that says forfeiture. I don't see it, which means it's a separate action they have to bring. And the government has the burden of establishing at least a prima facie case that what they're seeking to acquire, the property they're seeking to bring into their possession, is in fact the gains from this unlawful enterprise. Young Thug is a rapper. He makes money apart from the whole unlawful enterprise. SBF, Sam Bankman-Fried, ran a cryptocurrency scheme. Every dollar he earned was from this cryptocurrency scheme. Everything he purchased with those dollars was from those scheme. Right here, you have a distinction. What money was from the enterprise? What money was from the rapping? From what I can see, there's not a whole lot. There's not a whole lot that they can go after him and say this was from the use of firearms or all the other shit. Love was overreaching here. This didn't make sense.
Yes, actually, would the court permit us to send it electronically?
Sure,
Because
that's fine. And then if that is not imposed as a condition, is it just get litigated as like any forfeiture matter?
Yeah,
Yeah, it would be litigated later on.
It's
Yes.
a civil separate filing
Okay.
in this court. It's not related to the court.
All right.
It's related case, but it's unrelated.
Understood.
And we are sending that to Your Honor
Thank you.
at this time. And as it relates to the conditions of a conviction under 1615-4, Your Honor, we would ask, or as part of the sentence, defendant would be required to adhere to the requirements, the sentencing requirements of the gang statute, which at least in part require that he not associate with any gang members whatsoever. And I can read the rest of that into the record if the court requires, or I can continue with the factual basis.
All right. And let me ask you, because I know that at least while y'all were negotiating, one of the things that I guess was being negotiated was some exception for, I think, somebody that is contractually obligated on his record label. Is that something that the state would still be in agreement to?
No, Your Honor.
Okay. All right, go ahead.
All right. Your Honor, as part of the requirements of 16,
You ever hear of ask too much and you get slapped back down? Because I think that's what that was right there. When a judge says, is that something the state's still in agreement with? Might give you an indication of what the judge is thinking. Maybe you're overreaching. Just maybe.
15-4,
Yes.
defendant would, one moment, Your Honor. Under 1615-4, in addition to any other penalty provided by the code section.
Sorry. A. Hettinger is right. This is a good point. Forfeiture. They seize your shit. You have to prove that it didn't come from illegal activity. So they get to seize your shit and you have to demonstrate, no, this came from a legitimate purpose. But I think in Young Thug's case, it's a little easier for him to do that. So it's different. And Steele is up in arms about it, rightfully so, I believe.
all sentences imposed under the code section shall require as a special condition of the sentence that the person sentenced shall not knowingly
Wait,
have.
just a tad, because there's a court reporter taking it down. When we start reading, we read really fast. So go ahead.
This code section shall require as a special condition of the sentence that the person sentenced shall not knowingly have contact of any kind or character with any other member or associate of a criminal street gang, shall not participate in any criminal gang activity, and in cases involving a victim, shall not knowingly have contact of any kind or character with any such victim or any member of any such victim's family or household. So that is, and we've listed in our indictment the victims of the crimes, the overt acts that have been committed, and under the basic conspiracy law, those are the victims that we are naming. Your Honor, as this case has been tried and would continue to be tried until the state completed its case in chief, the evidence has shown that the defendant, through
Sorry, Ms. Love, for cutting you off. I don't think you were ever going to complete your case in chief. I'm just saying. I don't mean to throw shade, but I don't know that you were ever going to get there. I love this. You know what? You keep swinging, honey. You keep going, and you keep saying, I can do this. I can totally do this. Thomas the Tank Engine. I think I can. 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 As the state will eventually get to the end of this case, at the end of this millennia, on the 5th mistrial. Good God. Oh my God. Just let's rewind and hear that bullshit one more time. Oh my God. Oh, that was so terrible. That was so terrible. You don't even believe your own fucking lie. There's no way.
We've listed in our indictment the victims of the crimes, the overt acts that have been committed, and under the basic conspiracy law, those are the victims that we are naming. Your Honor, as this case has been tried and would continue to be tried until the state completed its case in chief, the evidence has shown that the defendant, throughout the time between 2013 to 2022, conspired.
Hold the fuck on. Steele is taking this man is taking those with a Sharpie. Sir, can we I need a moment. You are taking notes with a Sharpie.
That the defendant, throughout the.
Okay. He's getting really pissed off, isn't he? He's getting really mad. He wants to knock somebody out. Oh, God, I love this man. Yeah, this is fucking great. Holy crap. Just like, hang on, let me write this down in pencil. Fuck that, Sharpie. We're just gonna go all in. Oh my God.
The time between 2013 to 2022, conspired with both indicted and unindicted co-conspirators to participate in the enterprise known as Young Slime Life, or YSL, through a pattern of racketeering activity. Throughout that time, multiple conspirators, both indicted and unindicted, and including the defendant, have committed.
I have never in my life seen an attorney move this much. He is so mad. Wow, he is so fucking mad. I've never seen an attorney move this much.
Overt acts intended to further the enterprise itself. With regard to the defendant, as far back, the evidence has shown, as 2013, the defendant, along with other YSL founding members, Walter Murphy, for one, committed an aggravated assault and armed robbery against Derek Dotson. The court has heard evidence of that presented through Adrian Bean, who was a co-conspirator in that particular act. The armed robbery of an Archillian Bennett back in 2013. As alleged in the indictment, defendant and unindicted and indicted co-conspirators committed acts to further YSL that included drug sales, aggravated assault, and murder. They used and furthered, rather, this conspiracy by using social media posts and music to assert the violent nature of and the dominance of Young Slime Life, which is also known as YSL. The defendant is charged with being a leader of the gang YSL, and evidence has been presented by accomplices and co-founders of YSL, Trontavia Stevens and Walter Murphy, and evidence would have been presented, in the words of the defendant himself, that the defendant, as shown by some of his own social media postings, was the founder, one of the founders of YSL, along with Mr. Stevens and Mr. Murphy. YSL formed, according to the evidence that has come out in this trial, in 2012, 2013, under the former version of the name of the gang called Rock Crew or Raised on Cleveland.
Oh, this part's about to get off.
The court has heard evidence of the 2014 and 2015 incidents that have involved conflicts between YSL members and IF gang members that included someone shooting the window of Mr. Williams' car and armed individuals rushing outside during shootings at Club Crucial to ensure Mr. Williams' safety, shootings at a place called the Dugout where armed individuals rushed to ensure Mr. Williams' safety, shootings at Mr. Kelvin Watts committed by members of YSL, communication with members of YSL after those incidents, and ultimately the murder of Donovan Thomas at the hands of members of YSL. The evidence has shown and will show that on January 10th of 2015, members of YSL drove a car rented by the defendant, a gray Infiniti, and drove past Mr. Thomas as he stood outside of a barbershop, him, to the guns and the vehicles that were used in the murder. Persons who accompanied him to Miami, money to lay low. Little Wayne tour bus drove. Mr. Williams had come out at that time with a mixtape that carried the name of an album that Mr. Carter was set to release and was not able to because it caused Mr. Williams. And as the person who ultimately is a person that I believe that be free and
here's the thing. Why is Adrienne Love going on for so long? Why is she going on for so long? Because this is her only fucking shot. That's it. Why is she going on for so long? Because this is her one shot to get every piece of evidence in front of the judge that might persuade the judge that what the judge has been seeing throughout this entire trial is in fact not what the judge has been seeing. Like, she has one shot to get the judge to buy into this shit about Williams. I don't know. I've watched several days of this trial. I have read through several allegations. And I have not, I don't know. Maybe I'm wrong. Maybe I'm just a terrible judge of character. I don't know. I have not seen Jeffrey Williams as this. Did he do some shit? Yeah. Was it dangerous? Hell yeah. Was it stupid? Mm-hmm. Uninformed? Mm-hmm. Is he a present danger to society such that we need to incarcerate him to protect society? Adrienne Love hadn't proved that to me at all. So I am just struggling with all of this. I don't know that she's proven shit during this trial. I honestly don't. I think she's just confused. We're all confused. And I think Jeffrey Williams just doesn't want to be here anymore. That's where I am with it.
Members of YSL regarding communication about getting a lawyer. Follow members of groups that they can overt acts were committed by YSL. Specifically, the music, Your Honor, contained lyrics such as the following. I rep my life for real. For slimes, you know I kill. I shoot at your mammy, need to stand down. I up my stamina, take it to trial, get an appeal, take it to trial, pay for that casket. That's just if we whack them. YSL slimy and shady. Watch me whack that bitch, pop them like assist, block with the assist. It also consisted of a song wherein Mr. Williams sang or rapped the lyrics, hey, this is that slime shit, that YSL shit, killing 12 shit, fuck a jail shit. I'm in the...
It's a fucking song. It's rap. How are we saying that this is anything? I write poetry and wax philosophically about the size of the vehicle I drive. The fuck are we talking about? Of course he's talking shit. Fucking rap. How does this have anything to do with fact? Why is this a lot? This is bullshit. This is stupid. Yeah, you know what's funny? Look at any of Eminem's lyrics. Eminem's lyrics. Look at those lyrics. Set your house on fire, burn you inside, like all of the above, every single one of them. Is this what we're gonna start prosecuting people based on? Are we gonna allow this to come in trials to adjudicate their guilt or innocence? Or determine the level and extent of punishment? The fuck are we doing? What are we doing? You're going to charge for the acts. You want to convict for the acts. Convict for the acts.
The VIP, I got the pistol on my hip. Fuck the police. You praying that you live. I'm praying that I hit. This is slime shit. 100 rounds in a Tahoe. I'm prepared to take them down. Got banana clips for all these ends acting monkey. This is that slime shit. This is that mob shit. Fuck the judge. YSL. This that mob life. Defendant Williams released a video on YouTube of a song wherein he states, I shot at his mommy. Now he no longer mentions me. Act like you want war and they're going to smoke you like a blunt. Another song, I escaped every one of the licks because I was supposed to be rich. I don't care nothing about a cop. I'm just telling you how it is. I done did the robbing. I done did the jacking. Now I'm full rapping. Gave the lawyer close to $2 million. He handles all the killing. We don't speak about shit on wax. It's all my business. We know to kill the biggest cats of all kittens.
Oh, she does this for a while, huh? Cool. Read his lyrics. Got it. That's what we're going to do.
Junior, a phone call was made from Demise McMullen's cell phone to defendant Williams' phone. And then immediately after that call, Mr. Williams calls his Mr. Myrick reached out.
Keeps going. Holy shit.
Later, Mr. Stillwell, from one of the victims in the indictment,
and they're standing. Holy crap.
Asked Mr. Williams, do you have a star ring? What did he want? Mr. Huey responded with a number. Mr. Williams responded slat. After Mr. Williams stole a star ring from one of the victims in the indictment, he asked Mr. Williams, do you have a star ring? Mr. Williams said yes. Mr. Huey said, slat, you can't cash out me $500 so I can make a payment to my lawyer. Mr. Williams responded slat. Mr. Huey sent him his phone number. Mr. Williams assured him through his responses, slat, that he would take care of them. Throughout Mr. Huey's phone, you see messages of this nature between Mr. Huey and Mr. Williams. The court, again, will hear that.
Have impeached another witness. It's called detective. Help tell the jury.
Right. Come on, Brian Steele.
Definitely video was never
All right, well, if there's a conviction on the RICO or murder count following the close of this trial, that would be the appropriate time for the victim impact statement to be made. All right, Mr. Steele or
Wait,
Mr.
what?
Adams.
Wait, what? Does she want a victim impact statement? What?
Donovan
Miss-
Thomas is one of those acts.
I know, and this trial is not complete, and so y'all have not yet proven that. Not to mention that you dismissed the murder charge against one of the co-defendants who already pled, so
Not for Thomas,
charged.
the hope that Mr. Williams obviously made in the indictment. He asked Mr. Williams, do you have a star ring? Mr. Williams said yes. Mr. Huey said, Slat, you can't cash out me $500 so I can make a payment to my lawyer. Mr. Williams responded, Slat. Mr. Huey sent him his phone number. Mr. Williams assured him through his responses, Slat, that he would take.
What the fuck is slat? What is slat? Will someone translate slat for me? What is slat? I don't want to. Do I look this up? What is slat? Slime love all the time. Using it as ad lib similar to drip or no cap. I don't understand any of this shit. No cap, I get, means no lie, like I got it. No, yeah. No, that's slap. Strategic lawsuit against public person. That's slap. Very close, but slat. Apparently it means slime love all the time.
Take care of them. Throughout Mr. Huey's phone, you see messages of this nature between Mr. Huey and Mr. Williams. The court again will hear that as this trial continues. The recommendation that the state previously made prior to us reaching this point was made with the hope that Mr. Williams would agree to certain special conditions of probation that we asked him to adhere to, and that
Just
he would
amazing.
take ownership and responsibility.
Why are we like love, Adrian Love? Why are we here?
For being the leader of YSL. Given that those negotiations have broken down, we are asking that the court sentence Mr. Williams as we have asked earlier. And prior to the court imposing a sentence, we would ask that Ms. Shawana Edmonds, who is the mother of Mr. Thomas, be allowed an opportunity to make an impact statement. And that.
Nope. Nope. You don't get that. You only get that when you get to a jury verdict. Like you don't get that in a plea.
That is all that we have unless the court has questions.
Okay, well, given that Mr. Williams is not charged with the murder of Mr. Thomas, I don't think that that is applicable here.
I checked on that, Your Honor, with respect to count one. As a co-conspirator, Mr. Williams is responsible for.
Come on. Are you fucking kidding me? Adrian, his love, respectfully. The wall is at capacity. The wall cannot hold any more shit. You have thrown enough at the wall. It cannot bear the load of any more bullshit that you're trying to throw. It just can't. So he also pled nolo contendere for that. So just The wall is already full of your bullshit. Can't take any more. I know you're upset. You wanted this trial to go. You wanted this trial to be the trial that never ends. Jesus. Just. Oh. Whew. We're gonna have to take it. We're gonna take a break after Love finishes to auction a pen. It's gonna make us happy.
For all of the acts of the other co-conspirators, the overt acts, the overt act of the murder of Donovan Thomas is one of those acts.
I know, and this trial is not complete, and so y'all have not yet proven that. Not to mention that you dismissed the murder charge against one of the co-defendants who already pled, so.
Not for that case, Your Honor. That was Mr. Drinks.
Okay.
We've
Ain't
not
hearing
dismissed
shit.
any.
All right, well, if there is a conviction on the RICO or murder count following the close of this trial, that would be the appropriate time for the victim impact statement to be made. All right, Mr. Steele or Mr. Adams, does the defense want to put anything on the record? Obviously, you need to make a recommendation.
Yes, Your Honor.
Go ahead.
Many of the statements.
All right. Shall we pause and auction a pen for Ian's charity? I think we should, because oh my God. Wow. Adrian Love. I'm sorry, you just demonstrated in one fell swoop how absolutely disorganized, disjointed, and just everything about this trial, every single part of it. Okay, so here's how we're going to do this. We're going to auction a pen for Ian's charity, and here's how we're going to auction the pen. Do this. I've got Ian's charity pulled up, and right now we are at $10,795. Shaggy, you're free to go elsewhere if you don't want to. Or if you want to not be here, but that's fine. But I'm going to go ahead and give away at least one of these pens. So let's do this. Let's start with, we'll do this guy. I like this guy. All right, so this guy, for the next 5 minutes, we're going to go ahead and do this. So it's 12 a.m. my time, which means at 12:17 my time, we're going to go ahead and just say bye to this pen. For scale, is that big? Yes, I made it. Start the bidding at, let's go ahead and say $50. 5 minutes to bid on the pen. I will probably I'll probably auction all except for one of these tonight. So the rules are you can bid for the next 5 minutes. So until, we're going to say until 12, we're going to say until 12:20. Till 12:20, we're going to go ahead and accept auctions or accept bids on this one. And we'll start doing countdowns on the amounts. The mods are going to track and see exactly how much is being wagered. And what we're going to do is the winning bid is going to make their donation to Ian Runkle's charity stream. And then when the donation clears, they're going to send me an email with where it is I can send the pen. So again, pens handmade. I don't sell my pens. I do not sell them. I only give them away or auction them. So right now, I think we've got 600 as the high bid. I didn't see the first person that did it, but 600 was the high bid on the pen. 601. It's a fun pen. I like it. Little 22. Ink is refillable. Little cartridges. I have the Amazon link for the replacement cartridge, so it's not just a single use. Works well though. I like the little ones. So this guy he was resin, he was epoxy. Probably turned him last year. Oh, we're up at 1,000. Sandy, stop bidding. I mean, you can bid if you want, but again, these are for donations for charity. Don't got to pay me a cent. Just got to donate to Ian's charity. The donation amount is what gives this. I'm just sending this to the person that donates at that amount. Again, do not donate until you are verified as the winner. Once you're verified as the winner of the auction, then go ahead and send that donation. Once the donation is confirmed, I'll go ahead and send the pen to you. You just have to email me your address so I can send it to you. 1,100 is the high bet right now. It's the high auction. It's a charity donation, not a charity pledge. We are not doing an Amber Heard thing here. Again, I like the bolt action. And this guy, he's the small one. This guy fits in purses and pens and pockets. See? Look. Ian is not live yet. Ian's not live until 12 a.m. Again, we're going to go ahead and leave this one up for about, what do we got? 4 more minutes. So right now, this evening, I'm going to go, I'll tell you what I'm auctioning. I'm auctioning so you guys can make the assessment. We have these 3. So we have 2 small pens, a mechanical pencil, all of which that I've made. And then Mischief has added a set of bracelets made by Mischief and the Minis. So we have four total things that we're going to auction this evening, and 1 that I'm saving for tomorrow. The one I'm saving for tomorrow, I will preview. The one saving for tomorrow is the brother to the one I gave Ian for Christmas. This guy. That's the brother to the Christmas one. And if you can see, that's shotgun shell bullet cartridge. That's the one I'm saving for tomorrow to auction. And it has a flaw in it, a remarkable flaw in it that I tried to patch. See? So it's flawed, but it's still good. But the one that's up for auction right now is this one. That guy. So you bid Can a Bunch by placing your bid in the chat. You place your bid in the chat if at the end of the bid, which is at 12:20, if at the end of the bid you are the high bidder, you confirm your bid. Once you are announced as the high bidder, you confirm your bid by making that contribution to Ian Runkle's charity stream. When I see the Ian Runkle's charity stream, when I see that having hit or having that deposit hit, then you send me an email that verifies your contact information where I can send the pen to you. And that's how it's all done. So we've got 2 more minutes to go ahead and do that. I will post in the chat when we're starting to do the countdown, because you'll see when I post in the chat, you'll see when I'm starting to count down. I know there's a delay in what I'm talking about, but I want you to focus on the chat itself. So I think the high bid right now is what, 13.15 is the high bid for the purple and blue. We'll call this one, why don't we call this one Purple Swirl? So this is called the Purple Swirl pen. So Purple Swirl. So when you make your donation to Ian's page, you have to call it the Purple Swirl pen. Purple Swirl pen when you make the donation. So that's the note you have to put in the donation page. And please, yes, it is epoxy. I didn't pour it. This was not one of my pours, but it is epoxy. It is resin. So let's see. Guys, please don't re-announce the high bid. The mods are watching it, so please don't re-announce the high bid because it can confuse where the bid is. Right now, I'm seeing Paladin Phil at 1330. That was the most recent bid for this one. But this is, again, a donation to the Children's Hospital. And once I see the donation go through, the pen is yours to have. That's how we do it. That's how we're gonna do it. That's how we're gonna get Ian to above $100,000, hopefully, in donations to this lovely hospital. So we got 1350. What I'm gonna do with 1355 is I'm gonna go ahead and say in the chat, watch the chat, not my words, watch the chat. Watch the chat. Watch the chat because I just posted. Hang on. And
I'm hiding in the back.
all right, bidding is closed. Bidding is closed. So bidding is closed. Ian has popped on to say hi.
You know that thing where you're trying to sleep and your brain goes, "You have things to do,"
I know.
and then you
know.
just can't sleep.
Now, Chad has
So I guess
told
we're
me about
starting the Red
something.
Bull.
We are. Chad has told me there's something I forgot to do. So it's not fair for me to do the bidding without removing slow mode. So, mods, can one of you take care of removing slow mode? Please?
Yeah, I feel like you have to add a little bit for that.
Yep. If you can, if one of the mods can remove the slow mode, that'd be very helpful. But high bid, who won? So who was it? Mods, did you catch it? Oh, Ms. Pete, I missed you. Ms. Pete, you slipped in right at the last second before after bidding was closed. There's more pens, Ms. Pete. There's more pens. So the high bid that I've got, mods, can you confirm this is the high bid? Paladin Phil.
Dang. Paladin Phil, that's going to do a lot of good.
All right, Paladin Phil. As soon as the deposit, as soon as if you can either email me. I talk about Bruno, slow mode's being turned off, and I've got more pens to auction. Okay, you have not missed out. So, but as soon as that donation comes through, then that pen is yours 100%. I just have to verify it. And if you want, you can screenshot that and send that to me, lawandlumber@gmail.com. Screenshot the donation confirmation when you get the email or whatever. Again, lawandlumber, all spelled out, LAWANDLUMBER@gmail.com. So that was this pen, Paladin Phil. Congratulations on becoming the very lovely owner of a pen that I very much enjoyed making. I love the bullet pens. They're fun to make. I'm not going to auction off. I told you I'm going to auction off the let me do this because we've auctioned that one. I'm going to auction off the twin of the one that I gave you for Christmas and your birthday. This one.
Ooh.
And I've already pointed out the flaw to it, so you know it's original.
Yeah, it's like these are not coming off a machine because a machine wouldn't screw this up.
The machine would not screw that one up. If the highest bidder does not make the payment then what we have done is we have then defaulted to the next person. We give the next person down the opportunity to make that payment. That's what we've done, historically speaking. And by historically speaking, I mean, we've done the auction, I think 3 years now.
I think, yeah.
So we've kind of got it narrowed down. Are you ready for your 24 hours?
Ready is always a thing. See, I've got this. I was hoping to have this done. And then I discovered that there's something very difficult about making something like this. And the very difficult thing is that you've got this shape here. And I want to dye this thing a different color than the rest of it, right? Because that just makes sense. I could just have it where it's just I leave the eyes black because I already colored the eyes black, and then just do it as like a leather look and do it all one color. But the that I think is less cool than like dyeing it. I'm hoping to do like a pink and a blue. So like pink for the, like a pinky purple for the sort of the Cthulhu there, and then a blue for the rest of it. The problem is that I need to figure out a way to mask it. So the solution I'm hoping might be the cricket. So I'm going to try to do this with the cricket. And that's a whole experiment. But yeah, basically I'm just going to have to see if I can make that function. So we'll see. It's an experiment and a half.
I have the utmost faith in you, my friend. You will absolutely pull this off.
I don't. So yeah, that's I mean, I appreciate the faith, but at the end of the day, it's like, we'll have
What
to
else am I going to
see.
say? What am I going to say? What am I going to say? Am I
That's fair.
feelings?
Rob's like, you're going to screw this up, right? And it's like,
Yeah, I'm not going to say that. You're about to start a 24-hour live stream. Why am I going to say that? Why would I give that negativity? I'm not going to throw that in this mix.
So
It's a terrible
here's the
idea.
other really fun part is that and people are saying the cricket and a small brush. I'm going to be using the airbrush. So I'm going to very carefully, because the other alternative is to put tape on the thing and then cut the tape out, but that'll be a project. Here's the other thing I've discovered: the extra life that is going on here in Edmonton. They're doing 12 o'clock to 12 o'clock, but noon to noon. So they're going to start after I've already been going for a while. And I'm wondering if I'm crazy enough to finish at midnight, sleep for 8 hours, and then try to see if they'll let me pop in. And somebody just knows there's a donation from Friday Night Frenzy.
Where? I didn't see that one yet.
It's showing up. I've got a thing that when I'm on my stream, it'll have a like an overlay.
Yep.
So that's
I
gonna.
see $100 from Friday Night Frenzy. That's a great one. Paladin
Yep.
Phil, I see you. You got a few minutes. I'm not gonna. Trust me. The mods have taken down. We have taken down who the next place is. So, just let me know. Let's do this. Let's do one more pen, then we'll get to, let's do the bracelets before we get to the Brian Steele coming in with Brian Steele in the way only Brian Steele does.
Ooh, what's Brian Steele up to?
Oh, Young Thug pled.
I saw that. I actually think his defense lawyer is either an idiot or the most brilliant person I've ever encountered, and it's really hard to tell which.
I think it was. I think Young Thug took it away from the defense lawyer's call.
It was a ballsy move, 100%. Because
I don't think it was his call. I think Young Thug took it. I think it was his.
It really ballsy move. I would have been super nervous if I was his defense lawyer. I got to tell you that.
Well, you should have seen him rocking back and forth during the hour recitation that Adrian Love gave as to why the judge should impose a 45-year sentence.
That is why I would have been super nervous, because I could have seen the judge doing it. I mean, the problem with taking a guilty plea where you've got a situation like this where it's because I mean the big thing they've got is what is it? They've got like all of this badness in terms of what's gone down in their case. And so the big problem is that the judge could say, well, okay, cool, but at the end of the day, like, we're just using that against you, right? We're just like, now you get to go to jail for the full time. And I'm like, that would suck. So,
yep,
it's a
It was a move.
whole, it was a ballsy move, and and I'm just going, that could have so worked out poorly for him.
Could have been terrible. All right, we're going to start the bidding on the bracelets. We're going to go for 5 minutes on this one too. So these again were made by Mischiefs. I say Mischiefs because I think the minis contributed to at least one of these. I think the one with the really bulky knot was one of the minis. But these bracelets, they started like $5. So no, there's no super chats, Krista. Krista, I turned off super chats. There's a QR code that's above my head though. The QR code will take you to donate at Ian Runkle's charity stream. So we're not doing super chats this evening. We're just donating 100% to the charity stream.
It's funny because sometimes people
I
get
set a
upset.
goal. By the way, I set a goal for chat. The goal I set for chat was $15,000. Paladin
Nice.
Phil, I saw the auction went through. Paladin Phil, you win the pen, my friend. Please email me the contact information to where I can send that glorious pen. lawandlumber@gmail.com. Please. If you can't click on a QR code, there's a link pinned at the top of the chat. So yes, you can. There's a link at the top of the chat. Well, you can click that and donate as well. But we're going to start the bidding on the bracelets at $5. I don't know if anyone's bid yet, but the bracelets are fun. Set of 3 of them. They all match. They're beautiful. It's for charity. You know, it's all the things. Mischief Manager made them with the help of many Mischiefs. Family and
You know, like there's just never going to be, another opportunity to get stuff that like the mini Mischiefs, or if there is, it might be next year that they, helped out with, or that Mischief Manager helped out with. So these are unique. These are, and there's a question of, are they bidding for all 3 bracelets or just one at a time?
Ms. Pete, I saw your donation. I'm going to credit. Ms. Pete donated $1,800. So
Whoa.
I feel like I have to credit that $1,800 to the next pen. But the bracelets right now, wait, who said bidding is at $250? $250. Honey, are you bidding $250 on the bracelets? Oh shit. Okay. Never mind. All right. I thought the bidding was at 50, but the bidding is apparently at 250. And XCDA bid $300 for them. Oh, Bauer said 250. XCDA said 300. So 300 is the high bid, apparently. 300 for the bracelets. 3 bracelets. Three bracelets, 3 people. Mini Mischief 1, Mini Mischief 2, and Mischief Manager. Oh, R. Bauer. R. Bauer takes the lead. $600 bid for the bracelets.
Dang.
It's going till 12:35. 12:35. So wow. CDA was 650. Y'all are just donating to charity right now. This is just R. Bauer and XCDA are in a bidding war. They're in a bidding war right now. It's not auctioneer school. They're in a bidding war. They are back and forth, neck and neck. XCDA is in at $800. $800 is the high bid. $800 going for another minute. We're
Whoa.
going for another minute on this one for 3 bracelets made by the minis. 3 bracelets. I set a goal for $15,000. That's going to be surpassed in about 2.2 seconds. Bracelets at $900 from R. Bauer. R. Bauer, $900. I will tell you this: Mini Mischief number 1 is going to shit her pants. I don't know, like, if because she loves making these bracelets, she will shit her pants if she learns that these things go for $1,000. $1,000 for bracelets that were made by 3 individuals with love and care and for no other purpose than to get donations to charity. So if I tell this girl that that these bracelets sold for $1,000, they're gonna die. So I'm gonna go ahead
Just
and give
make sure
30
you let
seconds.
them know that like part of that is charity, because they might have a hard time selling that, at the mall, etc., for the same rate. Although I hope that would be awesome.
This is yeah, it's for charity. They're not, no. Mini Mischief 1, you will not get $1,000 if you make these things. Yeah, no, you Mini Mischief 1. If you decide that you are going to leave this house and try to sell bracelets for a living, thinking that you can sell each one of these bracelets for $1,000, let's have a conversation about economics, okay? Because this is for charity. So I very much appreciate it. And we've got it going once in the chat. We're going to do a going twice in the chat. And I think 1,000 might be the high bid. And I'm going to go ahead and say.
Also, Rob.
Yes.
Have you sent your details off to David for your character?
No.
Well, that's something that's got to happen.
I should do that before I go to bed.
Yeah, I mean, he should. So far, it looks like we've got details from me and from Hogue, which doesn't surprise me. Should we tell people who the Twitter DM thread? So it's not going to be Lawyers and Dragons as in a continuation of the campaign, but it is going to be a role-playing game one-shot, just for the folks who are sort of wondering. And we've got a special guest as well. That is Natalie.
Oh, we do. Oh, look at that.
And it is going to be Halloween Christmas themed.
I just saw Clips and Vixen's Halloween costume that she sent on Twitter. Looks phenomenal. Dressed as looks like a witch with actually just straight throwback to Hocus Pocus. The book that she has is the leather book from Hocus Pocus. Phenomenal.
Awesome.
I'm just sending a note to David. Will reply as soon as stream concludes. Just that's there to remind me. Okay. So XCDA was the high bidder on the bracelets. I think, Ian, let me see here. And Mrs. Pete, I'm keeping your bid. I don't know if I even want to. What do you think? Mrs. Pete had an $1,800 bid on the first bullet pen. And do I have a third one of these small ones?
Did I say what time the game was going to happen? It's going to be 8 Eastern, 10 Eastern.
10 Eastern, 8 Mountain.
Yep. Got to make sure I sent the right time to Natalie now that I'm thinking about it.
Okay, Mrs. Pete. Here, Mrs. Pete. It's not, I see this motion to let Mrs. Pete choose a pen. That's what I'm going to do. I'm going to give her the next one. The next one that I had up that I think she's going to like. I do. I very much think she's going to like this one.
That's a tremendous donation. So 100%.
It was a remarkable, and I want to celebrate it. So I'm going to pull that one down and I'm going to present Mrs. Pete.
Gonna ask the chat as well for there might be somebody who's better at this than I am.
Yeah.
When
Ms.
you've
Pete,
got a
is
moment.
that one okay? Yep.
Oh yeah.
Is that one okay with you? Mrs. Pete, you just gotta let me know.
That is a beautiful pen. So that's like a swirly sort of pearlescent acrylic.
Swirly pearlescent acrylic, and then
It's a pearl handled pearl handled
yeah.
sort of gun pen. I love it.
Hyper Peach, yeah, we're going to YSL in two as soon as I can get confirmation from Mrs. Pete this is okay. She donated the $1,800, even though she was not the high bidder because we had closed the bidding, but I want to make sure that this is okay with her because I'm gonna be happy to send that to Mrs. Pete.
She says, yes, give me email again.
Okay, lawandlumber@gmail.com. LAWANDLUMBER@gmail.com. Send me your address and I'll mail it to you. Okay. Thank you for the $1,800 donation. $1,800. So right now, between the two pens and the bracelets, we've got what, 1,388, 1,800, and another 1,000. So $4,180. So thank you guys. You guys, by the way, you guys have now ticked us up over. Let's do this. You've now ticked us over this milestone that I set for the chat for basically for the conclusion of this FNF stream, $15,000. You guys have done it.
Nice.
So Ian
that is amazing.
Beginning his live stream with a head start of $15,000.
That is amazing. Can I borrow the main screen for a second to ask for a favor from the chat? Because there's probably somebody who's better at this than I am. So I have a scan of my leather journal, and I'm trying to get a shape. I need to get the outline of this octopus. And the reason why I need to get the outline of it is so that I can cut out from Cricut stencil material to make a mask to sort of so I can airbrush it. There's got to be a better way than what I'm up to here with like trying to erase everything that's not octopus to then do like edge detection on it. So if somebody is able to, I don't know if somebody's got a better graphics editors for it, but if they're willing to volunteer, then that'd be amazing. So somebody says you're going to need a bigger goal next year. What we're going to do is when we hit the goal, we're going to add more goal.
This is a solid move. I think this idea is great.
Yeah.
White paper, pencil over top of it.
But then I still need to take that pencil over top of it and make get it into a line outline.
Yeah, but I think it'll be easier for the program to detect white versus black as opposed to
true. As opposed to leather versus leather.
Yep.
So yeah,
Trisha,
I can send
Trisha
somebody.
is also asking. She's offering her services too.
Okay. Trisha, do I have your email? I can send you the image there. Oh, I see somebody donated and said watching Law and Lumber. So it reads me the little text. So
that's really fun.
Let's just see here.
Send that email. I'm going to get YSL back up. Good?
Absolutely.
Okay. Let's see. Present screen. I feel like we should swoop to this. We're going to swoop to this. Swoop.
Statements made by the prosecutor we vehemently disagree with. The prosecutor misstated many pieces of evidence and then.
Oh, shit. That's his first line?
Apparently.
Go Brian Steele. First line. Prosecution misstated evidence. Love it.
Took liberty that is the state's theory. Mr. Williams has tendered a nolo contendere plea to the RICO conspiracy count. And in that count, there are several overt acts. And the first one, Your Honor, deals with a traffic stop. It's on September 9th of 2013. And I won't go through every one because it might take a long time, but just for completeness for this, as court knows, Mr. Williams is driving a car. There is a dash cam video of the stop. The officer testified at the trial 11 years later. The case was, a gun was found under the passenger seat. Mr. Williams is not tied to the gun. He's not convicted of that. And the dash cam video that the officer said would have picked up sound as well as definitely video was never turned over to us, supposedly lost, could not explain the loss. The armed robbery in another overt act of Mr. Dodson, D-O-D-S-O-N, has the following information. The state only, because we haven't called witnesses yet. So the state put up a man who said nothing except, I don't recall. And then they put in his prior recorded jail calls. That man was taken, his name is Mr. Bean, B-E-A-N. He was taken to Grady Hospital and he was spoken with by a detective. The state vehemently accused me of lying to the jury, that the man never went, Mr. Bean was never taken to Grady Hospital, and that somehow I planted on him to say something on a recording where he said, the reason I implicated Jeffrey Williams is because the police told me that it would be easier for me. Then I had to go through the CAD reports and show that Mr. Bean was in fact taken to Grady Hospital, and Mr. Bean on recording told Detective Quinn.
Oh, so he's swinging at the prosecution for various reasons. Like they
He's swinging
threw
hard.
him under the bus. Okay, I'm
And who,
in.
of course, told the truth. Yes, when I spoke to the detective previously, I did lie. Then what the state doesn't tell the jury is that there's another man in the car. He is shot at the scene. He's arrested. He pled guilty. His name is Fred Prethrow, P-R-E-T-H-O. And Mr. Prethrow is in the Georgia State Prison System, easy to find. And Mr. Prethrow was in Grady Hospital also, unfortunately suffering from a gunshot wound. And you can hear the medical equipment behind him. And Detective Williams came in and was recording the whole conversation and said how many people were in the car. And Mr. Prethrow names the people. Adrian Bean, who's the gentleman I just said, himself, and Walter Murphy. Are you sure they weren't a fourth person in the car? No, the three of us.
Sorry, I had to send something.
The state doesn't call that person. The state does call Detective Williams. So I wanted to ask and inquire on that.
Oh, come on. Ian, we were doing so well.
I think I might have, doomed you here.
That the state to obstruct, if that's obstruction.
All right, I'm going to pause this for a second. Come on.
Asked the predecessor court to prohibit me from getting into the fact of any conversation that would have impeached another witness. It's fine. Fred Prethrow is on my witness list as well as a detective, and I have the recordings. In addition to that, Walter Murphy gave a statement while in the hospital, and his statement is very interesting. It's two different police reports, signed the same date, which is September 11th of 2013. And on the first 7 lines of the police report, they're identical. Then all of a sudden, when it gets to on the right-hand police report, it says Mr. Murphy stated that there were 3 people, I believe, I have to go back, in the vehicle. On the other police report, it states Mr. Murphy stated there were 4 people. There's no reason that they should be different. They're both signed the same. The state doesn't call that officer at all. I tried to ask Mr. Murphy about it. The state objects, and the predecessor judge sustained the objection. Mr. Williams was not involved in the Mr. Dodson. Miss Bennett, that was Mother's Day, May 12, 2013. She reports allegedly an armed robbery. The detective who testified here and investigated stated he never took out arrest warrants from Mr. Williams. And he wrote in his police report, Miss Bennett is not truthful. That is the case that the state is talking about. The state then, there was Brady evidence that they don't turn over, and we find out about it in court. after they arrest Miss Bennett because they say she's not cooperating. And it comes out that she told the prosecution over and over again that this did not happen the way that she reported it, and she doesn't remember. As to Donovan Thomas, and Mr. Williams has nothing but empathy, sympathy, and sorrow. They were friends. It is a lie. What the prosecution put before this jury is a lie. What happened here is the prosecution comes up with a theory because they need a motive, they think. I know you don't need a motive in reality to prove a murder case or any other case, but they wanted a motive. So they made it where Mr. Williams and a gentleman named Rich Homie Kwan, his name is Mr. Lamar, he's a performer, and Mr. Williams and Mr. Lamar were close. There are public documents, recordings, Mr. Lamar being interviewed almost every year, and then he talks about his time with this band or a group called Rich Gang. And he says every year up to this past year, he, God forbid, died. We can't call him as a witness, how close he is to Mr. Williams. The state, though, made it in this case, or tried to make it, that Mr. Williams and Rich Homie Kwan are enemies because Rich Homie Kwan will not sign with a record label that has nothing to do with Mr. Williams. Mr. Williams doesn't sign that record label. That record label is owned by a gentleman named Brian Williams, also goes by Birdman, wildly successful. He started Drake's career. He started Mr. Dwayne Carter, performer known as Lil Wayne's career. He started Nicki Minaj's career, just fabulous, powerful person, well-respected in the industry. But the state wants it to be that Donovan Thomas interceded and would not let Rich Homie Kwan sign to Mr. Brian Birdman Williams. And that is the reason that Jeffrey Williams had a feud and killed Donovan Thomas. Your Honor, what the evidence would really show if we kept going to trial, and I could tell you that Mr. Adams and I never thought we'd be in front of this honorable court. We always thought it would go all the way through trial. Was the state is saying that Rich Homie Kwan and Jeffrey Williams don't speak since the fall, and they have a bad relationship the fall of 2014. We would have shown, and we served on the state, December 15, 2014, Jeffrey Williams in a private plane with Mr. Lamar or Rich Homie Kwan, and they are high-fiving and laughing with each other. That is on audio video. There's a man who the state hasn't called yet, Mr. Martinez Arnold, also known as Duke. It's on the state's witness list. He's represented by the Honorable Ashley Merchant. He's on that plane as well. He would have identified the item, and he would have testified that Mr. Williams and Mr. Lamar were very close in December 2014. Then on December 29th of 2014, Mr. Williams, Mr. Rich Homie Kwan, Mr. Arnold, others were at Brian Williams' home in Miami, Florida. There was a posting by Mr. Lamar, Rich Homie Kwan, and a picture of Mr. Arnold and Mr. Lamar, and they said, Mr. Lamar says, "This is my number one man, Duke," or something to that effect. We would have put that into evidence. In addition to that, Your Honor, on December 8th, 2 days before Mr. Thomas, God forbid, was killed, Mr. Williams is with Mr. Thomas, as well as Mr. Sledge and Brian Williams in Brian Williams' tour bus outside of a fabulous entertainer, artist, Mr. Clifford Harris, T.I.'s studio. And at that time, they were very close. But you also have the detective with the gang unit, Detective Underwood. I asked her within the last 2 weeks or 3 weeks, did you do any, and she was on the gang unit the entire time, including today. And I asked her, do you have any evidence about Mr. Williams and Mr. Thomas being close friends? And she said, yes, of course I knew that. I said, how about in January of 2015, close to the time of Mr. Thomas's death? She said, yes, they were close friends. Mr. Michael Sprinkle, he's a deputy district attorney in the Fulton County DA's office. He has a recording with Mr. Treadwell. You've heard the name O.G. Bentley. And in that,
he's just gonna light this whole fucking case on fire.
Mm-hmm. Also, we are, in terms of the Canadian rankings, currently sitting at number 3. We are a little over $1,000 behind Animathon. And
on its head of the state. The
Team Beanox is at 22,000.
Catherine Godecki, this is a good question. Yes. The answer is yes. They are proffering the entire case at this point. They are offering to the judge what they contend the evidence would have proven, because right now we are bypassing all the rest of the trial and going straight to sentencing. So they are saying, this is what our evidence would have proven. Judge, this is what you've heard so far. Please make an adjudication based on what you believe the evidence would have borne out at trial. That's what this is. This is argument. This is lawyer versus lawyer. This is who has the more compelling narrative. And I can tell you who's fucking winning right now, Brian Steele. I keep singing this song in my head. It's Alicia Keys. This case is on fire. Brian Steele lit it on fire. Just fucking roast it. This is just, he's just going point for point. Let me tell you how bad this fucking case is.
Fact that the state has put in Mr. Williams' lyrics are offensive. Mr. Williams has tens of thousands of recordings. On our witness list, we are bringing in all of his people, his recording artists, his engineers, his managers, his record label, and an expert, the Honorable Dr. Eric Nielsen, to talk about how Mr. Williams creates his music. His music is then changed around and merged. Mr. Williams, some of the lyrics you just heard are not even uttered by Mr. Williams. The state has no idea when these lyrics were made. Some of them were made before the shooting of Donovan Thomas that the state is saying this applies to the Donovan Thomas killing with the Tahoe. They are so far afield of where we need to be when we are trying to, God forbid, take somebody's liberty, Your Honor. The state is talking about things like F the judge and I rep my life for real. That's not even said by Mr. Williams, but they don't care to find out. They are on a tunnel vision to try to convict a man who should not be convicted. The statement about I never killed nobody, but I got something to do with that body. If the state just bothered to talk with anybody, that is a Nicki Minaj song with Jeffrey Williams. It is written by Nicki Minaj. That is on the text messages I gave, not the text message, the Instagram or Twitter rather, that I gave to the state. That is out well up before this, but the state doesn't care. This was out in 2015 or 16 or 17 or 18, I can't remember, I think 18, where Mr. Williams was asked who wrote anybody, and his response is anybody was written by Nicki Minaj, and it was. But it was really written and sung. It's a takeoff of a song by Tupac. There's a song that it parallels, which is an inspiration. But here we are with the state. Also, I never killed nobody, but I got something to do with the body. The next line comes up is it's a truancy body. The state can't explain that, so they just conveniently leave it. Your Honor, there were wiretaps on this case. Mr. Williams, it was going to come out, there was an application to wiretap his phone. The state never presented to a judge. That speaks volumes. The leader of the YSL criminal street gang, who's been involved from 2012 until his arrest, and even according to the state, while we sit here, they never even tried to wiretap his phone. It might have been because they don't really know what his phone number is. So all these communications you're being told about with Mr. Huey, I'm not so sure the state could have gotten anybody to say that's Mr. Williams' phone. This is how the trial has gone for us. But we sit here for almost 2 years since we did our jury selection initiation.
Client is now feeling it. Client's like bobbing around going, yeah, exactly. Shit. Did I do the wrong thing? I should have just let you roll with it. I don't hate this deal. Not the deal. I don't hate the plea that he gets, or not plea. I don't hate the sentence he gets. The sentence he gets is I mean, honestly, a little bit of luck, a little bit of good. But shit, I would not have rolled this dice. I would not have rolled this dice. This was wild. This is wild. All right, Mr. Steele, keep torching.
On January 4th, 2023. Mr. Williams has been sitting in a jail since May 9th, 2022. This is 2.5 years waiting for the conclusion of the state's case and a verdict from the jury. And that's why he is tendering this plea. I'm telling the court this, and the court knows when you came out the first time, it's very hard for Mr. Williams. I am not supportive of what we're doing right now. I'm not against it. But I told Mr. Williams, you okay with me saying yes? I told Mr. Williams that.
Yes, yes, all the yes, every single ounce of yes that I can muster for what he just said. He was like, I told the court, and he looks at his client, are you okay with me saying this? The client says, yes, you're okay. I told the court, yes. Can we have 1 million Brian Steeles? Just,
I mean, the thing is they have been fighting this thing uphill.
yeah. This is wild. He looks at his client and says, are you okay with me saying this shit out loud? And the client's like, yeah, Let it flame. Just burn it.
I think we're winning the trial and we should go to verdict. But he told me I can't wait another 3 months if there is any possibility I could go home because I have children that are hurting. I have things to do, and he has some medical issues that he would like to tend to. He eats out of a bag, Your Honor. He eats processed food only. He gained 75 pounds during trial. He's lost it since. But it is hard. You know, for me, it's only 3 more months. It's enjoyable, actually. I enjoy coming. It's not that enjoyable for Mr. Williams. He told me he wakes up. I said, he wakes up every day, and it's another day in HE blank blank. Your Honor, the state is talking about, in this case, they put in social media. This honorable court was not here, but the state put in that Mr. Williams, in the indictment, Mr. Williams put out a call for murder. He put $24 million murder for hire on a person's head. That is a lot of money, and that is awful. If they would have read the chat, the Instagram chat, Mr. Williams, right above it, there's a picture of a very well-known, very accomplished musical artist who actually had surgically implanted in his forehead a pink diamond worth $24 million that day. That's what Mr. Williams would talk about. That's the type of evidence that is coming from the state of Georgia in this case. It is wrong. This is all wrong. And I know we're pleading guilty, and I know we're...
I love this. I know we're pleading guilty, but that's not my fucking choice. I want to keep going to trial.
pleading nolo, and I know we're asking this honorable court for a certain sentence, and we'll get to it with the court's permission, but this is the type of evidence that there is. But it is holding this man.
Tanika has a request. Recap this trial, Ian. Recap.
That would be it's like a million days in, right?
We're on day 154. And those are trial days. Trial days. It's not possible. Niklas was here earlier, and he was basically saying there's been 50 motions for mistrial, 36 jury instructions given during the course of trial.
Then they never bothered to put in all of the chats. Why did it take me to read the chats? In addition to that, going back to Donovan Thomas, talk about Mr. Williams involved, the state did a geofence. A geofence tracks his devices. It doesn't have to be a phone. It could be an iPad. It could be any type of electronic device that targets and is used. You don't have to be on the phone. It's the contact. If he has an app open, it'll capture it. And the state targeted the McDonald's, where they keep saying that Mr. Williams met with people there. They targeted the barbershop where the killing occurred. And they targeted a third location, no, 2 locations. And it comes out, Mr. Williams' devices are not there. It's exculpatory. I don't get that information. I got that because I interviewed Lieutenant Crabtree, and the results can't be found, according to prosecution. I did a motion for that. They just can't find it. That is great evidence for Mr. Williams. It would have also shown clearly that when he does go down from his house after getting this call that I'll talk about from Demise McMullen, he's not with these other people. And the expert for the state, the FBI agent who does the telephone analysis, Mr. Williams' phone does not ping off the same tower as a Demise McMullen or a Mr. Copeland or a Mr. Garlington or whomever. The state of Georgia has misrepresented for 2 years in front of this jury. They have hidden evidence. They have violated Brady. They have falsely accused Mr. Williams.
Wow. You guys recognize that is not a statement that any attorney makes lightly, ever in court. Usually you will get a judge jumping down your throat if you even come close to an accusation like that.
It's one of those things where it's like, you're going to take a swing, you better not miss.
And he just lays the hammer. My God, it's openly says the state of Georgia has lied to you for the last 2 years. Fuck.
Your Honor, saying that Mr. Williams gets that call 7 minutes after, the state said 6, it was 7 minutes after the killing of Donovan Thomas from Demise McMullen. Mr. Williams was already out of his home. Mr. Demise McMullen's is calling Mr. Williams. He's not even there. He's going down to meet with Mr. Kelvin Treadwell, also known as O.G. Bentley. O.G. Bentley was supposed to go to Miami, Florida. They were talking about this deal. And Mr. Williams, that day, he was given another contract. Mr. Williams, by this time, he went from zero money. He is a multimillionaire at the time. He doesn't need the Cleveland Avenue drug deals for $15. He doesn't need the shootings. He wasn't even living in Atlanta since 2018, 19, 20, 21. He came back the very end of 21, 6 months, and he got arrested in May of 2022. In his house, Your Honor, we have everyone on the witness list. There are 12 people living at that house. Mr. Williams opens up any of a car that he has. He'll rent cars for people. Any home he has, he will allow people to live in hotels because people that he knows, unfortunately, are homeless. And he gives them all places to stay, cars to drive around. He is not involved in criminal activity. Mr. Williams just got back in our country. His passport shows it. Right before he was arrested on May 9th of 2022, there were other people in that house with the drugs and the guns. There are people whose the guns are in their names. They were going to come in court and claim the guns. Everybody else was doing as well, but Mr.
Nicolas was speaking on a panel with most of the defense attorneys earlier today. So Nicolas Stero had almost all the defense attorneys on his panel earlier today. How much the state spent on the case? The rough estimate was about $700,000 per month, which is about $12 million to date. There are 1.08 million residents in Fulton County. So this has now hit the pocketbook of every resident, just this trial.
Williams has entered a guilty plea. I'm not going back on that, but I just want you to know that this case is just wrong to do to somebody with no bond and to hold him hostage. He wants to, you may not do it. He's aware of that. He's aware of that. But the state offered him 15 years on probation, but they keep piling on these conditions. He just said, he made up his mind. He said, I'm just going to go with it. I got to get home. Judge may not let me home, but I'm not doing these conditions and admit that I'm the leader and I'm involved in the killing, and my music just promoted everybody to do it. He's not going to do that. So he did not do that. And that's how we wound up here. The state, the night of the killing, people came to Mr. Williams' home. The state tells the court, he said, lay low. What they don't tell you is right after that, he gave money to Mr.
Oh, come on.
Sledge, who said, they're going to kill me. They think I did it. And Mr. Williams said, if you had anything to do with it, I don't want to be with you. And Mr. Sledge said, I just need a hotel room with my children and my bride or my significant other to get to. And Mr. Williams said, be safe, lay low. That's the lay low. In addition to that, Mr. Williams told Mr. Copeland's with the police. Hours after the killing of Mr. Donovan Thomas, Mr. Copeland goes to the police department. Mr. Williams is the person who told him to go. Mr. Copeland said, what do I do? They're shooting at my house, at my family's house, at my significant other's mother's house. And Mr. Williams said, if you had anything to do with the murder, get out of here. Mr. Copeland denied it. Mr. Williams said, then go tell the police. Mr. Copeland said, you want me to go to the police? Mr. Williams said, if you had nothing to do with it, they think you did it, go to the police. In addition to that, Mr. Copeland said, well, I'm going to retaliate. Mr. Williams told him, don't do that. Let 12 handle. That's on recordings. That is on recordings on January 11th of 2015 with Detective
12 is cops. Let cops handle.
Thorpe. Your Honor, as far as Dwayne Carter, a performer known as Lil Wayne, Mr. Williams had no conflict with him. They are friends. We were presenting evidence that right before this shooting of the tour bus is April 26th of 2015. Mr. Williams is performing in New Orleans area. Then that's the area where it's Holly Grove, where Mr. Carter, or Lil Wayne, a performer known as Lil Wayne, comes from. And in order to drum up popularity and interest, people get on the internet and they start what's called rap battles. Arguments, feuds. That's what happened here. And you would have heard testimony from Mr. Williams' management that they said Start a rap battle. It'll be better for your career. Mr. Dwayne Carter is aware of that. Mr. Dwayne Carter's interviewed. The state's aware of this. He has interviews after this. Are you mad? What's the real deal with Jeffrey Williams? He states, no, he's great with me. He brought popularity to me. He loves me. He idolizes me, and I love working with him. They did an album together. In 2014, they're in the studio together, making music together. It is all made up that Mr. Williams is involved. Mr. Williams gives a statement. The state refuses to put it in and then stop me, the previous judge, from cross-examining the detective. His name is Racy. He met with Mr. Williams in the DeKalb County Jail on the 15th day of July 2015. Mr. Williams is arrested that day. And there's a long interview. And Mr. Williams waives his right to counsel. He tells them, I'm his lawyer. They say, you don't want to speak to us? You don't have to. He said, well, I'll speak with you. And they asked Mr. Williams these questions. What about Lil Wayne shooting? He said, it was outrageous. I love it.
All right. I have to fast forward a bit because it looks like Willie Steele just keeps going. I appreciate it. I love it. But holy crap, you flamed the case. It's on fire. It's dead.
Mr. Williams found about. He went to the stores and he repaid all that. He didn't steal anything. He doesn't need to steal anything. Your Honor, Mr. Williams stands with Elton John. Elton John called Mr. Williams the next coming of John Lennon. Mr. Williams is unbelievable talent. He's not just a rap artist. In fact, when he's interviewed in 2017, he gives a statement and he says, I had to learn rap. He grew up in a house learning other forms of music. He likes all music, but rap hit in his community, and his community raised him. Or at any lawful employment, touring, studio, which is violation, which is.
All right, I didn't mean to interrupt you.
No, it's fine. It wants it, and he embraces it. But to me, this is a wrongful prosecution. This is outrageous.
All right, so you're pleading guilty.
Judge is like, you're pleading guilty. Let's get to the sentencing, please. Like, you've made your point. The case is on fire. You have thrown it in the trash and lit it on fire after throwing gasoline on it. Let's go.
Or your client is pleading guilty to counts 57 through.
So, the post office absolutely hates me.
What do they do now?
Well, I walked in and I was like, I need to check my P.O. box. And they were like, oh, by the way, they're like, oh, you have 6 packages. And I was like, could be. And they're like, no, 8 packages. And I'm like, okay. And they're like, no, you have lots of packages. So, yeah, I've got, I'm just opening them now. So Trisha Lynn sent some lovely little sort of keychain charms here. I got to keep everything organized. But yeah, this is, I'm sort of like, I'm going to be buried in things. But I'm trying to open them and yeah.
But you got the things.
I got the things. I also got the their annoyance with from the post office. So yeah, they were not happy.
I just looked at
Trisha Lynn says they're zipper pulls or keychains, whatever you want to use them for. So
Ian, I need help. What job do I want to do? This David's question is hard.
What was the question there?
Never mind. David's question in the Twitter thing.
Oh, yes, that question. Did you see my answer?
You're an asshole.
Why am I an asshole?
I just think it's a great answer. I can't come up with something like that. It's a great answer.
It's hilarious, but
yeah, it's bullshit.
Oh, come on. Chat.
Fine.
We got Torin's braided belt.
Oh, very cool.
So that came through in the in ideal timing.
Yes. Wait, no.
Chat.
This is
Rob
the best.
needs a funny job.
Nope. Got it.
You got it?
Look down below.
Agent of Chaos. Is that your job title?
It is now.
Nice.
No. This is the best. Oh, wait, hang on. Can I do this? There's only there's 2,000 people watching. What would the Agent of Chaos utilize as a tool to enact their chaos? Blunderbuss?
A blunderbuss is a pretty good choice.
But it shoots toys.
That's even or candy.
Okay, that shoots either toys or candy, depending on the circumstance.
Danielle S.,
And
we're getting
always the wrong choice
for the
or
circumstances.
circumstance required. Like if it needs to shoot toys, it's going to shoot
Candy.
candy. All right. Done.
Yeah, this isn't exactly Lawyers and Dragons in the sense that Lawyers and Dragons is like that specific campaign, but it is a tabletop role-playing one-shot. Yeah.
All right. Getting back to Thug. Ready?
I also like Al Fliggins' suggestion of a Halligan bar.
I don't know what that is. The blunderbuss is something that I can easily process in my Neanderthal brain of what it does.
I mean,
And
Halligan bar is basically you could use it sort of as a beating tool, but it's a very particularly shaped entry tool. It's used by firefighters to break into houses. So if you if your house is on fire and they need in, and you are you're not available to open the door, they'll Halligan bar it, and a Halligan bar will get your door open.
Yeah. No, I just want to shoot candy and or toys. This is a
Fair.
phenomenal idea. I like this. Okay. Good.
Yep.
62.
It's all true.
Do you
Yes, there's a
concede
factual
there's a
basis.
factual basis
I can
for those
see.
counts?
Yes, I can see that.
Okay. All right, I didn't mean to interrupt you.
No, it's fine. And Your Honor, I'll answer any of your questions, but the point I'm trying to make is 45 years to serve 25 years in prison when just this morning, it was a probationary offer. It was a probationary offer. The state knows, but they want to control. They have this theory of music, and they want to stop Mr. Williams from making music, from entertaining, just stop his life. That's just not right. And it's wrong of the district attorney in Fulton County to do that. If they offer probation, then he's not a 45 to serve 25 years in custody type of person, and he's certainly not the person that the state has stated in front of the court. What we're asking, Your Honor, on count one, which is the RICO count, to accept the nolo contendere plea. Please sentence Mr. Williams to 20 years to serve 5 years in prison commuted to time served. Mr. Williams has served, as I said, 22.5 years. On count 56, Your Honor.
So they want 20 commuted to 5. So they want time served. Wait, 20 commuted to 5. He's only served 2.5. So was he actually proposing time? No.
On 56, Your Honor. That's the leadership of a gang. Nolo plea, 20 years to serve 5 years, commuted to time served, consecutive to all other counts.
Got it.
On count 57, which is a gang count, Your Honor, not a leader, guilty plea, 20 years to serve 5 years, commuted to time served, concurrent with count 1.
Okay.
With regard to count 58, which is possession of, I believe it is marijuana with intent to distribute, 10-year sentence on probation, concurrent with count 1. On count 59, which is violation of Georgia Controlled Substance Act, possession of codeine with intent to distribute, 5 years on probation, concurrent with count 1. On count 59, Your Honor, which is violation Georgia Controlled Substance Act, possession of cocaine, 3 years on probation, concurrent with count 1. Count 61, 5 years of probation. It's a firearm count, consecutive to the other counts, consecutive to before count 56. And then count 62, 10 years to serve community time served. That should be a total sentence, Your Honor, that we are respectfully requesting the court to consider. I believe it's 45 years to serve 5 years in prison, community time served, 40 years on probation, credit for the time already served and community time served. As I said, after 3 years of probation, the probation becomes non-reporting, and after successful completion of 10 years on probation, the balance of the sentence be terminated. Mr.
Can
Williams,
I just say how insane
asked
it
the
is
court
that we have
for house arrest for
Go ahead.
you guys have 10-year probation terms? That's nuts.
Oh, this is I think he gets 15.
Yeah, you know what the max term of probation is in Canada?
What?
2 years. More than 2 years is an unlawful sentence for probation.
Yeah, but what's the trade-off? Do you trade that off for incarceration? Like
Usually,
for
yep.
example,
Although,
and that's what I'm saying is like the trade-off.
but here's
is,
the other thing is Canadian sentences are so much less than US sentences. If I was like dealing with these kinds, well, I mean, a lot of the things he's accused of aren't even crimes, but here, but if he was charged in Canada, there wouldn't be like 40 years on the table. It would be like, yeah, he might be looking at like, 5, 6, maybe like, well, I mean, there wasn't like a murder charge or anything like that, right? It was all just like you're in a, yeah. So
for my take on this, the Brady violations by the state would have been enough to get this dismissed with prejudice, as to at least some of these defendants.
Oh, I mean, this should have been yeeted into this. If I was the judge on this one, I can tell you I would have had some opinions. And so I might have said, there are some rare cases, but they have happened here in Canada where the judge has said, I'm refusing to take your plea on the basis that I am instead just like dismissing the charges. And yeah,
this one is the prosecution fucked up so damn much.
I might be inclined to say I'm refusing your plea here because honestly, it's not in the interests of justice. It's not, and the appropriate thing is charges go away. Can I also share just what I pulled out of a thing right now?
That's fair.
This has so many levels to it. First, pigeon.
Business.
Pigeon.
You said
second, the pigeon's briefcase.
Yes.
And at first I was
backpack. It's supposed to be a backpack.
Well, I mean, I had backpack and non-backpack versions, but there's a pigeon briefcase. And at first I was like, oh, well, that's pretty cool. And then I noticed something. The briefcase opens up.
Does it have drugs?
No, well, it might be drugs. There's a little package, but there's also like file 1, file 2, file 3.
Wait, hang on. Chad is saying in big and hang on, give me 1 second. There.
So here's the pigeon.
Drugs.
It's an awesome pigeon.
Wait,
here's the briefcase.
Wait, stop. I gotta pause you. Yep. There was a story that Ian covered about a year and a half ago where people were throwing pigeons over the wall of a prison with backpacks on the pigeons that had drugs in them. That's it. People were throwing pigeons over the wall of a jail, and the pigeons had backpacks that had drugs. So all of this began this whole pigeons with backpacks and drugs because it was a story that actually had real life connotations. And then Ian covered a case that was so bullshit and such asinine, Janet Braun, that the chat created a moniker called Pigeon Business, which is pigeon shit. So Pigeon
it's
Business
from the
was,
old line of
such bad. Yeah.
It's from the old line of like, don't play chess with a pigeon because the pigeon will just crap all over the board and declare itself the winner. And so what I was saying is that it can be hard to tell the difference between somebody who is like engaging in some sort of brilliant tactic that you don't understand versus somebody who's just shitting everywhere. And so it's, it's like, is this some brilliant tactic that I don't get, or is this just pigeon business? And so chat was like, pigeon business. This is a whole thing. So,
but the pigeon has to have a backpack because the pigeon backpacks carry meth.
File 1, file 2, file 3. Oh, it's even better. A bag of seed. This is amazing. This is so amazing. This little, we've got the pigeon and the briefcase. It is so, oh, and I'm being told I have to open the files.
There's something in the files?
There's so many layers.
There's a fucking pleading that says comes
There's
now.
a pleading that says comes now is, wow, there's like, this whole thing is just like an onion. There's all sorts of layers to it. Wow. This is amazing.
Oh, that's really great. That makes me so happy.
I probably can't bid on these things myself.
No, I want to bid on the damn thing. Don't do that. I'm going to bid on the fucking thing. I want the pigeon business with the backpack. Give me
that. Is super cool. That is amazing.
Okay. That makes me very happy. I'm glad that you shared that, Ian. That makes me very, very, very happy.
I was just like, what?
Why did Ian go away? No,
I'm just reaching for another package, and I'm trying not to show addresses on the screen.
Yeah, don't do that. Hang on. We're zooming the plea.
I think the only address that you might have been able to see was my P.O. box.
Good.
But house arrest specifically defined that Mr. Williams will be in his home or at any lawful employment, touring, studio, performance, business meetings, and the like. Wear an ankle monitor for the first year and pay the costs of same. And the company must be approved by probation department. And the ankle monitors are insanely expensive, by the way. Mr. Williams cannot possess a firearm, but he can be around licensed security who are armed or other persons.
It does make for an issue of two tiers of justice, because if you can't afford the ankle monitor, then you can't be put on ankle monitoring. So yeah. And I got a whole bunch of stickers here. So, and a whole bunch of things, and there are a whole bunch of little clay figures. This is from Lori Lenny, who sent Bear.
Bear. So you have 33 minutes till your stream begins.
Oh, crud.
So
I'm going to
finish this, and I have to set up a redirect for yours. But before I do that,
I will stop interfering.
Well, there are 3,239 votes on a poll that I have posted at the top of the chat. The poll at the top of the chat, Ian, I'm going to draw your attention to this.
Nope.
What is the ideal temperature inside of a home? Sub 68 degrees, 20 degrees Celsius.
20 to 21.
Between 68 and 70 degrees, which is 20 to 21. Or between 71 and 74 degrees, which is between 21.67 and 23.33 degrees Celsius.
No, that's an oven.
Or above 74 degrees, which is above 23.33 degrees Celsius. So please,
isn't that like bake at that temperature for however many minutes?
Oh, thank you. Thank you. I am inclined to agree, but I am allowing people to continue voting on this until the end of the stream. Please do vote. We do. I do want to see the end of that poll. And let's continue with this because we're going to get to the end of it.
I voted.
Good. And then we're going to redirect to Ian's stream. And while we're playing this bit, I'm going to go ahead and set up that redirect to the live stream for Ian.
Who are lawfully carrying a firearm with a license. And that would be knowingly for Mr. Williams. Mr. Williams can transfer probation outside the state of Georgia. He has residences in the state of California. He has studios in the state of California. Mr. Williams be allowed to travel throughout our country and the world for lawful work-related industries. Mr. Williams wants to perform.
Yeah, who else
He's going
gets
to do
to
this
travel
anyway, Your Honor,
around
but
the
we may
world
close
for
sentence.
lawful work?
At
You
least
know, you don't get to do
one-
that if you work at, like, you know, Waffle House.
Yeah. But the freedom to move freely about the country.
Well, the thing is
You
they
need-
would otherwise have restrictions saying you can't travel.
Correct.
Except he
But
gets,
for someone that has as their means of providing income. And then there's another part of this where part of one of the conditions, I don't know if Steele proposes it, or the judge orders it, but is that some of the concerts are actually to give back and some of the proceeds are donated. So let's.
Sorry, my phone is telling me I got to
year
wake up to be ready
at a
to
venue,
start streaming.
if they'll have him holding 10,000 people, if that is workable for the venue and Mr. Williams' management, and he is going to donate all of the profits that he makes to a 501c3 charity.
Yeah.
Mr. Williams wants to pledge $100,000 for the next 3 years to the Fulton County Sheriff's Office if they will hold.
Pledge or donate? Pledge or donate.
He's probably gonna give the fucking money. If it's a term of his probation, he's forking up the cash.
And all of this is stuff that is just not available if you are, you know, if you're not young Thug.
That's correct.
Can I share just something that I have just discovered about Gmail?
Briefly.
Gmail apparently has this limit where it will stop showing you, you know how it nests all of the emails from one person together?
Yes.
Apparently the nesting for that is limited to 100 emails, and then it starts out on another one. And the way I know this is that I have in my email a thing saying, you have 100 emails from Extra Life saying, congrats, you received an Extra Life donation. And then I have a second thing where it's going, and now you are adding more, and now there's more donations. So it's the donations have caused a Gmail rollover.
Very nice.
So-
That's a good accomplishment. We're speaking of donations, we're at $15,315.
Awesome. That is amazing.
Harry Burrell. If there was ever a t-shirt that needed to be printed, not going to derail you anymore. Can I share something?
My bad.
35 minutes. I'm not going to derail you anymore. Can I share something?
Firearm buyback to buy back firearms that are not supposed to be on our streets. Mr. Williams does not wish to go near the Cleveland Avenue area, not to insult that area at all, but it is just not a good idea under this circumstance. And he can drive on the highway, but otherwise not come within 1 mile of the area that we call Cleveland Avenue, and we can give the exact dimensions of that area. Mr. Williams must perform 100 hours of community service per year for the next 3 years as designated by probation department. Mr. Williams can associate, and this was agreed to previously, with people who are convicted felon or alleged gang members solely for lawful purpose of making music.
I see Ms. Love shaking her head, and I think it's fair to establish that until the entirety of the negotiations were agreed to, it was all up in the air.
Sure.
That may have been something y'all had already hammered out, but it's not anything they're bound to.
Absolutely.
Fair. Okay.
I agree with that. Mr. Williams can have no contact with any of the supposed victims.
Very rarely will you have two attorneys that actually are in court that actually fucking hate each other. These two fucking hate each other. Like usually attorneys will, they will not care for each other. I actually get along with almost all the attorneys I litigate against. I have great working relationships with them, and it's like you don't like what I'm gonna say, but it's not personal. These two attorneys hate each other. Hate each other. They really don't like each other. And I can see why.
And there was an Exhibit A attached to the state's proposed plea agreement, negotiated plea agreement that was sent to you. So we adopt that Exhibit A, but we can give it to the court if you need those names. And Mr. Williams have no contact with any of the co-defendants in this indictment, with the exception of Mr. Quantavious Greer, that is his biological brother, as well as Mr. Sergio Kitchens. He's a phenomenal artist. He goes performer known as Gunna, Gunna. Mr. Williams and Mr. Kitchens are contractually obligated, and they frequently perform music together. Your Honor, any other conditions that the Honorable Court deems appropriate? I want to thank the court for all your time. Always, I want to thank Ms. Percifield for everything she has done. I want to thank Mr. Williams for allowing me to stand with him. And I really never thought we would be here, but
And
this
I
is
want to
his
thank Ms.
decision.
Love for
I
sucking
want
at
to
her
thank the Honorable
job.
Keith Adams, who may want to speak, Your Honor, but I can never imagine a better lawyer than Keith Adams.
Mr. Adams, do you want to add anything to the record?
Wow. Very rarely does first chair call out second chair and at a sentencing like this.
I don't know if I'd say it's very rarely, because I see it a lot.
But
where you've
calling
got,
out, like saying thanking, but offering them and then having that person take the opportunity to speak.
Oh yes, that is a little more unusual for sure. So
look at the smile on this dude's face down here in the corner. That's like a genuine smile.
yeah.
Your Honor, I don't know that there's really much to add. Mr. Steele has represented to the court, I think fully and thoroughly, the breadth of our knowledge of the case, Mr. Williams's background. I think the court has not just heard it from Mr. Steele, but has had the opportunity to sit here and hear some of the evidence and kind of get a feel. You've had a chance also to observe Mr. Williams and then get a feel for him, his background, and so forth. The only thing I can say about Mr. Williams that hasn't been said is that he comes from an area. You might have heard throughout the course of the trial that there was an album, a concert tour. We came from nothing. And that is true. Mr. Williams came from, I hate to use the word abject poverty, but that really is the case. Came from an area where there was a significant amount of crime, where, as you've heard, he's had tragedy in his life and has observed tragedy in his life. And he has gone through a good bit. He has been involved in a lot, but he has raised himself up. He has done the best he could and has done phenomenally well, and is, I think, an inspiration to a lot of people from that community who look to him and see the success that he has gained and have been fully supportive of him. But he finds himself here. He's in front of you. He is tendering this plea because he accepts responsibility. You've heard everything Mr. Steele has had to say. I can only ask that you follow what we have put before you. You also have, I believe, the paperwork that was given to you by the state, which kind of gives you some idea of what they were looking for as well in terms of conditions on Mr. Williams, if we were to ever reach some sort of agreement. And we ask that if you feel that there's anything within the state's proposal that might be appropriate in terms of the sentence for Mr. Williams, that the court please feel free to do that. There's nothing that he puts himself before the court. And I think 2.5 years sitting, going through this process, challenging process, but now standing before you and asking that you consider everything and sentence him appropriately in the way that we've requested. I'd simply ask you, I join Mr. Steele and Mr. Williams in asking you to do the same. And I thank you as well, as Mr. Steele did, for your patience with us and for bringing some order to the proceedings.
The knowing chuckle, bringing some order to the proceedings.
That candidly
A little bit of shade.
was needed. So that's all I have to say. I thank you again, and I ask you to consider everything that's been put before you.
All right, Mr. Williams, is there anything that you want to say?
Yes, ma'am. I take full.
And at this point in time, both defense attorneys are very, very, very fucking nervous. Like, please.
Oh yeah.
Don't say anything, please. Please just be good. Please be good.
Responsibility for, my crimes or my charges.
It is the latter. Law and lumber spelled out. Law
I want to say
and
sorry to my family, my mom. My mom got 11 kids. I can't say all their names, you know. My managers, my kids that's not here. Really everybody that got something to do with this situation, I want to say sorry for just like, you know, having so much time invested into this, you know, and I am
come on.
a smart guy. I am a good guy, and I really got a good heart, you know. I find
Yeah. Oh, come on. Now,
you know, and I am a smart guy. I am a good guy, and I really got a good heart, you know. I find myself in a lot of stuff because I was just nice or cool, you know, and I understand that you can't be that way when you reach a certain height because it could end bad, and it don't really have to have nothing to do with you, but it can end bad and it could, you know, fall on you. And I know the choice is yours, it's up to you, and I hope that you allow me to go home today and just trust in me to just do the right thing and never see you again unless it's at a, you know, bar in the future or something. Just out of this type of situation, I promise you I won't ever be in this type of situation again. I'm going away. I've learned from my mistakes. You know, I come from nothing and I've made something and I didn't take full advantage of it. I'm sorry. Through these last 2.5 years of my life, you are really, truly, honestly, the best thing that has happened to me because you made.
Judge, only you. Okay, young man, I understand. You, I get the judge is the one who kind of corrected the course of action in this trial.
A little bit. I mean,
I get what you're saying, but the bailiffs are laughing. When the bailiffs are laughing, usually it's a sign of endearment or holy shit. This one is
it's
more,
either really good or really bad.
yeah, this one is more in the terms of this dude's really fucking nervous and has no idea what he's saying. So, yeah. Everyone at this point in time, let me tell you this. At this point in time in this courtroom, the writing is on the wall. You have read this judge's demeanor and everyone kind of knows what's happening.
I mean, if I was the judge here, I'd be inclined to say I'm just not accepting the plea. I'm dismissing this with prejudice.
No,
but
the judge is recognizing a whole lot of fault that he has. The judge is going to recognize a whole lot of, I mean, he pled guilty to these things. These are not things that the judge can just dismiss. He pled it out.
Sure they can.
He pled guilty. I know they can, arguably.
And should.
Whether he is situationally oblivious, as in doesn't recognize the situation he's in, or whether he was an active co-conspirator, not conspirator, I don't mean to say it that way, an active participant in any of this behavior. There's some not good shit. Some shit that deserves some recompense. Even the minor stuff, Ian. Even the minor stuff.
Nah. Sorry. Yeet.
You're on the state. Yeah. You're the state's conduct deserves complete eating.
Yep.
I can see how you get there. Hell,
I'd be like yeet and costs from the state to be borne 50% by the government and 50% by Ms. Love personally. Ms. Love, when can we expect that check?
My gut is there. My gut is there. And here's the problem I have with that. My gut is there. But the state, ugh. Wouldn't it have been interesting to see a competent trial? Like to see a competent prosecution of this case? I would have been curious to see it
might have been, yeah. But we didn't see that. What we saw was, yeah.
So that's the, I don't know. I struggle with this. I think the disposition here is appropriate. I am much in the line of Steele. Like, I think I would have won this trial. I think Steele would have won this trial. Honestly, I think this would have come back as NG. But at what cost? Or mistrial. And at what cost? Williams is the one who is serving the time. Williams is the one who gets to make the call. He's
And
the one
the
that
thing
gets to
is
decide.
they're gonna try to fuck him over on the probation. You know they will.
15 years of it is tough, and that's what I think. That's what Steele was pushing against. 15 years probation with all of these criminal, like all the time to serve on the back end is pretty shitty.
And the thing is they will absolutely, like, the goal of probation really ought to be that you know, that people you know, clear their probation and make it through and are supervised in case they you know, supervised in case they are falling into bad paths. But yeah. And Al Fliggins's probation is run by a different entity than the prosecution. It's possible they won't persecute him. Possible.
No,
but yeah.
Not likely. All right, continuing. 15 minutes.
Made everything fair for me and everybody involved on both sides, you know. I'm sorry to the sheriff, you know, everybody for just having to put extra time in. I know y'all got paid more money, but I'm sorry for y'all having to put this extra time in to be away from y'all family, you know, and I just hope that you find it in your heart to allow me to go home and be with my family and just do better as a person. I know what I bring to the table. I know what I am. I know the heights I've reached. I know the impact I got on people, period, in the community, you know, all people. I learned that late, like these past 2 or 3 years of my life, I kind of learned that late. And maybe it was because I was, you know, probably on drugs or anything, I don't know. But I have came to my senses and I understand what I mean to this world. But I am a good guy, you know, I don't mind doing stuff like, you know, like free shows. And I always did that. You know, I did free shows and gave it to single parents, millions of dollars. You know, I made $1.8 million on a free show and I gave it all to single parent charity. And I did like 2 or 3 shows that made like $700,000 a piece. And I gave it to the breast cancer organization. Like, you know, I do things. Like, I put millions of dollars back into my community for real. I really did. I did more than anybody ever did from my side, you know, but I understand.
I like him.
You know, rap lyrics. I understand how it could be twisted. I understand what it could do to the mind of people. I understand all that. And I promise you, I'm 100% changing that. You know, it's just, I'm older, I'm grown now, you know, and it's just like, I'm smarter. It's more things to rap about. Like I've experienced a lot of good things. I experienced more bad things, but I experienced a lot of good things too. And anyway, I can go forever.
Well, I appreciate it. And I appreciate that you do realize how much of an impact you have on people. I mean, it's,
even this trial's had an impact on people.
It's past your neighborhood. It's worldwide, especially young people. And having come up from where you came up from and living in and around that, you know that gangs are damaging to our community. And it may be that a whole lot of rap music and the rap industry is, I mean, honestly, it sounds like a modern day version of kind of WWE wrestling that used to be on television, where people would just get up and posture and act like they hated each other. And it may be that that's a lot of what is going on in the music industry with rap. But whether it is fake or not, it has tremendous impact on kids and young people who think, this is cool. This is what I want to do. Look at him. He's a millionaire. I can do that by being, you know, a gangster in the streets. And that's not true. What you're likely to have happen to you if you're a gangster in the streets is you get shot, you get killed, or you get thrown in prison. And those are, by far the most likely outcomes.
Yep.
And, you've been in here watching the trial, and you've seen the pictures of Mr. Ryan posing with a gun as big as he is at 15 years old and going out and shooting and killing another teenager. And that's what gangs do. And that's unfortunately a lot of what rap music does. And if you are a modern day John Lennon, he might have rapped too in this day and age. I don't know, but I know you're talented. And even if you choose to continue to rap, you need to try to use your influence to let kids know that that is not the way to go, and that there are ways out of poverty besides hooking up with the powerful guy at the end of the street selling drugs.
Yeah,
And,
name 3.
I know that happens for protection sometimes, but
Yeah, Ian, that's the trouble. I get what you're saying. And she led right into it. She finished the sentence and went right into it. Go ahead, make your point. I want to hear it. Name 3.
I mean, this is the thing, is that poverty is a trap. And when she's like, how else? Like, I'm sorry, no.
The statement of there are other ways to get out of this situation.
Yeah,
there are
it's
other ways
really
to get out of
easy
this
for
situation.
for this
It's
kind
easy, yeah.
It's really easy for like a judge to say that, but there was a guy who did a test. And so basically what he did is he got rid of his ID. He basically said he wouldn't use any of his credentials. He wouldn't use any of his money. And he put himself on the street, and he wanted to see how long it would take him as an able-bodied, fully, like no mental health issues, whatever, to go from street to back into a life. It took him like 1.5 years of dedicated work and luck to do this. And, saying that it's
to it either. He didn't get back to it anywhere close.
No, he got to like, I have an apartment and I work at like the Walmart, and, not to sort of anything big. Whereas like this is, so judge, like you're saying that it's, oh yeah, there's all these roots out of poverty and so forth. Like, you don't know shit because you've never been on that road. So maybe like before you comment about how easy that road is, it's, yeah, this annoys
Here's
me.
the thing. I want you to see the part of the sentence that actually does apply.
Fair. Just
here's the part that does apply. You have done it. Like you've done it. Like you have made this jump. And yes, there was bad things happening along the way, but you've seen it happen, and you're here. And
I mean, the other
help guide other people.
Yeah, it's possible to make it out and to achieve success if you happen to be like one in millions talent, right?
Not
like,
what I'm saying. But that's not what
no,
I'm saying.
that's
not what I'm saying.
No, but it's what the judge kind of comes out with.
I know
and,
it is. It's a little bit of what the judge is saying, but there's I think
the other thing that I just want to sort of rant briefly about, because I know we got to do a transfer here, but
yep.
We talk about like we need diversity on the bench, and what they mean is we need like different colors of people who all go to the same country clubs and grew up playing golf at $1 million, estates and whatever else. And what I think we need is more like diversity of background, as opposed to like, and I mean, diversity generally is good, but I want to see more judges who know what it's like to have to choose between rent and eating, that kind of thing. Because when they, we get, people who are like, oh, we've got the first, they're talking about like, oh, this is one of the first black judges. And I look into their background. It's like, oh, this guy grew up as a multimillionaire. And I'm like,
before you have to switch over, can I give an example of a judge? One of my favorite judges to appear in front of right now. One of my favorite judges to appear in front of went to college and he went to college. He was one of the few from his high school who went to college, and he went to college to obtain a degree, and he obtained a degree that was in some completely irrelevant field. And he came back from college after going to college, and half of his friends, half of the people from his graduating class in high school were in jail. You know what he did? He went to law school, and he became a lawyer because he wanted to fix the system. And he ended up being a lawyer in juvenile court, advocating for kids that ended up in this side. Then he became a juvenile court judge. Now he's a circuit court judge where I am. I love this judge. I love this judge. He has been and seen and done all of it. That's what we need in the justice system.
Absolutely. I want more people who've like, I mean, hell, I want judges who've seen the inside of a jail cell and weren't there on a tour. You know, I don't want somebody who's like actively a criminal now, but like somebody who was a criminal 20 years ago and then went to law school. I'm like, fuck yeah, I want that person. You know, somebody who like, get me a judge who's been on the street. Get me a judge who grew up in the res. Get me a judge who, you know, I mean, hell, I'm not from like an impoverished background, but you know, when I was a kid, we got our house broken into and the Nintendo got stolen, and there was no replacement Nintendo because there just wasn't money for it, right? Whereas in law school, when I'm sitting there talking to people, they were asking me, where are you going for the summer? And they were like headed off to places like Barbados or the Alps. And I'm like, here, dude, I got no money to go flying off to like international travel. And they're like, oh, you know, I'm going to my family's villa in the, you know, in the Alps. And I'm like, that's gotta be like cool. But also we don't need this in judges, right? And that's who's becoming judges. That's who's becoming, you know, they've got a leg up the whole way along too, because, you know, they're competing with people who, so you got people who have to work their way through law school. Their grades suffer because they're competing with people who don't. And who's got the better chance of being appointed to the, you know, the bench, because it's appointments here. Well, the person whose grades are because they, you know, we got to fix all of this. And I don't know how. I am going to bail though, so that you can fix, so that you can get through this. I'm going to start up my stream. Nobody needs to feel an obligation here, but I'm going to go start the stream and you guys watch this and then come watch this.
Poll results, 3,000 votes, 68 degrees to 70 degrees wins. Go. Bye-bye.
See ya.
All right. So the poll results were, the winner was 68 degrees to 70 degrees, 46% of the vote, with 3,000 votes counted. Yes. Yes. Rob wins. Yes. However, I think like if I ideally could have done it, it would be below the 68 degrees. But 28% said 71 to 74 degrees, and then 6% of you said above 74. You courageous few. Okay, I'm going to finish this up, and then I will kick you guys over to Ian. Oh, I will try to finish it up. Come on.
Getting an education is out of poverty besides hooking up with the powerful guy at the end of the street selling drugs. And, you know, I know that happens for protection sometimes, but a much better way would be getting an education and setting, you know, hanging around with people who set a good example. And you be one of those people that sets a good example. I mean, all right, so that's my high horse on that. I could also go on. But I want you to try to be more of the solution and less of the problem. All right. All right. So it is not lost on the court that the state had they been able to come to agreement on certain special conditions, was willing to entirely dismiss the RICO count, was willing to entirely dismiss one of the gang counts, and was willing to entirely dismiss this, machine gun count. Was willing to give a sentence that permitted Mr. Williams to walk out of the door today, and therefore does not seem to be particularly worried that Mr. Williams, if on the streets, would be a danger to society. I'm taking that into consideration in crafting my sentence. And in permitting a nolo plea to the RICO count in one of the two gang counts, I would not be permitting the nolo to the one if you were not pleading guilty to at least one of them. But you are, and y'all admit a factual basis for the counts that you are pleading guilty to. I find there to be a factual basis for those counts and for the remaining counts with which you are charged. I am going to impose a sentence, and I've taken a little bit of the suggested special conditions from the defense and a little bit of the special conditions suggested by the prosecution. On count one, the court sentence is 20 years to serve 5 years, commuted to time served, the balance of 15 years to be probated, and a $25,000 fine. On count two, the sentence is 5 years to serve, commuted to time served. That's the minimum sentence that's permitted on that count. It is required to be run consecutively. I'm going to run it consecutive to count one, but I am going to backload.
Backload means gonna put it off the end. Come on, internet. Jeez, man. Now, at the end, we're gonna do this. We're gonna have this debate. Mr. Router, we have a disagreement, and I am disagreeing with your opposition to my carrying forward with understanding what the fucking sentence was. Stop doing this.
Serve, and it's going to be run consecutively to count one. Backloaded, by which I mean after you serve your 15 years of probation, if you have been successful on.
Oh, no. We're not doing this. If you success, we want success.
That probation, and I sincerely hope that you are, then at
I hate so many things right now.
the end of that 15 years, I will commute the entire rest of any service portion of your sentence to time served. So I'll get to the end of it and give you the total sentence, but I'm also going to impose a $15,000 fine with regard to that count. Count 57, 20 years to serve 5, commuted to time served, the balance of 15 years probated, concurrent with count 1. Count 58, 10 years to serve 5, commuted to time served, balance probated, concurrent with count 1. 59, 5 years to serve, commuted to time served, concurrent with count 1. 60, 5 years to serve, commuted to time served, concurrent with count 1. Count 61, 5 years to serve, that is required to be also a consecutive sentence, so that's going to be run consecutively to count 56 and backloaded. Count 62, 10 years to serve, also required to be served consecutively, that's going to be consecutive to count 61, also backloaded. So essentially, the total sentence is 40 years to serve the first 5 years in prison, but commuted to the time that you have already served, followed by 15 years on probation, followed then by the backloaded 20 years, which can be served in custody and will be served in custody if you are not successful on your probation. If you are successful in completing your 15 years probation, that will be commuted to time served. You are to remain on reporting status for the first half of your probation, active reporting for the first 7.5 years of your probation, and that is pursuant to OCGA 17-10-1, subsection 2, A2A. And Mr. Steele and Mr. Adams, in order to keep him on reporting status, there needs to be good cause shown. We all concede that good cause is shown here?
Stipulate.
All right, I appreciate that. Special conditions of your probation.
What good cause? What do you mean?
Can I have a second, Your Honor?
Sure.
Thank the judge. Thank you, Your Honor.
All right. You had enough time to talk with your attorneys?
Yes.
Okay. All right, special conditions of your probation. After 48 hours from your release, you are to stay away from the metro Atlanta area and that's defined by the U.S. Census Bureau. It may change, but you can look that up anytime to figure out what that is. For the first 10 years of your probation, subject to the following exceptions, you are permitted to be in the metro Atlanta area to attend any wedding, funeral, or graduation from high school, college, or graduate school of any of your immediate family members. And immediate family members is defined the same way that you all were contemplating it when you were negotiating. You can get here up to 24 hours prior to any such event, and you need to leave within 48 hours after any such event. In addition, during each year of your probation, I'm going to require that you come to the metro Atlanta area and make a live anti-gang and anti-gun violence presentation 4 times a year, each year of your probation, at a grade school, a middle school, a boys or girls club, anything like that, that type of group. And if you want to, that presentation can include a benefit concert, and these presentations may count towards your required community service hours, which I'm going to impose, that during each year of your probation, you perform 100 hours of community service. You are, and this is required by the fact that there's a gang conviction.
Holy shit. I didn't guess that. During each year? 100 hours? Okay. Y'all do the math. 100 hours is a bunch of time. So, okay.
Conviction. You shall not knowingly have contact of any kind or character with any other member or associate of any criminal street gang. Exception to that, if your brother is a member of any street gang, I hope you talk him into getting out of it. Contavious Greer, and then also Sergio Kitchens, as long as you are contractually obligated to him. That is going to include anybody who is named in this indictment, except as absolutely necessary to conduct the lawful business of your musical career, and to any extent that the state is not agreeing to the exception for Mr. Kitchens. In the event that that part is not enforceable because it is only a portion of a special.
So Zents, I get the point. I hope you're wrong. I get the point. I hope you're wrong. Let's say with defendants, sometimes split. You don't know. Sometimes they care. Sometimes they don't. Sometimes it fixes them. Sometimes it doesn't. You don't know.
Condition going to provide that that be severable from the rest of this, and I'll put some case sites in the Senate sheet for that. You are in no way to promote any criminal street gang or any criminal street gang activity, including on any social media platform. You are not to utilize any hand signs, terminology, or language that promotes any criminal street gang. You are not to participate in any criminal street gang activity. You are not to knowingly engage in any contact with any of the victims that are listed in this indictment or with any of their family members. And you may not have in your possession or with arm's reach any kind of a firearm because you're going to be a convicted felon. And that is, except I know that you have security and you need security. You can be within arm's reach of a firearm that is in the possession of either licensed law enforcement or licensed security personnel that are in your security detail or anybody that you're performing with. You are to submit to random drug screens and not use any drugs unless they are prescribed for you by a licensed physician. You are to execute a Fourth Amendment waiver that will permit the search of your person, residence, vehicles, and electronics for any firearms, any criminal street gang paraphernalia, or any illicit drugs. And as I mentioned, with regard to one of the first of your co-defendants from this trial, at least since I've been involved, to plead guilty. Our Uniform Superior Court rules instruct and provide that it is absolutely proper for a judge to grant leniency in sentencing when, quote, the interest of the public in the effective administration of criminal justice are served, unquote.
Oh, this is a slap in the face to love. So here's the thing. Have your opinions about Young Thug as you will. I am all but ready for the slap across the face to Adrian Love for how this case has been prosecuted, and Fonnie Willis.
And I think that this plea is in the interest of the public and in the interest of effective administration of justice. Have been trying to ensure that to the extent I can, this trial also abides by that. It's been challenging at certain times. I find your plea to be freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences, and I accept it as such. I also need to inform you that your attorneys are going to represent you through either the last day of this term of court or 30 days from now, whichever is later, and any of the filings that were mentioned that need to be filed within that time, they would file on your behalf unless they are permitted to withdraw from representing you before that time. I am not going to impose the conditions suggested by your counsel about the benefit concerts and the donations to the sheriff's office, but I certainly strongly encourage you to do those things and to do and continue to do things that benefit your community and especially help young people to stay out of criminal trouble. And unless there is anything from counsel other than that.
I have one matter, Your Honor.
Okay, and does the state as well?
Your Honor, with regards to Mr. Williams being permitted to come to the Metro Atlanta area or Cleveland Avenue area for funeral or the other items,
Right.
can you also consider, God forbid, there's a serious medical condition of a person that
In
is,
his immediate family,
yeah.
certainly, we can add that. And I also meant to mention, because I know you do travel all over in order to pursue your career, that it's permissible for your probation to be transferred to out of state, and that has to be done through probation, but that is fine with the court. And you may also keep your, nobody's mentioned it, but keep your passport and travel out of state and internationally to the extent that you need to do that for business purposes as well. All right, Mr. Body.
Yes, very briefly. Thank you. The district attorney just wanted me to urge the court, due to the fact that the Thomases have been negatively affected incredibly traumatically by what has been discussed by both parties here today, to make a brief statement as she believes they fall.
Wow. Adrian Love, the fuck you sitting for? You coward. You coward. Oh, you coward. You absolute yellow-bellied fucking coward. You knew this would be declined. So you're making the guy at the end make the argument. Why aren't you making the argument? You made the argument on sentencing. You made the argument on sentencing. Get the fuck up and make the argument. If you know you're going to get shot down, stand up and do it. Are you fucking kidding me? This is bullshit. This is... Has he spoken through any of this? No. At all. Not a single peep. It was Adrian Love that got up and made the argument as far as what the sentence should be. It was Adrian Love who made the recitation. It was Adrian Love who handled every single thing about this. All of it. Making the initial request. Oh no, I understand that. I get it. But you don't pass that shit down the table. You make the argument, you lose the argument, you want to remake it, you get your ass up and you make it yourself. I don't care if he's also a district. I don't care. I don't care. You make the argument, you lose the argument, you want to remake it, you want to reiterate something to the court. That's your case. That's your baby. That is your argument. You get your ass up and you make the fucking argument. That is bullshit. No way. If I lost an argument to a judge on a request, I don't care if he's first chair. Adrian Love was the one that gave all of it. If I lost my first argument and I had the chance to come back and make the second time and the second go round, who's getting their ass out of that chair? Me. I don't care. I don't like this. I don't like this.
All right, to the extent that you need to do that for business purposes as well. All right, Mr. Body.
Yes, very briefly. Thank you. The district attorney just wanted me to urge the court, due to the fact that the Thomases have been negatively affected incredibly traumatically by what's been discussed by both parties here today.
And even then, the district attorney just wanted me to readdress and reaffirm to the court. It's not even that he has the heart to do it. It's Fonnie Willis. It's the DA just wanted me to readdress and reassert this to the court.
To make a brief statement as she believes they fall within the exception or within the bounds of Marxist law. If the court would allow, I understand the court made a ruling earlier as it relates to that, but she wants to.
it's over now. All right, thank you. And I appreciate, well, I cannot even begin to understand what they must, anybody must be going through when they lose a family member to violence or criminal violence. Mr. Williams himself has expressed his own sorrow to the family. I, again, am going to stand by my belief that the appropriate time to hear a victim impact statement from them is at the close of the trial that contains the murder count with regard to their family member. All right, thank you. Okay, court is adjourned. Good luck to you. And I'm going to have there better be no violations, but if there are any, you're coming back to see me.
Yeah.
All right.
Thank you, Your Honor.
There you go.
That was, I'm angry. All right. Close one, open the other. Screen interview. That pissed me off.
Collective
I don't know
opinion,
why. But
Jeffrey
just
would have been found not guilty of everything. So this is very painful. But that's another 3 months or so in custody. And he wants to go home to his family. And negotiations totally broke down with the district attorney's office. Horribly broke down. At that point,
the tea. Give me the tea.
we believe that justice will be found with the honorable court. And Jeffrey just wanted to go home. How agonizing it is to know that we've spent a year trying a case where the prosecutors have put on lies, knowing lies, hiding evidence, is insane in 2024 in the United States of America. And the only reason that this got revealed is because of you people. You people brought the truth to the community because nobody knows this. This is not the only courtroom it's happening in. And I just want to thank all of you. I especially want to thank Jeffrey for letting me represent him.
Mr. Steele, I already loved you, sir. You don't have to double down on that. You have my devotion. But to repeat that this happens in every courtroom, sir, please continue. Serenade me.
Him. I think he's a wonderful person who does wonderful things and will continue to do things even greater. I cannot express to you how Shaquille Kokomo, how Trisha Renard, how Haley, how my wife Colette, how Bram, how countless people, but especially Miss Courtney Edwards, has worked without sleep for 3 years representing Jeffrey and helping him. I will never be able to stand with anyone more ethical, honest, hardworking, insightful, intelligent.
Mr. Adams, I now know your tell. I have your tell. That's your tick. That's your comfort.
And kind than the Honorable Keith Adams. The gentleman to my left
How
is
you
the best
express
lawyer
frustration.
in the country.
Do you think prosecutors negotiated in good faith at all during any of these negotiations? Let me take this one. Let me answer that. The short answer.
No. Yes. Oh, baby. Yeah. Okay. So what was I doing here? So every lawyer, every person has a tick, something where they express frustration. So lawyers do this all the time. Let me in Bacon for a second. I know Ian's going in Bacon. So lawyers, we are tasked with essentially remaining very stoic in court. Well, there's energy that the body exhibits. So lawyers, good ones, good trial lawyers, learn the ability to channel that energy to a certain thing, something that is, they believe, not noticeable. So some lawyers will stupidly learn the click pen. So I had a trial against a lawyer last week who loved the da. It was 1, 2, 3. It was always 1, 2, 3. It's always fucking 1, 2, 3. Drove me fucking nuts. But 1, 2, 3, 1, 2, 3. And he would hold the pen behind his back. Boom, 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 boom. But that was where the energy went because the rest of his body remained stoic. So the body has to release energy in some fashion. So this lawyer that I litigated against, the energy release was the right? So every lawyer has one because if you have that level of apprehension, you can't just plain bottle it. It's not possible. You have to put it into something. What What's mine? Mine usually is a pen, like the twiddling the pen. I don't, but that's why I stopped carrying click pens. Because of that, I would do that. But Mr. Adams, watch where he puts his energy. Where does he put his energy? Rewind for a second. And watch how fast he jumped.
Intelligent.
Ready?
How Trisha Renaud,
Focus on the finger.
how Haley, how my wife Colette, how Bram, how countless people, but especially Miss Courtney Edwards, has worked without sleep for 3 years representing Jeffrey and helping him. I will never be able to stand with anyone more ethical, honest, hardworking, insightful, intelligent, and kind than the Honorable Keith Adams. The gentleman to my left is the best lawyer in the country.
Do you think prosecutors negotiated in good faith at all during any of these negotiations? Let me take this one. Let me answer that.
Why don't you let me take this one? Let me answer that. God, I love that.
The short answer is no. This is a case that possibly could have been resolved if folks were reasonable. But we did not believe that we could enter into good faith negotiations with people who wanted a case resolved in a manner simply to save face. And Jeffrey Williams was not going to say things that they wrote for him, that they wanted him to say, that was their theory when it wasn't true. And so good faith, no. I don't believe we were ever really negotiating in good faith. And you've been here the past year that this case has been on trial. You've seen the numerous motions for mistrial. You've seen the behavior of the state. You've seen the dishonesty. You've seen everything being hidden. You've seen things come out in court in front of you. And so you know what kind of prosecution we were dealing with. And that's okay. You know, Mrs. Steele and I have fought through this the past 2.5 years. And as he said, we ultimately decided we were going to put our faith in the court as opposed to the folks on the other side of the aisle. And, you know, the best thing out of all of this is that Jeffrey Williams, in a very short period of time, will be home. And that's all we've wanted from May 9th, when they went and picked him up and have held him in jail without a bond for the past 2.5 years. He'll be home shortly.
Keep it right. This either one of you can answer that. 2 questions. First off, you go into a blind plea, you don't know, right? There's nothing for sure. What was your emotions like when you guys?
Here's the thing, guys. I see disagreement in the chat, but the chat's allowed to disagree. There's nothing I have seen that has been disrespectful towards any other member of the chat, or inherently disrespectful or rude, offensive, or disparaging of anyone on the screen. There's been a lot of comments, a lot of honest opinion given, and I give a whole lot of latitude to people to do that. So I appreciate all of the input. Whether we're nice, not nice, what we want to do or say, that's fine. You're allowed to do it. There's certain rules you just can't talk. You can't talk about people's appearances, people's intelligence, stuff like that. But as far as criticism of their opinion, their take, what their likely outcome is going to be, the disposition of the case, whether it was right, whether it's wrong, you can do all you want to do. Offensive, doesn't matter. You can be offensive. Just be respectful of one another in the chat and don't dip into personal. That's it. Only rules.
Went into that, I would imagine the conversation, you kind of take us into the room before you went out into court with the conversation going back and forth. Obviously, I know it's attorney-client privilege, but it's a big decision.
Well, I didn't want to give up the jury trial, but that was a decision made. And once that decision was made, we were just thankful that there are people like the Honorable Judge Whitaker who understands what a trial is like and what it should be like. And I cannot thank the Honorable Court for being here and coming in. She's not our first judge, but she's the first time we received justice.
Mr. Adams, this is your second high-profile RICO case here in Fulton County. Do you think that maybe the prosecutor's office is abusing that statute? And what are your opinions of RICO generally?
I have, for the 30-some-odd years that I practice law, always believed that if you, as a prosecutor, think that someone has committed a crime, you charge them with the crime, you put it in front of a jury, and then you do it fairly and let the chips fall where they may. The courtroom is not the place to get adventurous, to get inventive, to think, well, we don't have evidence on him for any of these incidents, but maybe, if just maybe, we tie him up in a RICO and put him with people who may have committed crime, we can get him that way. That's an abuse. And so, yes, for some strange reason, the Fulton County DA's office seems to be in love with RICO, and my honest opinion is that they're in love with it because it makes it easier for them to try and convict people that they otherwise could not convict. And that's what was happening here. We're fighting a mountain, reams of evidence, most of which didn't have anything to do with us. And so is it an abuse? I think it is. There are better ways to, and I used to be a prosecutor. Right? And I can tell you that there are better ways to prosecute cases than the way this case was prosecuted.
You guys obviously rejected initially what the state was going to offer. There's some details you can give us, because it sounds like from what you guys decided in court, I mean, it's still pretty stringent. There's a lot of different details, but what was the state asking for that you guys rejected?
I'm not going to get into plea negotiations because they are privileged under statute, but it was outrageous. They would let him out of custody, but they would have a tether around him so tight that it's unconscionable.
And how are y'all feeling about what the sentencing is, especially with not being able to be in Metro Atlanta except for specific parameters, and how is Mr. Williams feeling about that decision?
You know, we're okay with the sentence. There comes a time in any case, if a person is sentenced, that we're out of the courtroom, and now what happens to that person is entirely up to them. Jeffrey Williams is a fantastically talented man. He is a great person. He's become a great friend over the course of the last couple of years. And he has the ability, the incentive to go forth and do everything he needs to do to put this behind him. And we're confident that he will. One of the questions you asked a little earlier was, what was that feeling like, stepping into a courtroom to do what's called a blind plea, not knowing what's going to happen? You know, it's a scary feeling for all involved. There's probably no feeling quite like that other than sitting in a courtroom, waiting for a jury to come out and tell you what your fate is. But we walked in there knowing that we were in front of a fair tribunal and being comfortable that the right thing was going to happen, and the right thing did.
What do you think about your client just serving as a role model? Obviously, as part of the agreement, using to participate in the community, doing events, things like that. Obviously, he has a huge reach for what he does for a living.
I've known Jeffrey Williams. I've defended him for over a decade. I have been with him where we go to young children, children in need, children who are going down the wrong way. And he tells exactly what he's going to continue to say. He tells everybody, this is not a good life. We have to stop the generational disaster that is plaguing the community. And although right now I'm successful, I'm a product, but every one of you can get out. And he always stresses education. Jeffrey Williams is a great person, a great role model, and he will do even better now, hopefully, if you allow him and his words to get out. As far as how Jeffrey's feeling now, he knows my feelings, which I'm not going to reveal for attorney-client privilege, but this is not the same as a not guilty verdict. That should have been rang. But nobody here wakes up every day on a concrete floor that they're calling his bed, gets up at 4:15, gets shackled on his feet, his waist, and his hands, comes to the Fulton County Courthouse to be on concrete, eating out of a bag. Doritos is his meal of choice. And then coming to a courtroom and sit there with a leg chain on him every single day and hear lie after lie. So for Jeffrey, go home today and not have another 90 days or 120 days of it, he is very happy, thankful to the Honorable Court. So to answer your question, this was not what I wanted. I don't believe that it is just, but I believe that under these circumstances, it is justice for Jeffrey Williams, and he is delighted, as are we. I'm thankful.
Can I ask you?
All right.
And right next to it, he was addressing the judge. What seemed like a very sincere apology to her, apology for what happened. That's gone on. How did you feel sitting next to him, knowing him for the last decade as an attorney for him? What he was saying in television?
Jeffrey Williams is being truthful. That is his heartfelt feelings. He feels so bad for the loss of life, and he feels bad that people are taking his music or his social postings and making it into violence. That is all promotion. That is not a symbol of go hurt somebody. So I hope I've answered your question directly, but how I felt, I've heard that from Jeffrey over and over again.
You called out a lot of challenges in this trial based on the prosecution's point. Do you have any message to, the co-counsel that for now is still on trial, or what's left of us?
Oh my God, they are phenomenal lawyers, and I'm confident if you keep going, which I assume you will see some great lawyering. They don't need my help.
Yeah, you will.
And the truth is, they've been there with us for the past 2.5 years.
This is the point that I want to make. And this is kind of the last point I wanted to make. So close this out. So the last point I wanted to make was this trial is still ongoing. All of the things that you saw, yes, young Thug himself pled out. Yes, but there are still several defendants on trial. And the prosecutors bringing this trial are still Adrian Love and company. Public eyes aren't just reserved for Mr. Williams. Public eyes on court are reserved, or not just reserved, public eyes on court need to occur in every case. Because I have no doubt this prosecution is going to continue to go down the same road it has gone and trample over or attempt to trample over certain rights that exist. So I think it's important that people still watch this trial. And the sad part about it is I think that the the coverage is going to drop off a lot. So it probably will be covered by local news, but I don't know if Law and Crime will continue to cover it. But it should, because you still have so many defendants that are still on trial in this massive RICO case. And the same bullshit's going to happen. So can we keep covering this trial, please? I'd like to. I think it's important. I'd like to see the same eyes on it. Be important. Because the same bullshit can't happen. It's a lot of what Ian was saying earlier. Yes, Young Thug gets these conditions on release that a lot of people don't get. But the people that don't get them are still on trial. So why don't we keep eyes on that? So let's see. I like to keep covering. On the Delphi issue, I know that Andrea Burkhart has been covering that extensively. And by extensively, I mean she is on the ground. Andrea doesn't cover something. Andrea, like, covers something where she knows every fact, every lawyer, every argument, every pleading. Never seen someone cover something so comprehensively. I would hate to try a case against her. Holy shit. I'd be terrified about the thing I wrote 5 years ago coming out to light. Like, she is methodical. Anyways, let's wrap up and get to Ian's stream. Ms. Squirrel, Runkle is awesome. Congratulations to him. Congratulations indeed. Time Lords, Team Mischief. It's 73 inside and I'm in a hoodie. Oh, time. We were such friends. We were such friends. For a time. Judy, you got this. I'll be retired. My last milestone. Thank you for it all. Judy, you got this. You will always be a part of this family and channel. Ohio Palm Mom. Are these DAs or judge facing ramifications? No. Morgan, woohoo, I finally got my 2-year purple star. Yeah, Morgan, awesome. 2 years. Thank you for being here for that time. Light Queen, have to get to sleep, but so happy to have spent over a year with the two of you. We'll be watching Ian after work tomorrow. Have a great night all. Thank you, Light Queen. Congrats on a year. DSN, that is fantastic. Thank you very much. DSN gifted a membership. Much appreciated. Auburn Warfare. Thanks, Robin. The mods. Heart. See you soon, Ian. And I start a question. Olivia Nile. Rob, question. Does law school prepare you to remain stoic in court? If so, how? It does not. It does not. What prepares you is seeing arguments over and over and over again and seeing how lawyers treat cases and trials. You have to watch court to understand court. So, honestly, y'all are getting good education here right now. Good point. So, Laura, I have a new associate right now. To all of you, I have a new associate right now. A young associate who just passed the bar. And I recounted to this associate a story that I had once told. I think I've told you guys this once before too, but I'll recount it again. I was in a moot court competition with two seated judges as panel members and one practicing lawyer as a panel member. And I finished the competition and the two judges gave me great praise for what I had done. The arguments I had made, they said, you did great. And we get to the practicing lawyer, the trial dog. And he says, I couldn't actually hear a word that you were saying because I couldn't stop but focusing, or I couldn't help but focusing on the half-inch gap, quarter-inch gap between the top of your collar and the tie beneath it. And he said, does that seem ridiculous? Yes, it does. But it came down to this statement of, you are an advocate for your client, which means the last thing you want is for a judge to be focused on what you're wearing rather than what you're saying. And that always hit home, and it stuck home, and it's always rung true. So you don't learn how to be stoic, but you pick up things here and there. And it's funny the things you pick up. Like that. That was 14 years ago, 15 years ago. But it's still here. So, like I said, you pick them up, you carry them with you. So cheers to all of you. I hope you had a wonderful, wonderful experience. We are 6 hours in, 5 hours and 55 minutes. I promised I was going to be a short stream, but then Ian got on and I was like, I can make it to get you a redirect. Overcommitted. I do it all the time. I hope you guys have a wonderful weekend. I will see you tomorrow morning, 10 a.m. Eastern time, my time. So in roughly 8 hours, I'll see you in 8 hours. Cheers to all of you. Have a lovely evening. And then please, I will redirect you to Ian. Please continue to contribute. We are up to $16,327. Let me share that. Boom. Look at that. Wonderful. 16,327. By the time I wake up, I hope that's over 25,000. That'd be great. So cheers to all of you. Thank you. Go make something. Go make lives happy. And, this weekend, go make a contribution to a children's hospital. Good night, all. Cheers. A wonderful weekend. I will see you next time. And make something, you'll feel better.